No mention. Yes. Calcutta list.
Regular bench, not
All on the list.
Lord.
These matters, because the composition has changed, we'll send to the regular bench on next Wednesday. All these matters will be there, but before the regular bench presided over by me.
Lord, only in our case, only a reply is left by Mr. Mitra.
Whatever is left, I will take it on the record.
And Mr. Majumdar.
In view of change of the composition of the regular bench presided over by one of us within bracket Bhattacharya J bracket closed, comma, to which the matter was assigned, comma, the part is cancelled and let the matter be placed before the regular bench presided over by Bhattacharya J
Yes.
on November 19, 2025.
Mala.
Same order in all the, formally call kurun.
1 and 2 is we are happy.
Your Lordship, in item numbers 3 and,
Same order.
3 and 4 was
Yes.
fixed from the 19th of November at 10:30.
So in any event that will retain its position.
That will be
So my lord, it will retain its position at 10:30.
10:30 I mean yes. যদি 10:30 হয়ে থাকে তাহলে 10:30 রাখুন।
In our case,
and only
My lord, can I?
That was the order, man.
এই প্রদ্যুৎ বাবু এটা 10:30 তেই রাখবেন পরের দিন। প্রদ্যুৎ বাবুকে বলছি।
and only
ও আচ্ছা এটা
My lord, there's a request in item 3 and 4. If it can be placed on 3rd December instead of 19th
No.
December.
whatever was there. Let it appear.
I'm great.
5 column.
And only the
All only is on next
the
one.
appellant and the respondent had made their submissions. Only the reply by the
Consider that
appellant
why
was.
you're wasting time. Yes.
I'm great.
So item number 5, I am for the respondent.
5 same. Okay. তো প্রথম বাবু এলে yes, original side mentioning.
My lord, may I be allowed to mention?
Original side mentioning?
Original side
Yes,
mention.
yes, absolutely.
My lord, this is an assigned matter of an intra-court appeal. Grateful.
Appeal.
Grateful, lord.
কাকে অ্যাসাইন করি এখানে লেখা নেই ফাইল টেলে চেক করে নিতে হবে আমার বেঞ্চ চেক করেছে কিনা হ্যাঁ তো ঠিক আছে দিয়ে দিই পরের দিন হ্যাঁ যা আসবে লিস্টে দিয়ে দেবে কল করো হ্যাঁ সবই তো 1 and 2 yes Mr. Bose.
Same problem as last time. I'm here alone. But my lord will not be troubled. I tell you,
I'm on the virtual board with Mr. Bose, my lord.
Yes Mr. Sharma, yes.
my lord, there was a 397-398 application moved by Hungerford Investment against Turner Morrison.
Yes.
It may come back to your lordship's memory and mind that matters between these two parties were very common in those days.
Yes.
397 was dismissed. Appeal preferred, appeal dismissed. Review made, review dismissed. So, my lord, the order passed on the 397-398 application assumed finality. Then what happened was, my lord, to rake up, my lord, the past sins, if they may be called any, Hungerford, my lord, took out an application under 340. But to that we say that we have to be heard. And my lord, Justice Aniruddha Bose, as his lordship then was pleased to pass an order. I will not pass any order on the 340 without hearing you. So, my lord, we preferred an appeal against that order. Strictly speaking, it is not required, I say, as a counsel, because my opportunity of representing to the court below has always been kept open. The only clarification which I was asking for is there is an order passed by the learned single judge which says that any matter by which the 397, 398 original application is raked up for other reasons will not be heard till a particular application taken out by me, which is GA number so and so, I have the number with me, or my junior has the number, is taken up for hearing. So that is the only clarification I'm asking for. I'm not asking your lordship to go into the appeal. Kindly pass an observation, if it comments to my lord, that the matter will be heard by the trial court after GS number so and so, my lord, is disposed of. But again, I'm in that precarious condition again.
Who is appearing for the other side?
Well, at the other side, they have stopped appearing for a long time. Mr. Hoon is long dead. My lord, efforts.
Oh, that Mr.
Yes. And thereafter, there was.
No, if that order is already there, Mr. Bose, why do you require another order from from us?
Since the appeal, it struck me, I have conveyed it to my juniors. They insisted I make this application because I have certain responsibilities as a counsel. But then kindly keep it for next Wednesday. I'll take instructions and
I mean, Mr.
leave
Bose,
to
this
withdraw.
appeal, you want this appeal to be disposed of with that observation?
Just that
Have
observation.
you got a copy of that order, previous order? We can pass it right now. If you have a copy. You will just clarify that since that order is already there, nothing further will be passed.
Because I don't think I will be able to find it in a hurry, my lord.
Very well, Mr. Bose will keep it next Wednesday.
Next
Come back and we'll keep it as to be mentioned then.
Very well.
This is short matter.
Absolutely.
Learned senior
Left
counsel.
to myself, I would have said, kindly grant me leave to withdraw this appeal. But I'm not left.
Yes, exactly. I mean, anyway, so learned senior counsel appearing for the appellant submits that the appeal can be disposed of on a short point. First of the appellant primarily seeks a clarification as to all other connected matters arising out of a previous disposed of application under section 379
397.
of the Companies Act 1956 should be heard after GA2.
I'm
You're
unable
not
to
sure.
give the number.
After a particular application in terms of the order already passed previously by the learned single judge. Which of next para, in view of the short ambit of the matter, comma, let the same be listed on November 19, 2025 under the heading to be mentioned.
I'm very grateful.
Thank you. Just try to bring the copy of that order. That would suffice.
I know it is somewhere here also.
No, we understand.
Juniors too.
We understand, fully understand.
That's why item number 1 and 2 both.
1 and 2 both very well. In both matters. Matters. Yes.
3 Melodies, my appeal from an order impugned dated March 9, 2017.
Right there.
There may be a question of maintainability. I hope my
Question of, sorry?
maintainability.
Maintainability.
Because, my lord, this impugned order has already been affirmed.
Let us have the file. We don't feel confident unless you have something. You know. File 2 number, 3 number. Huh? সকালে এসে চেক করনি কেন আমাকে বলনি কেন লিস্টে অ্যাপিয়ার করছে ম্যাটার নেই এরকম এম্বারেসমেন্ট যেন না হয় সব ফাইলই তাই কেন এটা কি কোনো স্পেশাল ফাইল নাকি ওর ওই যে আগে ছিল তার কাছে স্পেশাল তাকে ডেকে পাঠিয়ে আমার চেম্বারে যে ডেকে পাঠিয়ে তুমি এসো সঙ্গে We are very sorry. The file cannot be traced out because somebody else was there in his place yesterday.
I think we'll
take it up on 19th.
We'll come back.
We'll come back.
Come back. Yes.
Great.
It's an embarrassment for us actually. জীবনে যেন আর না হয় তুমি সকালে এসে যদি না পাও আমাকে ফোনে বলে দেবে I am very clear on these things. Detail.
Next one. Great.
তুমি আজকে বিকেলে ওকে নিয়ে বিকেলে হবে না This is item number 4. You're appearing. None appears for the parties at the time of call. Let the matter stand adjourned till November 19, 2025.
Lordship, I'm appearing for the respondent.
As for the appellant, my lord, your lordship need not have to go into the merits of the appeal because this was a part of a.
Whether this file is also not there. No.
My lord,
Yes,
your
yes.
lordship will look at the order of 16th April 2024 of the division bench, deed and division bench. There was a deed of family settlement which was to be registered. That was the issue only. So the honorable division bench said, my lord, initially there was some dispute between the parties as to the stamp duty which is leviable. Ultimately, we could not resolve it. That is why, my lord, by a subsequent order, Mr. D.N. Mitra was appointed to hear out the grievances of the parties with regard to leviable of stamp duty, and then he was in charge for the purpose of execution and registration.
As a special officer.
As a special officer.
So the appeal arises out of what?
Arises out of terms of settlement. Whether the terms of settlement was executed, the award was executed in terms of the terms of settlement or not. Ultimately, both the parties felt before the division bench that if the terms of settlement is registered, then the matter is resolved. This is the
If the
now,
terms
my
of
lord,
settlement are registered, then it is.
yes. Now
They must only
we are ad item now. Finally, my lord, with Mr. Mitro's intervention, after exchange
What
of,
remains then to be done? By?
then just the order, my lord, that the special officer now shall complete the process of execution and registration of the terms of settlement on the basis of the last draft which has been circulated to the parties. And your lordship will record that the terms of settlement in its entirety is registered. Last deed, I think we have agreed. Last draft which has come. Can
I'm totally stunned, Millard. Till now, we've been fighting all the time, but we don't get the instructions. And Mr. Sen, if he knows, it's good.
Very well then.
We were on the dissenting point so long.
Come back on Wednesday. Don't take the risk.
Millard, kindly take it up one more day, Millard. I'll take it.
Yes,
We are agreeable.
On next Wednesday, we take up
we have become agreeable now. I say that so long, Millard, we were on the dissenting side.
Oh, acha, the other way around. Learned counsel for the appellant submits that the matter now hinges merely the matter now hinges 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 only on directions being passed by this court for registration of the terms of settlement agreed to between the parties through the special officer already appointed
by the order dated 1st May 2024.
By the order dated May 1, 2024. 2024. For the next para, in order to enable learned senior counsel appearing for the respondents to take instructions on such submission, comma, let the matter stand adjourned till November 19, 2025. Should we keep it as to be mentioned then? If there is difficulty, then we'll put it under.
I only request if you're if it is next week, it's only one day.
Under the heading to be mentioned. We are putting as to be mentioned. If you see there is some difficulty still, then we'll put it on.
Not be, because I think so long, as I said, I was on the dissenting side.
No, they may choose to.
As it now, my lord proceeds, we'll agree.
Well, thank you. দুটো to be mentioned হলো তাহলে পরে সব
6, my lord, I am appearing for the
respondent.
But this is I am sorry to oppose a section 5 because it is of at more than 1,000 days. And my lord, according to us, my lord, there is actually no ground which is pleaded.
Mr. Shen, was there any direction for affidavit?
Yes. All filed, my lord.
না ফাইলটা তো চাইতো তো ফাইল দিতে পারছে না একটা ফাইল দিলি
37 appeal, my lord.
We'll record the order that they're not appearing. If they don't appear on the next day, we'll just dismiss for default.
I'm sorry, delay of 445 days.
Not much.
But my lord,
depends on instruction, perception of your client.
My instruction is, my lord, to rely upon one Supreme Court judgment where Supreme Court in the appeal in a commercial matter has laid down some stringent grounds.
All right.
I will just
Recent judgments.
2021, not very recent.
2021.
Yes, not very recent.
We'll give them a last chance because it's the third occasion when they're either not appearing or.
I think they wanted to file a supplementary affidavit. They have filed a supplementary affidavit also.
That has not been recorded here.
Kobhe
And they did not seek the leave on the last occasion at least. They might have at the time of call, comma, none appears for the appellant, although the respondent numbers, you are for 7. No, you are for the, no.
Only respondent, award holder.
Comma, the award holder is represented through senior counsel. For sub next para, we find from the previous orders that on August 20, 2025, comma, when the matter was called on for hearing, comma, none had appeared for the appellant, comma, due to which the matter was adjourned for that day. For sub next para, even on September 24, 2025, comma, when the matter was next taken up, comma, the appellant had prayed for an adjournment, upon which the same was adjourned. Full next para, even today, comma, at the time of call, none appears for the appellant. Full it prima facie transpires that the appellant is not interested to move the application for condonation of delay. Accordingly, as a last chance to the appellant to move the application, comma, the matter is adjourned till November 19, 2025, with the clear rider that in the event none appears to move the application and or any adjournment is sought on behalf of the appellant on the next returnable date, comma, the matter may be disposed of ex parte in the absence of the appellant. Mr. Shen, if you can intimate this order to them so that it will be, they'll know what is coming from them.
I'll show.
Yes. You two are appearing together, Mr. Basu and you.
No, we have various parties.
No, we are appearing together.
Ishwar na তুমি
আছি তো
Ishwar,
সব ঘাবড়ে যাচ্ছে
I appear for the respondent or
আসল লোক কোথায়
You're for the KMD. You're the face of KMD in the High Court now.
yes
Dean, file ta
his
dao.
senior is no more coming so that's why he is the only person
That's it. No, he's competent.
there are some other independent.
আছে নাকি
তারা brief পায় না
ওকে দেখতে পাই না
You've been allocated to our court then because we see only you every time. What is the matter about?
This is relating to the Dakshineshwar temple.
Oh,
So basically what has happened, as your lordship knows, there is a scheme of administration
yes.
by which this honorable court monitors the administration of the temple.
Yes.
Now, as per the scheme, from year to year, every 2 years, we come before this court and under the area of the court, the court appoints a special officer who conducts the elections. Last year also, we made this application. This year also, we made this application. It was 2 years expired, and we came before the court that please appoint somebody who will conduct the entire. Former Chief Justice of this court was appointed to conduct this. Challenging this, there is a small minority who total about 3%, 4%, who come to court only. They don't go to the temple. They don't participate. And why I'm saying is they never participate in the elections.
All right.
They never go and attend the meetings. But they come and file applications.
They're members of the board of the trustees.
They're members of the board. They are Shebites.
Shebites.
Having very minuscule.
But they also have palas.
No, not palas over here.
This is not a pala arrangement.
No. What happened? That is
the Kalighat.
Kalighat is pala. Over here, what happens is the Shebites elect trustees.
All right.
The trustees are the ones who run the temple. But
for that tenure.
Yes, for this period of 2 years,
right.
as per the scheme.
So what is the ground of challenge here?
I could not make out.
Who is the appellant?
Yeah, appellant is Mr. Bijoy Odhikari.
We release the matter person. No, they're not appearing today.
No.
What is the ground of appeal? At least
also they don't appear
we'll dismiss for default, then they'll come.
I think that will be better. That will be better. If my lord knows we will not oppose for lawyers ground. Let you dismiss for default. If they interested, let them come.
We'll advert to the previous orders also when they did not appear.
In code number 10 probably.
Oh, there is also two public interest litigations also who are there.
Okay.
So that is why the court hearing it released the matter that since the PI, because that was before the other courts, the PIL should also be heard together and everything. And
They should also go there.
no, before your lordship, everything is now assigned.
No chance.
The PIL is PIL is
No,
also there.
everything is also. You're all assigned before your lordship.
PIL also filed by the same person.
The same.
Name lender.
This side, that side. But generally, same set of lawyers only conduct.
We find from the previous orders that on July 9, 2025, none had appeared at the time of call on behalf of the appellant. Although the respondents were represented through counsel, even on August 20, 2025, a similar exercise was repeated, as the appellant was not present to move the matter, although the respondent KMDA was represented through counsel. Next para. Again, on September 24, 2025, at the time of call, the appellant had prayed for an adjournment. Next para. Even today, none appears for the appellant, although the respondents are represented through counsel. Hence, it transpires that the appellant is not interested to proceed with the appeal any further. Interested to proceed with the matter any further. Accordingly, APOT 138 of 2025, along with WPA within bracket P 480 of 2022 and WPA within bracket P 559 of 2022, with IN number GA1 of 2025, GA3 of 2025 and GA4 of 2025 are dismissed for default. Interim order, if any, stands vacated.
I appear only WPA 55.
You give the numbers and your name and the numbers and the party for it.
We are there in all of them.
Yes, you are there in all of them.
If they come, or not, will.
If they come, we'll take up the matter and dispose it of. Yes.
Grateful.
Thank you. Great. Thank you. বিজয় দিবসের সঙ্গে তুই ঝগড়া কর এবার বিশেষ তো ইটশনে মারবি yes yes
Respondent will not.
But in this matter, Mr. Vijay Kumar is suffering.
Mr. Vijay Kumar, yes, he was happy.
He is suffering from cancer, my lord.
Yes, we know, but that has been happening for a long time. He went somewhere for treatment. He's supposed to come back now.
But he was supposed to be in treatment, my lord. He just went there, my lord, for the treatment, my lord. That he has told me, my lord.
So then, Mr. Arifin, you have to make alternative arrangements. We fully respect Mr. Kumar and we fully empathize with him. But this cannot go on forever because this is being adjourned for months on that illness, and he himself also prayed for an adjournment on that ground on one occasion. So if he could come to court, he could move the matter. Now, if this continues, we cannot stall the matter indefinitely because your learned friend is coming and going.
I understand that. I am deeply.
You make alternative arrangements. We'll keep it next week. Make alternative arrangements.
Well, even with the extended time, paper books have not been filed.
But that is
That is a-
difficulty, my lord. All
that
Yes,
is
but
a
cancer cannot be a ground of,
default clause.
then make alternative arrangement. If I was suffering, I would have made alternative arrangements.
we have to make them, my lord. If we,
So
Make it
that is-
immediately.
That is a default clause but by minor justice saying in the event paper books are not filed, interim order stand vacated. So if they are not willing to proceed the appeal,
देखिए, आगे order
well,
sheet.
give me liberty
kindly
to
No,
proceed
we'll
the
check
contempt
that.
matter.
It cannot be an indefinite
give us
ground.
1 week time, my lord, for
Even with the extended time,
Check, we check.
but
they
You
are not
cannot
filed.
prevent us from checking. Why are you continuously speaking? He is speaking. You cannot disturb the court in this manner. It's not a free for all. He's arguing. Please keep your mouth shut, Mr. Arifin. Why didn't you file the paper books? Mr. Kumar is not supposed to file the paper books.
but
His
he-
juniors are.
He's the advocate on record, my lord, and all papers are with him, my lord. That's the problem, my lord. We have tried our level best, my lord, to convince him to file the paper book, my lord, and everything is with him, my lord. But I understand, my lord.
So then why don't you take the papers from him and file it?
My lord, my lord,
He will appear at the time of call.
my lord, I have tried, my lord, my level best, my lord. Even the ECL authorities has tried, my lord. But my lord, he is, my lord, he's arrogant that he will do that.
No, then we are dismissing the matter. Then you will learn a lesson.
Just give us 1 week time, my lord. I will make arrangement, my lord. I will take the all responsibility, my lord.
No,
for
not
this matter.
responsibility. You have to file these paper books then
Certainly, my lord,
within
my lord,
that period.
type to obtain papers if necessary,
They can't obtain papers and file paper book within 1 week. We are giving them 2 weeks as a last chance. We'll dismiss the matter for default unless they do that. This is the last chance we're giving. Learned counsel for the appellant. We'll record that. Learned counsel for the appellant submits that the learned advocate appearing for the appellant is suffering from a serious ailment and is unable to appear before the court. Full stop. Next para. It is reflected in the order sheet and as well as borne out by the records that similar adjournments had sought on the self-same ground on several previous occasions. Full stop. Next para. Learned counsel appearing for the respondent numbers 1 to 6 rightly points out that despite previous mandatory directions directing the appellant to file paper books, nothing has been done till date. Full stop. Next para. Despite empathizing totally with the ailment of the learned advocate, despite empathizing totally with the learned advocate appearing for the appellant due to his serious ailment, the same cannot be a ground to stall the appeal indefinitely to the detriment of the respondents. Full stop. Accordingly, the appellant is requested to make alternative arrangements for appearance in the event the learned advocate at present appearing for the appellant is unable to do the matter. Full stop. We also find from the order dated September 3, 2025 that an extension had been granted to the appellant to file paper books. Full stop. However, despite the last date for such filing being September 24, 2025, even today paper books have not been filed. Full stop. Para. In view of the above, as a last chance to the appellant, the time for filing paper books is extended till November 21, 2025. Full stop. The matter shall next be listed on November 26, 2025. Full stop. It is made clear that in the event the appellant does not file the paper book within the stipulated period and or is unrepresented or seeks an adjournment on the next date of hearing, ex parte orders may be passed against the appellant.
I'm really grateful.
Don't give his name.
No, I'm just giving my name.
8 হয়ে গেল? Second. ও আচ্ছা, আমি তো কন্টিনিউ করছি, ঠিক আছে, ঠিক আছে, গুড, দেখেও ভালো লাগে। আমি কল করতে শুরু করার গালাগাল খাওয়ার জন্য রেডি। আজকে অনেকদিন আসেন ওই হ্যাঁ, এটা ঠিক হয়ে ওয়াইফাই ঠিক হয়ে গেছে? Yes.
May I permitted to pay for a leave to file this application for dismissal of appeal on.
Why is leave required?
Leave is required because the filing section saying that the name of the sole appellant who died, though it is not required to file the death certificate, but I have annexed the death certificate, but name of the deceased not matching with the cause title of the appeal. But I have in my preamble, I have already mentioned it by taking alias.
The leave is, we are granting leave. At an endorse code, leave is granted to file the application.
Lordship is permitted to mention an application for inclusion in the list, Lordship.
What sort of application?
And matter, Lordship.
And yes.
Lordship, kindly allow me to mention one application in connection with first appeal matter.
Yes.
I am seeking leave to file an application in a writ petition arising out of a land reforms tribunal order. My lord, this writ petition has been filed by the state against an order passed by the land reforms tribunal directing the state authorities to hand over the possession in favor of my predecessor in interest. Now, my lord, in this writ petition, informal paper book has been prepared. Now, my lord, the sole respondent, my predecessor in interest, expired. Now, my lord,
What is the leave
my
sought
lord,
for?
I am seeking, my lord, seeking to file an application for early hearing of the writ petition.
Why
My lord,
do you require a leave?
my lord, because, my lord, I am yet to be substituted and the department is not accepting since
Is there a substitution application pending?
pending, my lord. My lord, this matter, no steps is being taken by the writ petitioners, the state authorities. I have mentioned it several times before the honorable coordinate benches. My lord, since the petitioner is not represented, the matter should adjourn, my lord. So, my lord, I am only praying leave to file this application, praying for expeditious disposal of the, my lord,
No, if you are not a party or don't have the locus standi.
the application is pending. I am an interested party. Matter is pending since
No, then you have to file
2010, my lord.
either a
They have
different
filed.
either you have to file a different application or a composite prayer has to be made.
Well, that I have made, my lord.
Pure
That
addition of
writ
parties.
petition along with the connected application. That
No,
I
no,
have
not
made.
that. You have to seek leave. I mean, formally in the application or seek addition of party. Otherwise, how can you do that?
Addition of party, my lord, I have once prayed. That was turned down by the honorable coordinate bench.
Then how can you pray?
My lord, thereafter, my lord, the state filed an application which is still pending.
No, if your addition of party prayer was refused, you cannot file an application.
Since,
Rightly.
my lord, that order, my lord, may I show the order, my lord? That order was turned down, that prayer was turned down because I am a party, I am to be substituted against the respondent, and since the petition has been filed by the state is the, my lord, that is the observation of the honorable court, that the state is required to file the substitution, not the respondent. So that is why my prayer
That application has been rejected. How can we add it?
But thereafter, my lord, the state has filed an application for substitution, which is still yet pending. And my lord, no steps is being taken by the state. My lord, matter was mentioned at my behest, my lord, before the honorable.
How have you described yourself in this application?
My lord, as applicant, my lord. You legally are of the sole respondent.
Let us see the application once.
My lord, it is tagged, my lord.
You have to amend the your description. You are this Miss Lina Roy
and others.
So you have said that you are applicants. You say proposed substituted respondents stroke applicants. You
Yes,
do
sir.
that. We are
That
granting
I
you
will.
leave, but do that. Verbally
I
we are
will.
telling. Leave is add a leave the other to file.
Lordship, may be permitted to mention a matter for application for inclusion.
Order 41
Yes, you are there first. You are there first. Yes.
I have the permission to mention.
Quickly mention.
Lordship, the appeal is arising out of a money suit.
Appeal hearing.
No,
Sorry.
uh,
Then what?
It's a uplisting for the matter.
No, no, sorry. Application. Please help her.
Lordship, this is my first appearance. Kindly pardon my mistake.
First appearance in handover. Yes, whatever it is.
I think it's order 41, your lordship, no application.
Whatever it is. Yes.
One order 41 and one application.
Both. FA order 41.
Order 41.
যা দিয়েছে প্রথম অ্যাপিয়ারেন্স নেই দিয়ে দিই লিস্ট টু বি মেনশনটা দিয়ে দিও যদি ডাউট থাকে টু বি মেনশন yes is the defect Mr. Shandal?
The application for substitution is there, lordship. The last occasion we have submitted the certified
So what
copy
is
of
the
the
defect
decree.
in the appeal? As usual, not checked up.
The certified copy of the decree we have, lordship, submitted before the department.
Name of respondent to Chaw in the certified copy of appeal does not find place in the cost session. To Chaw you have not included here. Anyway, this is a substitution application.
Substitution application upon death of lordship, the appellant
Within
number.
time?
No, sir, after there's
You have served on the other side.
no, lordship, we have to serve, lordship, first time.
The petitioner shall serve. The petitioners shall serve a copy of Can 1 of 2023. Shall serve copies of Can 1 of 2023 on the respondents, indicating that the application shall be listed under the same heading next on. So this is a second appeal.
Second appeal, lordship.
Then let it appear before the learned single judge. You have this clarified and then come. the petitioners shall serve copies of the present application on the respondents, indicating that the matter shall be listed before the appropriate learned single judge having determination, and file an affidavit of service before the learned single judge as and when the matter comes up. এটা আর আমাদের লিস্টে এখন আসবে না, এটা বেরিয়ে যাবে সিঙ্গেল জাজ ডিপার্টমেন্ট পাঠিয়ে দেবে, মেনশন বিফোর সিঙ্গেল জাজ, গেট all these resolved and then come mention for order 41.
Great, please.
Already in item number 2, my lord, I am for the appellate.
Yes.
My lord, there is a defect, my lord, but I yesterday, my lord, I tried my best, my lord, to find out the report of the stamp reporter, my lord, whether it is, my lord, the limitation or not.
Why didn't you find out?
My lord, but I could not find any report from the department, only defective.
No, in the memorandum of appeal it should be there. Yes, in your memo, it's there in the memorandum. Memorandum says preamble is bereft of the name of judge. The ঠিক করে দিয়েছে, date of signing of the declared trial সেটাও করে দিয়েছে।
But there is the note.
You have not filed the decrees of both the court.
Decree, my lord, so far the trial court decree is concerned, my lord, I have got the certified copy, original certified copy.
Appeal court decree you have to file, otherwise it will be defective. We cannot
No,
take
my
it up
lord,
under order
appeal court
41.
decree I have filed. Certified copy of the
Report
appeal-
says none have been. Decree has not been filed. Only judgment has
that
been.
is, my lord, of the trial court.
Both courts. That is the report.
Kindly, my lord,
Let us check up directly. Yes, there is no decree of the trial court. Either trial court or appeal court. Without the decree, how can you take it up under order 41?
Very soon. Application.
Limitation won't run because order 41 rule 1 now says judgment. But our rules say the decree has to be filed before it becomes in form. Please file the self-certified copy. Let the matter go out of the list with liberty to the appellant to
This is the certificate.
rectify the defects,
No, my lord, this is where the appeal was dismissed, my lord, that is why there is no decree.
comma, by filing the certified copies of the decrees of both the appellate, first appellate court and the trial court. Because the appeal is dismissed, no decree will be drawn up.
But this is
Definitely it has to be done. যা বললাম তাই, হ্যাঁ, out of the list এখন ওই defect correct করতে হবে. Please correct the defects and then come file those and then mention.
Item number 3 with 4.
3 with 4, yes. Yes.
My lord, kindly, my lord, one thing, my lord. Can I file the, my lord, the certified copy of the judgment to the trial court as well as the
No, file everything in the department, let them give a revised report, then we'll take. Yes, Mr. Doctor.
My lord, in this matter, my lord, this is my lord, father. I have a genealogical table, my lord, I have prepared, my lord, also kindly.
Judgment of affirmance, Mr.
No, judgment.
Affirmance.
My lord, the counterclaim, my lord, plaintiff filed suit for eviction of license.
You are what, the plaintiff or the
I am from the plaintiff.
Achha.
Eviction of license after recovery of cash possession after my lord, revoking license. And my lord, the pro forma defendant number 2, father executed gift deed in my favor, and defendant number 1 is the eldest brother. And I allowed my eldest brother to stay. Then my lord, after serving notice, I filed eviction suit against defendant number 1.
Other gifted the property to you?
Other registered gifted. Muslim property, but
why was the suit dismissed?
Suit dismissed that regarding license, it was the observation that defendant number 1 was in possession a long time. So license cannot be believed. And when the fathers, when the evidence was going on, fathers was brought by my pro forma defendant, no relief has been sought for against my father. And father was pro forma defendant number 2, as he executed the gift deed, he was made parties. When the evidence was gone after 4 years, he filed counterclaim.
They filed counterclaim?
They, defendant number 1.
Other filed counterclaim?
Father, defendant number 1 brought.
Appeal for the father or the eldest?
No, eldest.
Father, what was the counterclaim of the father? Challenging their gift deed.
Counterclaim, my lord, says that upon misrepresentation,
So what happened to that counterclaim was allowed?
counterclaim dismissed.
Counterclaim also dismissed, or suit also dismissed?
Suit also dismissed.
Suit dismissed because it was observed by the trial court that he was there before you got the gift, so therefore you could not have granted license. But he could not substantiate any other
document in his favor.
Appeal court also said similar things.
Appeal court said that appeal court have formulated other things, that the gift deed was registered at Baharampur Registry Office. And there was sub-registry office at Bharatpur. Why father was brought to Baharampur, it was suspicion. And it was the misrepresentation. But father, similar way, my lord, executed in the 2001, executed 2 other gift deed in my favor.
Those were exhibited?
No, those are not executed. That's why you have filed application under Order 14 Rule 27. And my lord, the father also executed other 2 gift deed in favor of defendant number 1. And my gift.
All were in Baharampur Registry Office?
No, Baharampur, my 2 separate gift deed at Baharampur. And their gift deed at Bharatpur.
Bharatpur is a sub-registry office?
Sub-registry office. And appeal court formulated.
On that ground, the gift deed was disbelieved and counterclaim allowed. By that, counterclaim allowed, and you should.
And
so these 2 appeals against, one against counterclaim allowing, another against.
And my lord, I also filed a separate suit in 2005.
What happened to that?
That Order 14 Rule 27, I have taken this certified copy I have obtained. Photocopy.
Does that make a difference, Mr. Dutta?
My lord, in respect of 2 other gift deed, I also, my lord, filed a suit against defendant number 1.
What happened to that?
And that was decreed in my favor. Father was also defendant number 5. And my lord, father admitted that I have executed 3 gift deeds. And father father also admitted other 2 gift deeds in their favor.
So why didn't you produce those in the trial court?
Trial court, my lord.
Or the appellate court? You are producing.
No, after passing the trial court judgment, that was decreed.
But before the appellate court?
Before the appellate court, my lord, the other Order 14 Rule 27 was filed in respect of, my lord, the defendant number 1 initially claimed possession under, my lord, Homestead Act 1975.
Why was these documents not?
My lord, that document trial court believed, and after believing that document, father.
No, Mr. Dottu, we are asking you. You have filed an Order 14 Rule 27 here to bring the plaintiff.
That's I have explained, my lord. That is the one your lordship also earlier, my lord, in this week, my lord, passed a similar order to Order 14 Rule 27 regarding the my lord, important document. If it
was the finding of the appellate court on their counterclaim. Which appeal should you take up? Recently?
First.
72 or 11?
114.
114 is now essay. All right. Yes, 114.
114.
Shows the finding of the appellate court regarding this.
Page 60.
Bharatpur and Baharampur, this conundrum.
Yes, my lord. My lord, page 16.
Of 19.
But from the evidence, it is crystal. Has you also got in, my lord?
Not yet. Name Yes, please. 16.
From the evidence, it is crystal clear that Labusek had no intention to execute the impugned Hebanama regarding the suit property in favor of the plaintiff. Rather, it was intended to execute the same in favor of defendant number 1. The evidence of Labusek executant is very much vital. To make the valid gift deed, it is necessary that there be clear and unambiguous intention to the donor to make the gift. There is an absence of real bona fide intent of the donor on the donor's part. The alleged gift is considered void. The declaration of the gift must be made voluntarily. The donor must give free consent before making the gift. If the declaration of the gift has been made under coercion, my lord, there is no pleadings in the counterclaim. Coercion, fraud, only misrepresentation, there is only misrepresentation. Or undue influence, such gift deed will be considered as void gift deed. The evidence of Labu Sheikh executing this summary, Labu Sheikh had never intended to execute the impugned deed regarding the shoot property in favor of the plaintiffs. It was decided that the properties of Labu Sheikh will be distributed among his sons as their possession. The possession of the shoot property from the long time with the defendant number 1. In the evidence, Labu Sheikh admitted that he has the intention to settle the property, all the properties. The impugned deed was executed at Bahrampur Sador, more or less 50 kilometers instead of Bharatpur ADSR. The executant Labu Sheikh was a senior citizen and old, and the content of the impugned Hebanama has not been explained and read over. My submission would be, my lord, in others, all these, my lord, in the written statement, my lord, Labu Sheikh signed in Bengali written, there is no read over explained. But in case of the impugned gift deed, my lord, in respect of shoot property, only the averment of the appeal court that there was no explanation, read over explained. Now, my lord, last paragraph, during that page 17.
What about this act? What are you saying about this act? Where have you handed over? This Artisan Act?
Artisan manner in by for Labu Sheikh deposed and admitted the gift deed, and that judgment was passed in my favor. Trial court, my lord, held that that judgment is, and my lord, the appeal court, my lord, we have also, my lord, taken a order for Rule 27. And appeal court held that the judgment is not binding on the civil court.
Order these appeals will be heard on the following common questions of substantial questions of law. 1, Roman 1, whether the learned judge of the first appellate court substantially erred in law in overlooking the admission of Labu Sheikh, the father of the appellant, in a different proceeding under the West Bengal Acquisition of Homestead Land for Agricultural Laborers, Artisans and Fishermen Act, 1975, to the effect that he had executed a hibanama within bracket deed of gift bracket close in favor of the appellant, and relying on the oral evidence of the said Labu Sheikh without adverting to the contents of such evidence at all. Next, Roman 2, whether the learned first appellate judge substantially erred in law in reversing the detailed findings of the learned trial judge without assigning appropriate reasons therefore, thereby committing perversity. Roman 3, whether the application for production of additional evidence filed before this court by the appellant ought to be allowed, and consequentially whether it would be established from the additional evidence, if so allowed, that other similar gift deeds had been executed by Labu Sheikh in the registration office at Bahrampur, which was one of the grounds of opposing the execution of the gift deed by Labu Sheikh. So, these 3 grounds.
And there was no averment regarding
yes.
void and
whether, fourth point, whether the learned judge of the first appellate court reversed the conclusion of the learned trial judge insofar as the validity of the gift deed executed by Labu Sheikh in favor of the appellant is concerned, on the basis of the ground of coercion, whereas thereby going beyond the pleadings of the written statements.
And I have also taken a ground that the trial court held that counterclaim will be considered at the time of final hearing. And after 4 years, counterclaim has been filed. That is all right, I have an application for injunction, my lord.
The appeals will be heard analogously, in view of the appeals having arisen respectively out of the decree passed in a suit and out of the corresponding counterclaim. Yes, injunction application, you have a right of hearing now. Why two sets of can 1 and 2? What is can 1?
Can one injunction.
And 2 is
Can
order for
2 minute I have Labusek also filed another suit that has been withdrawn.
Why can 1 and 2 in both the appeals? Similar applications?
No. In the can one I have paid for leave that the certified copy of the trial court judgment has been enclosed in the first appeal for first matter.
Dispensation in the other matter.
And in this
this has been filed in can 1 of which appeal?
115th SAT can 1 application for leave.
And can 2
injunction. Can 2 injunction.
And what is can 1 in
can 114 injunction, and can 2 minor I have enclosed the documents of
order for
1027.
Very well. Then can 1 of 114 and can 2 of 115 both are injunction applications, so both can be taken up together and disposed of. You are for the only for the respondent.
Only for the one.
But pro forma respondent has to be served here because he took a serious stand in that.
Yes.
In this particular case, he has to be.
Yeah, for Sigma and I'm for.
You are for all the respondents. Only you for sake.
Yes, ma'am. Only your first.
There are two respondents.
The others are pro forma. Very well. Can 1 of 2025 in SA 72 of 2025 as well as can 2 of 2025 in SAT 115 of 2025 are injunction applications with similar prayers. Puts up in view of the appeals having been admitted on substantial questions of law, we find sufficient prima facie case for the appeals to be heard on merits. Puts up accordingly the you have sought for injunction against whom? Respondent number 1?
Respondent number 1.
Not 1 actually. Respondent 10.
Yes, yes.
10 is your fault.
Oh, Ismail.
Yes.
There shall be injunction restraining respondent number 10 and or his men and agents for selling, transferring, alienating and or encumbering the suit property in favor of third parties and or changing the nature and character of the suit property till disposal of the application. Push up. Have you
changing nature of character is
not prayed?
No, man.
No, man. When I have paid the alienation, incumbent, creating third party interest and parting in position. I may permit it that.
No, we are granting that also. Status quo as regards, status quo as regards nature and character, status quo as regards position.
Yes.
Of the status.
I am leaving there for 30 to 40.
1 minute.
Okay.
Restraining them from change, যেটা বললাম, selling, transferring, alienating, and encumbering the suit property in favor of third parties,
yes.
And or changing the ওটা দিও না তাহলে and or changing the current position in respect of the suit property, yes, in favor of third parties in any manner till disposal of can 1 of 2025 in SA 72 of 2025 and can 2 of 2025 in SAT 115 of 2025. The appellants shall serve copies of the said applications on all the remaining respondents and pro forma respondents, indicating that the application shall next be listed before the appropriate learned single judge having determination and file an affidavit of service to that effect before the said learned single judge. So next para, can 2 of 2025 in SA 72 of 2025 is an application for production of additional evidence and as such shall be heard along with the hearing of the appeals. Footstep affidavits, if any, shall be exchanged in the meantime. And SAT 115 can 2 was for leave.
Can 1
that leave 2. Can 2 of 2025 in SAT 115 can 2 is that dispensation.
Can 2 is injunction, my lord.
Okay, can 1 is the dispensation.
Can 1.
Can 1 of 2025 in SAT 115 of 2025 is an application for dispensation of filing of the certified copies of what? Judgment and degree of all the courts?
No, I have enclosed the decree judgment.
For dispensation of filing of the certified copies of the judgments of the courts below, such application is allowed and the certified copies annexed with the memorandum in SA 72 of 2025 shall be deemed to be sufficient compliance in respect of SAT 115 of 2025 as well. Full stop. The trial court record shall be brought by special messenger, comma, to be deposited by the appellants within a week from date. Full stop. In view of appearance of the respondent number 10, comma, service of notice of the appeals on the said respondent is dispensed with. The appellants shall deposit postal costs and other requisites for service of notice of the appeals on the other respondents and pro forma respondents also within a week from date. Full stop. Next para, the appellants shall prepare and file the requisite number of informal paper book, composite informal paper books without comparing with the records in respect of both the appeals within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Analogous hearing we have directed and composite paper.
Analogous.
And composite paper. All the rest happens before the learned single. Ultimately, no look at court.
8 number 12 না 12 we are grateful.
Thank you, sir.
This appeal very interesting question of law in court.
Next one or the previous?
Which your lordship considered.
My lord, I am appealing on behalf of the petitioner.
Appellant.
Appellant.
Yes. Too many read petitions. Doing too many read petitions.
There is an application for Section 5, my lord.
Section 5?
Section 5.
For the first time?
First time.
Sub copies of both applications? No, the other application that would tantamount to admission. Well, sub one can one.
Only one thing, my lord.
Yes.
The being aggrieved and dissatisfied with the order of the learned additional district judge Bardhaman, we have thereafter we have filed an application under 227 of the before the Honorable High Court at Calcutta. The Honorable High Court at Calcutta has been pleased to liberty.
No, but still Section 5 has to be filed because the delay is there. You can invoke Section 14 of the Limitation Act at the time of hearing, but Section 5 has to be filed because it has been filed belatedly.
Yes. Only 60 days delayed at my
1 day delay also you have to serve for nothing doing. The appellant shall serve copies of Can 1 of 2025 on the respondents, indicating that the matter shall be listed under the same heading on November 25, 2025, when an affidavit of service to that effect shall be filed by the 25th November. আচ্ছা একটা কাজ করো Can 1 of 2025, copies of Can 1 of 2025 and Can 2 of 2025, বাকিটি যেটা বললাম একটা লাইন অ্যাড করে দাও. It is made clear that direction to serve copy of Can 2 of 2025 shall not per se be deemed to be an admission of the said second appeal.
For the appellant petition.
Yes, sir. What is that?
My lord, all corrections made, my lord.
Wait.
Directions.
Out of time, when Section 5 has been served.
Section 5, my lord, yes.
You are for the
Yes,
oh,
appearing
yes,
for the respondents, my lord.
What is the delay?
My lord, delays of my lord 1 year, 2 months. Now, my lord, for the 2 months, my lord, Section 14, my lord, of the Limitation Act, my lord, I'll plead, my lord, since a revision was filed initially, that was my lord subsequent.
The impugned judgment.
Order 22, Rule 10, my lord, that has been allowed.
Yes, we are allowing. What is this addition of party? Who do you want to add?
Addition of party, my lord, that is just my lord, addition of party, because my lord, initially in the memorandum of appeal, my lord, the name of Shekhar Dash was my lord, inadvertently, my lord, made in the cause title. Shekhar Dash, my lord, died, my lord, during pendency of the my lord, the suit, and my lord,
his heirs were substituted there. You are permitting both these applications, allowing.
My lord, but I should well oppose, my lord, considering the delay and my lord, without any.
Why should you should? You are opposing. You are recording your opposition and allowing it. Can 1 of 2025 is an application for addition of the heirs and legal representatives of one Shekhar Das, who had expired during pendency of the appeal before the first appellate court, and his heirs had already been substituted. Full stop. Next para. Since the application is technical in nature and in any event, the heirs of the deceased have already been substituted in the first appellate court, Can 1 of 2025 is allowed, thereby directing the heirs and legal representatives of late Shekhar Das to be added as parties to the present appeal instead of the said deceased. full stop, necessary consequential corrections to the cause title of the memorandum of appeal and the pending application, comma, if any, shall be carried out by the learned advocate and record for the appellant during the course of the day this time.
Yes, yes.
In the course of the day. Full stop, next para. Can 2 of 2025 is an application for condonation of delay. Full stop. The present appeal challenges an order passed under Order 22 Rule 10 of the Code of Civil Procedure. Full stop. Initially, comma, a revisional application was erroneously filed. Full stop. However, comma, subsequently the error was detected. It was dismissed.
Well, withdrawn.
Subsequently, the error was detected and the said revisional application was withdrawn and the present appeal preferred on proper legal advice. Full stop. We find sufficient bona fides behind such error, comma, since it might omit the notice of the learned advocate, comma, if not regularly conversant with civil law as to the availability of an appeal against an order under Order 22 Rule 10 of the Code of Civil Procedure under Order 43 of the said code. Full stop, next para. Accordingly, we are of the opinion that sufficient reasons for the delay has been made out. Hence, can 2 of 2025 is allowed on contest, thereby condoning the delay in preferring FMAT 373 of 2025. Now, move the appeal under Order 41.
Yes. My lord, initially, my lord, the plaintiff, my lord, is, my lord, one Shankar Dash. He filed a suit for partition against, my lord, 3 defendants.
Yes.
Shekhar, Somnath and Minoti. Now, my lord, Minoti is the mother. Minoti is the mother. Shekhar and Somnath are 2 of his brothers. My lord, that suit, my lord, 1/4 share, my lord.
Shantadas is not corrected here.
Yes, Shanti is corrected, my lord.
Where? In the memo, it's not there. Still not corrected.
My lord, in the memorandum, my lord, it was, my lord, wrong. My lord, just now I moved the application for addition of party. Now it has to be, my lord, added.
Oh, that's Shekhar.
Shekhar one. First Shekhar.
Yes. Please carry on.
Yes. Now,
What is the suit for? Who filed the suit?
For partition.
Partition.
My lord, filed by, my lord, one Shankar. Now, my lord, Shankar died, my lord, during, my lord, after, my lord, the preliminary decree was passed. 1/4 share was, my lord, pleaded. 1/4 share for Shankar, 2 of his brothers, and the mother. My lord, suit initially preliminary decreed. After that, my lord, for final decree, application was filed. It's in the process, my lord, for final decree. In the meantime, the mother died. The mother
also died, mother also died.
Mother also died.
Both died after preliminary decree.
After preliminary decree.
Right. Mother's name?
Mother's name is, my lord, Minoti.
Minoti died. Both died. Yes. Then what happened?
Minoti died on 4th of March 2022.
So who are sought to be added now?
Not added. Well, what happened is, at that point of time, Shekhar and Somnath came up with an application under Order 22 Rule 10, stating that the mother already gifted us her share of the property prior to, my lord, filing of the suit itself. Suit was filed on 7th of July 2011. They came up with an application that the deed was made on 24th of May 2011.
In the written statement, they did not disclose.
Nothing. Nothing disclosed. Minoti, my lord, cross-examination happened.
If it's a registered deed, you have to challenge the veracity of the deed also. Otherwise, this cannot be decided at Order 20 Rule 10 stage. It can be tentatively decided that since they have a registered gift deed, the heirs. See, Order 20 Rule 10, they are already parties.
Already parties. 152 I filed for, my lord, correction of the decree, since initially I pleaded share.
So they are already parties. So now they basically seek to exclude the other heirs.
Exclude the other heirs so far as Minoti share is concerned.
Minoti and Minoti.
Minoti share is concerned, because they say Minoti gifted us her share of the property prior to, my lord, the suit itself. My lord, kindly, my lord, takes up their application once, my lord.
First, we'll see the order, Mr. Banerjee, and then we'll go back to
Yes, certainly.
That will make it
You'll
clear
be
for us.
taking up the stay application. I have an
the memorandum itself. So, what is the number of the order? Date of the order?
Order dated, my lord,
28th June.
20th of June 2024, my lord.
Let us read that order. Please place that, Mr. Banerjee.
Yes, just. My lord, 28th of June, my lord, order number 105. My lord, both the parties file their hajira. The petition under Order 22 Rule 10 of CPC is taken upon record for hearing in presence of both the parties. Peruse the petition, heard both the sides. At the time of hearing, learned lawyer of the plaintiff has submitted that the provision of Order 22 Rule 10 of CPC has come in.
Very well. Now, see, you have two very good grounds. One is that this happened. Apparently, the gift deeds were executed in 2011 prior to filing of the suit even.
Institution of the suit itself.
So, therefore, they did not take this point. They are precluded.
did not take these points in their in their written statement, in
And
their cross
before
examination ever.
before the shares, the preliminary degree has attained finality now.
Yes.
Now they cannot reopen those shares.
Reopen
on a
those shares
prior.
after I file a 152 in terms of that Minoti diet. So
Secondly, another ground is probably there because they're already parties. Order 20 Rule 10
Rule
was
10
a
does not apply
superfluity.
at all.
Superfluity.
Does not apply.
Yes, we'll ask you, why Order 20 Rule 10? If you rely on a gift deed, two questions to you. One, if you rely on a gift deed which was executed in 2011, why don't you disclose it before the preliminary degree is passed and the shares are declared? Once the shares are declared, they cannot be reopened because preliminary degree has equal binding effect as a final degree. It's a degree of court. If that be so, you are in effect trying to reopen the preliminary degree without preferring a challenge to that. One. Secondly, why this sanctifying or validating your stand by allowing an Order 20 Rule 10? Order 22 Rule 10 is applicable when somebody steps into the shoes of a party. Here you are already parties. This order will set aside, will permit you to produce the gift deed if otherwise permissible in law, subject to their objection in the suit.
Now,
but will also hold that this is a good ground for their resisting, that you are in effect. And why should we permit you at all? This Order 20 Rule 10 was a superfluity one. Second, the deed was executed prior to the filing of the suit. So you cannot reopen the preliminary degree without preferring a challenge. Therefore, you cannot produce the deed even. We cannot give you that liberty also.
Now, my lord, may I submit, my lord? My lord, the
only my lord, one thing, my lord, may I please, my lord? The application itself, my lord. Kindly, my lord.
What do they? What is the worst thing in the application? Tell us.
Worst thing, my lord, the only thing in the application is it was kept in a locker. I missed it. Whereas, my lord, the gift deed is in favor of both
Happens
the
every
brothers.
time to me. Maybe a truth. Maybe the truth. If you look at the application, you will be convinced.
My lord, lack of knowledge cannot be a ground.
Something is always kept in some almirah, some locker.
Yes,
What
my
happened
lord,
during demonetization?
This is not a will.
Your monies which were given by your mother in your birthday and you kept it in an exercise.
Happened mostly with the mothers.
No, not children also. Yes.
Yes, my lord. My lord, kindly consider this Rule 22, Order 22 Rule
Forget
20.
the provision. What is your answer to our
Well, I'm saying, my lord, my lord. My lord, the simple reading of the Order 22 Rule 10.
What does it say?
Start with, my lord, procedure in case of assignment before final order in suit. My lord, it is a procedural, my lord, provision. While it is a procedural provision of the trial court, it is also a discretionary power of the trial court. It is not a restrictive in nature. Kindly consider. This, my lord, in consonance with, my lord, Order 1, Rule 10 for proper implement of the parties. Now, my lord, my substantial right has to be established there. Otherwise, my lord, it will bring another, my lord, multiplicity of suit, because, my lord, I have to file another suit for declaration to get the right from the, my lord, deed of gift. Kindly consider. Next, my lord, this is not a final order at all. This is not a final order at all, my lord. My lord, by this impugned order, my lord, court given a chance to us to decide the matter. It is not, I said earlier, my lord, it is not final order. And my lord, no prejudice caused to my learned friend or their client in respect to share. And my lord, kindly consider, as per section 122, 123 of the Transfer of Property Act, a gift deed is final, valid, and complete when it is executed. They know about.
It is not. That is the fun of 122, 123. It is not when it is executed. When it is accepted during the lifetime of the donor.
Yes, my lord.
That is the difference between.
And my lord, they know the execution of the same. They know well about the gift deed. Till that, I am submitting before my lord, they have not challenged the said gift deed. That means they admitted it. My lord, the Order 22, Rule 1, my lord know better than me. The Supreme Apex Court, my lord, said it can be invoked if the situation so demanded. My lord, I can here and now show and order judgment of the Supreme Court. Kindly go, do not go. One thing, another, my lord. This Order 22, Rule 10, while, my lord, it is empowering under the discretionary power of the trial court, while it is empowering the trial court to bring the lease pendants transfer or transferees into the picture. It
not a lease pendants transfer.
Yes, my lord. I'm
pre-litigation transfer.
Yes, my lord. Now, my lord, it is all this power, this rule also empower the trial court to bring the pre-suit, my lord, transfer and transferees. Because, my lord, real owner and substantial right has to be established.
Let us read Order 22.
In consonance with.
Let us read Order 22 Rule 10. together.
It is said, my lord, during the pendency.
Let us read Order 22 Rule 10 together. That will help all of us to understand the law.
Procedure in case
Yes.
procedure in case of assignment before final order in suit. Before final order. Procedural. In other cases of assignment, creation or devolution of any interest during the pendency of a suit.
What does the meaning?
During the pendency of the suit. But my lord, in consonance with the Order 1, Rule 10, proper implement of the party and to establish the substantial right and to avoid the multiplicity of the proceedings, my lord, this or impugned order is justified because it is not final at all. This order is not final at all, and the apex court, my lord, in a judgment, the judgment may differ, my lord, factually, because in this judgment which I am relying, it is, my lord, relating to, my lord, least pending suit. But the observation of the Supreme Court, my lord, in this, kindly see, my lord, page 125, my lord.
Page 125 or what?
In a
The
shorter-
Book of Nature.
Yes, my lord.
With the citation.
Citation by 2013, volume 5, Supreme
You have
Court.
got
case.
one copy before a division?
My lord, extremely sorry, my lord. Within a short time, I can.
Read the citation. What is the citation? 2013?
2013, volume 5, SCC 397.
Which paragraph?
My lord, paragraph I want to rely 54.
Read it out, please.
In 54, my lord, the rule order 10, order 22, rule 10 has been, my lord, stated here. A simple reading of the above provision would show that in case of assignment, creation, or devolution of any interest during the pendency of the suit may, by the leave of the court, be continued or against the person to or upon whom such interest has been has come or devolved. What has troubled us is whether, independent of Order 1, Rule 10 CPC, the prayer for addition made by the appellant could be considered in the light of the above provision, and if so, whether the appellant could be added as a party respondent to the suit. Our answer is in affirmative. It is true that the application which appellant made was under Order 1, Rule 10 of the CPC, but enabling provision of 22, Order 22, Rule 10 could always be invoked if the fact situation so demanded. I want to rely on this, my lord, observation that, my lord, to bring the substantial right of the parties, as it is not a final order, to, my lord, bring the proper implement of the necessary parties in consonance with the Order 1, Rule 10, my lord, this order is valid. And since it is a, my lord, discretionary power, this should not be generally interfered with, my lord. It is a procedural law.
Who are the applicants there? 1 and 2.
1 and 2.
Shekhar and Somnath.
Shekhar and Somnath.
Shekhar has now died.
Shekhar has now died.
Yes, we are allowing the appeal. In recorded submission.
Kindly.
In view of arguable questions of law and fact being involved, we admit the appeal and hear it on the grounds taken in the memorandum. Which of next para? Since the ambit of the appeal is brief, we take up the appeal itself for hearing. Upon hearing both sides. Which of next para? In a suit for partition, after the passing of a preliminary decree, two of the parties to the said suit, namely one Shekhar, within bracket since deceased, bracket closed, and one Somnath, took out an application under Order 22, Rule 10 of the Code of Civil Procedure, alleging that their mother, one of the parties to the suit, executed a deed of gift in the year 2011, that is prior to filing of the suit in 2013, thereby donating her entire share in favor of the said Shekhar and Somnath. Full of next para, by the impugned order, the same was allowed. Full of next para, learned counsel for the appellant argues that by allowing the said application, the learned trial judge has given a premium to the applicants, that is Shekhar and Somnath, despite them having not pleaded or brought on record the said gift deed throughout the pendency of the suit till the passing of the preliminary decree. Next para, as such, it is argued that there was no occasion for the learned trial judge to permit such gift deed to be brought on record and or, comma, on the basis of it, comma, to go against the grain of the defense taken in the suit and permit an application under Order 22 Rule 10 of the Code. For some next para, it is further argued that there was no occasion for allowing an application under Order 22 Rule 10 of the Code, comma, since the two applicants therein were already parties in the suit and their right, title, and shares have already been decided in respect of the property by way of the preliminary decree. For sub next para, learned counsel appearing for the respondents 1 series within bracket as substituted bracket closed and 2, comma, that is Shekhar within bracket through his heirs bracket closed and Somnath, comma, submits that the power vested under Order 22 Rule 10 of the Code of Civil Procedure on the court is discretionary and must be exercised for the ends of justice if the fact situation so demands. Full stop. In support of such submission, comma, learned counsel cites নামটা একটু দেখে করে দিও ওই নেট থেকে 2013 reported at 2013 5 SCC 397 where the Honorable Supreme Court held inter alia, comma, that in the facts of the case, comma, a lease pendants transferee was required to be added as party to the suit, comma, under the enabling provision of Order 22 Rule 10 of the Code, comma, even if the application for addition was filed under Order 1 Rule 10. Full sub next para. Learned counsel for the respondent numbers 1 and 2, 1 series and 2 next argues that the right of a party is required to be established, comma, particularly in the conspectus of a partition suit where the respective shares of the parties are required to be allotted. Full stop next para. Thirdly, it is argued that an order passed under Order 22 Rule 10 does not conclusively determine the title of the parties and as such there is no scope of interference by this court with the impugned order. So next para, certain facets of the matter and upon hearing learned counsel for the parties, comma, we opine as follows, colon, next para, certain facets of the matter cannot be lost sight of. Full stop next para. First, comma, in a partition suit, comma, by way of the preliminary decree, comma, the title as well as the respective shares of the parties are conclusively determines. Full stop. A preliminary decree is as conclusive as a final decree within the definition of Section 2 of the Code of Civil Procedure and has conclusive and binding effect on the parties. Full stop next para. By dint of introducing the existence of a purported gift deed which was executed prior to the execution of the suit, comma, by way of the application under Order 22 Rule 10 of the Code of Civil Procedure, comma, the applicants therein now seek to reverse stroke modify the preliminary decree, comma, which has already attained finality, comma, for all practical purposes. Full stop. In the absence of a challenge to the the preliminary decree, comma, such an introduction and or modification of the decree in the garb of an order under Order 22 Rule 10 is not permissible in law. Full stop next para. It is also important to note that Order 22 Rule 10 of the Code of Civil Procedure contemplates only the devolution of a right lease pendens, that is during pendency of the suit and not pre-suit passage of title. Full stop. In the present case, comma, the 2011 gift deed which was purportedly executed in favor of the applicants in the Order 22 Rule 10 application was executed even prior to the filing of the suit. Full stop. In view of the defendants stroke applicants having not pleaded about the said gift deed and or produced the deed throughout the pendency of the suit till the passing of the preliminary decree, comma, they are now precluded from relying on the same. Full stop. Next para. Since the preliminary decree has since attained finality in the absence of any challenge thereto, comma, the applicants in the Order 22 Rule 10 application could not have been permitted to reopen the same at this juncture on the strength of a purported pre-suit deed. Full stop. Next para. Thirdly, comma, the judgment cited by the respondent number 1 series and 2 is not apt in the context of the present case, since the Supreme Court was considering a lis pendens transfer therein, and the ambit of the consideration was whether, if an application for addition of parties filed under Order 1 Rule 10 of the Code of Civil Procedure, but in effect, the uh, paradigm of Order 22 Rule 10 is applicable, such application should be allowing by invoking the provisions of Order 22 Rule 10, which is an enabling provision. In such context only, the Honorable Supreme Court held in the affirmative. Next para. As such, the questions which have arisen for consideration in the present case did not fall for consideration or were decided by the Supreme Court, Honorable Supreme Court, in the said judgment. Thus, we do not find any precedentiary value of the said judgment insofar as the present case is concerned. Yes, you were saying, sir?
My lord, kindly record, my lord, regarding assessing the preliminary decree, we have challenged, filed an appeal, my lord, which is still pending, my lord. Kindly, my lord, record.
All along, please keep it with you. Why didn't you say so long when we were hearing you?
No, I have said, my lord, on the earlier occasion, my lord. But since my lord is recording this, my lord's observation, that's why, my lord. Earlier occasion, I prayed to take both the appeal, my lord, and to hear the same, my lord.
যেখানে বলেছি has attained finality in the absence of an appeal, ওই জায়গাগুলো একটু বোল্ড করে দিও, অ্যাপিল করেছে। নেক্সট প্যারা, ওখানটা আমি চেঞ্জ করব। নেক্সট প্যারা, since the respondent numbers 1 series and 2 submit that they have already preferred a challenge against the preliminary decree, the ground of existence of the gift deed can very well be canvassed there. However, unless such appeal is entertained and allowed, thereby modifying the preliminary decree, the respondent numbers 1 and 2 could not have been permitted by the learned trial judge at the final degree stage of the suit itself, to reopen or modify the preliminary decree by introduction of the gift deed in question. Next para. In view of the above, even otherwise, the application under Order 22 Rule 10 of the Code of Civil Procedure was superfluous, since the applicants therein were already parties to the suit. Next para, the only purpose of filing the said application was evidently to seek a validation of the deed of gift, which was suppressed all through the pendency of the suit till the filing of the preliminary decree, and thus the said application could not have been permitted, being in essence a malafide one, seeking to do something which could not be directly done, indirectly. In view of the above, FMAT number 373 of 2025 is allowed on contest against the respondent numbers 1 series and 2, and ex parte against the against the pro forma respondents, service upon the latter being dispensed with, since they are not affected by the present order. Next para. Accordingly, the impugned order bearing order number 105 dated June 28, 2024, passed by the learned civil judge, junior senior division, second court at Chinsura, district Hooghly, in title suit number 625 of 2013, is set aside without any order as to cost. Can which has been 1 and 2 have been allowed.
1 and 2 as well.
Can 3 of 2025 stands accordingly disposed of as well, no order as to cost. We'll modify those portions where you have said it has attained finality because you have not preferred an appeal. We'll say that you have preferred an appeal.
Kindly take the, my lord, appeal number, my lord. It would be better.
We'll record that you have preferred it. Thanks. Next.
Grateful.
Thank you. Grateful. You argued well. You tried to argue well. But anyway, let us see. Oh, all the best in the appeal.
Grateful.
Next. 7, yes. Key. What about it?
Lord,
Yes,
And
yes.
we come back at 2 o'clock. I am just will be reaching High Court. I'm there at NCLT. Can I come back at 2 o'clock? Please.
He's leading you.
Yes, he's my
Yes,
senior.
Malad.
He's leaving me, madam.
You're for the appellant.
Yes,
Yes,
absolutely.
Malad. For the appellate,
Very
Malad.
good. You're 2 o'clock.
Grateful, Malad. Grateful.
At a 2 p.m. at an evening. Next. Why X? Is it a sensitive matter?
Yes, my lord, the appeal arises out of an rejection of an application under Section 8 of the Hindu Minority and Guardianship Act. My lord, the application, the defect has been pointed out by that the appeal has not been valued. But it has been specifically stated that this is incapable of valuation arising out of. Therefore,
This,
my lord, only my lord.
this counts as a minor.
Yes.
Any interim application is there?
Interim application, my lord, for disposal of the appeal itself.
We'll admit the appeal and allow this application direct put in the.
My lord,
it has been refused.
It has been refused.
You are the?
I am the guardian mother.
You sought to transfer the property of the minor?
Not transfer, my lord, not to enter into a development agreement for preservation and protection as well as for the interest of the minor. The court, my lord,
no legal necessity.
No legal necessity because that has not been specifically described in the application itself. The court's observation is that I have not specifically.
But you have to specify. Court is correct, Mr. Mitra.
In such event, my lord, this will not prevent my lord to file press
No,
application.
you serve a notice and come back. We may dispose of the appeal itself by
whom I shall serve.
Oh.
Difficulty is, my lord.
Mr. Mitra, we come back and we'll take up this matter. If necessary, we'll dispose of it. Dispose it. We'll admit and dispose of right now by giving you this liberty. If otherwise there is nothing on merit, we'll just check up. If
so far as
prepared with the appeal itself, I mean, we'll just hear it.
Yes, entire application is based on my lord. Rejection is
yes, you are right. This is unilateral, so there is no scope of any imputing anybody. We'll come back and dispose of it. Mr. Mitra, should we go to the impute judgment directly then?
My lord,
Father,
kindly
father
look
is not.
into
Father is not there.
untimely death, my lord, leaving two minors and the wife. And they have a only land to the extent of 50% in respect of a 9 decimals, which they want to develop along with other co-sharer. My lord,
She has any other source of income, not
no
what?
other source of income. That is, my lord, practically has not been
Considered.
And my lord, kindly look into my application at paragraph 15. I have stated,
yes,
the court held that there are no material particulars because I have not yet entered. Without the leave, my lord, I cannot enter into an agreement with the developer.
No.
And my lord, only offer, my lord, that this should be
Court says there is no particular of the agreement or something.
agreement,
Let us see
nothing.
that portion only.
My lord, kindly last word, before last page.
So brother has no objection. He has 50% share.
He has 50%.
And you and your two minors have.
They are school-going children.
And you together have 50% share.
Together have 50% share.
They are school-going children.
They are school-going children. One is of 11, one is of 13. And my lord, the court has explained that this is.
We'll come to that portion. The third last page, if you please come to that, it is pertinent to mention, Mr. Mitra. Before that, the evidence that your brother-in-law has agreed.
That the petitioner gave a
Vivid
descriptions of the sequence of events through which they become the owner of the property. But she spends only a few lines to show the urgency and has failed to establish the legal necessity for developing the property for welfare of the child. The petitioner disclosed in her application that the development is necessary to protect and preserve minor shares therein, and also for the purpose of meeting the daily expenses and educational expenses of the minor children. Save and except disclosing these reasons, the petitioner
Hindu minority and
not record anything to substantiate the requirement of the Section 8 of the Act to show that the proposed development is unequivocally for the welfare of the children. The petitioner claimed that the proposed development is for the welfare of the minor children, including for purpose of meeting their daily expenses and educational expenses. But the petitioners, apart from adducing the school identity card, did not produce any other document to show the expenses of our minor children in any way. The petitioners anywhere whether the minors have any other immovable property in their names, save and except the fractional share of the scheduled property which they acquired either by inheritance or otherwise. It is also pertinent to mention here that the petitioner did not disclose the current market value of the property, including the possible enhancement in the valuation of the property after the proposed development. Moreover, the petitioner did not disclose specifically as to how the proposed development of the property will serve the welfare of the minor. The petitioner did not disclose the present educational and living expenses of the minor, and also did not divulge that whether the children have any other means to support. The petitioner further fails to disclose the fact specifically that will there be any alienation of interest of the minors in the property, or the ownership will continue to remain with the minor. The petitioners further did not disclose the name of the developer in her application. The petitioner has not included a single word in her application incorporating the terms and conditions of the proposed development with regard to.
Mr. Mitra, you can give a proposed scheme of what sort of agreement you want to enter into, or something like that.
Because
more
we
detail.
have not yet entered into agreement.
We understand fully that because the terms are not yet clear. But we can keep it the language of section 8 is you have to take permission for previous permission of the court to transfer. So not that court will monitor the scheme. And in any event, it is voidable at the instance of the minor. Have you stated in your application you have no income whatsoever? And the
Paragraph 18, I have stated, my lord, I have handed over those applications to your lordships. Kindly look into that. Is the apart from that, my lord, we have practically no other. Paragraph 16. That due to untimely death of Kartik Chandra Ges, it is not possible for the petitioners, that is heirs of Kartik, to use the scheduled property in proper manner so that minor shares of the said property can be protected and preserved. The other co-sharers having 50% ownership in that is Lakhon Chandra, has been cooperating with the heirs of the deceased brother. But it is not enough to protect the schedule mentions both property, as both son and daughter of Kartik Chandra, aged about 13 years and 11 years respectively, and they are studying in school. It is very difficult for the minor wife, mother, wife of Kartik.
Yes, Mr. Mithu, we are allowing it. No further details are necessary. In view of arguable questions being involved, we admit the appeal on the grounds taken in the memorandum of appeal. Since there is no scope of service of notice, as the litigation is not adversarial in view of the nature of the same, having arisen out of refusal of an application under Section 8 of the Hindu Minority and Guardianship Act 1956, seeking leave to transfer the property of minors, we take up the appeal itself for hearing. Next para. By the impugned order, the learned trial judge rejected an application filed by the appellant. Application was by all of you. You as next
Application was all by all of us.
By the present appellants, whereby the appellant number 1 mother sought to transfer.
Sought to enter into an agreement.
Sought to only enter into an agreement.
Yes.
But transfer again, you have to take leave then. For agreement, you do not require any. No. Grant registered develop power of attorney. Acha, development agreement. Very well. Acha. Sought to enter into a development agreement in respect of the property of which the appellant number 1 mother and her 2 minor children, being appellant numbers 2 and 3, are the owners, are the co-owners. For the next para, the primary premise of rejection of the said application was that the details and particulars of the proposed agreement and or transfer have not been furnished before the learned trial judge. For the next para, the learned trial judge observed that although there is no straitjacket formula to determine the criterion of legal necessity, clause, of a minor, and it has to be interpreted and determined taking into consideration the factual aspect of each and every case independently, in the present case, the appellant number 1 has spent only a few lines to show the urgency and has failed to establish legal necessity for developing the property for the welfare of the children. For next para, the learned trial judge also observed that the daily family expenses and educational expenses of the minor children were also not disclosed, but only the school identity cards of the children were produced to show the expenses of the minor. Full stop. Next para, the learned trial judge further observed that the current market value of the property, including the possible enhancement in the valuation of the property, was also not disclosed before the learned trial judge by the present appellants, and as such, the learned trial judge was apprehensive in granting blanket permission to the petitioner to enter into any development agreement representing the minors with regard to their respective share, without first settling the terms and conditions specifically as far as practicable, which is, according to the learned trial judge, completely lacking in the present case. Full stop. Para. The brief facts of the case is that one Kartik Chandra Ghosh, along with his brother Lakshman Chandra Ghosh, were co-owners in equal shares of the subject property. Full stop. On the demise of the said Kartik, his share, that is 50% of the property, devolved on the present appellants, being respectively the widow and the minor children of the said Kartik. Full stop. Next para. As averred in the application under section 8 of the 1956 Act, as well as before this court, the appellant number 1 is unemployed and a housewife, whereas appellant numbers 2 and 3, her children, are school going, respectively aged about 13 and 11 years. Full stop. Next para. Thus, it is clear from the averments in the application itself that the appellants have no source of income whatsoever. Full stop. Even the learned trial judge did not cast any doubt on that aspect of the matter. Full stop. Next para. Thus, the over-reliance of the learned trial judge on lack of production of the educational and other expenses of the children is an irrelevant yardstick for the present consideration. Full stop. It cannot be denied that two school-going children of 11 and 13 years require educational expenses and other living expenses, irrespective of the quantum of the same. Full stop. In the context of the averment that the appellants have no income whatsoever, whatever may be such expenses, it is an absolute legal necessity for the appellants to enter into some sort of an arrangement with regard to transfer of the property for the purpose of having even the means to run their daily livelihood and the education of the children and their upbringing. Full stop. Next para. The learned trial judge proceeded on the further premise that no details of the proposed agreement or copy of the development agreement was produced. Full stop. It was also observed by the learned trial judge that the learned judge was apprehensive about the nature of the agreement and the details thereof, which is proposed to be entered into. Full stop. However, section 8 of the 1956 Act, unlike section 92 of the Code of Civil Procedure or other similar provisions in respect of trust, do not impose on the court a duty to monitor the transactions entered into on behalf of the minor by the natural guardian. Full stop. Section 8 within bracket 1 provides, Mr. Mitra, please take your seat, provides that the natural guardian of a Hindu minor has power, subject to the provisions of the said section, to do all acts which are necessary or reasonable and proper for the benefit of the minor or for the realization, protection or benefit of the minor apostrophe estate. Semicolon. However, the guardian can in no case bind the minor by a personal covenant. Next para. Subsection 2 of section 8 provides that the natural guardian shall not, double inverted without the previous permission of the court, double inverted close, mortgage or charge, or transfer by sale, gift, exchange or otherwise, comma, any part of the immovable property of the minor, or lease any part of such property for a term exceeding 5 years, or for a term extending more than 1 year beyond the period on which the minor will attain majority. Full stop. Next para. The safeguard inbuilt in section 8 is stipulated in subsection 3 thereof, which provides that any disposal of immovable property by a natural guardian, comma, in contravention of subsections 1 or 2 is voidable at the instance of the minor or any person claiming under him. Full stop. Next para. Subsection 4 of section 8, comma, on the other hand, comma, stipulates that no court shall grant permission to the natural guardian to do any of the acts mentioned in subsection 2 except in case of necessity or for an evident advantage to the minor. Full stop. Next para. Thus, comma, whereas under subsection 1 of section 8, comma, the power to transfer the minor's property for the benefit of the minor or for realization, comma, protection or benefit of the minor apostrophe estate vests by default in the natural guardian, comma, and the minor has a power to repudiate the same in case the provisions of subsections 1 and 2 are violated, comma, the scope of inquiry by the court is enumerated in subsection 4, comma, which is restricted to ascertain whether a case of necessity or an evident advantage to the minor is made out. Full stop. Next para. In the present case, comma, however, comma, the learned trial judge proceeded on an overzealous approach by seeking virtually to monitor the entire transaction by seeking the particulars of the proposed development agreement, comma, without appreciating that the scope of the court is limited only to grant permission and to ascertain for such purpose whether there is any necessity or evident advantage of the minor. Full stop. Next para. Even subsection 2 does not contemplate a monitoring by the court, but merely provides that the natural guardian shall not, comma, without the double inverted mode, the previous double inverted clause permission of the court, transfer the property as contemplated therein. Full stop. Next para. Hence, comma, in the present case, comma, the charter of the court was limited to ascertain legal necessity and evident advantage of the minor. For some next para, the very fact that the appellants are without any source of income on the demise of the sole bread earner, late Kartik Chandra Ghosh, comma, the husband of the appellant number 1 and the father of the appellant numbers 2 and 3, comma, is a sufficient indicator that there is immediate and urgent legal necessity and an evident advantage to the minor if a development agreement is entered into in respect of the property in question, comma, for the purpose of fetching a quantum of money which would inure to the benefit of the minors and their education as well. Full stop. Even otherwise, comma, unless a prior permission, comma, as contemplated in subsection 2 of section 8 is granted, comma, no development agreement can be entered into by the appellants at all. Full stop. Thus, comma, there was no scope of producing any development agreement before the court, comma, since the same would tantamount to the proverbial, within double inverted, putting the cart before the horse, double inverted close, full stop. Next para. In such view of the matter, comma, comma, on a careful perusal of the application under section 8 of the Hindu Minority and Guardianship Act 1956, comma, a copy of which has been handed over in court to us, comma, we are of the opinion that the learned trial judge erred in law in proceeding on an erroneous legal basis to dismiss the application of the appellants. Appellant number 1. Full stop. Next para. Accordingly, FMAT 412 of 2025 is allowed, comma, thereby setting aside the impugned order dated judgment and order dated impugned judgment and order, comma, bearing order number 16 dated July 25, 2025, passed by the learned additional district judge, comma, first court at Howrah, comma, district Howrah, in miscellaneous case number 243 of 2023, and allowing the said miscellaneous case under section 8 of the 1956 Act. Full stop. The appellant number 1 is hereby permitted to enter into a development agreement as prayed for in the application with third parties, with the rider that the monetary gain extracted from such development agreement by the appellant number 1 shall be expended primarily for the welfare and benefit of the two minors, being the appellant numbers 2 and 3, and a corpus shall be created from the said income to cater to a corpus will be created from the said income in the name of the appellant numbers 2 and 3 for the to cater to the future needs of the appellant numbers 2 and 3. No address to cause urgency.
Grateful.
You will also create a corpus,
Yes,
some funds of some sort,
that will
invest
be
somewhere. Obviously, you're the mother, you will do that, but we put in that rider because otherwise, yes. Can such and such is disposed of in the light of the above observations, no address to cause.
ওই application দুটো দিয়ে দিন।
Yes, we'll require a copy of that.
Yes, my lord, I am giving one copy. I am giving.
Yes.
একটু দেখে দিন।
Yes, Mr. Chaudhary.
I appear for the respondent lordship before my learned senior friend.
You're smiling means you are asking for time.
Only one day, my lord. I could
What
not.
do you mean by only?
My lord, actually, it is served.
It is 24 hours. Yesterday was short for time.
Your lordship, we were not on caveat, my lord. On Monday, when the matter was taken up, we asked for a copy. They have supplied.
Chaudhary is opposing.
Only I could not. This is my incompetency, my lord. I could not prepare myself in one day.
Incompetence.
No, no.
Only one day. If
After that, Mr. Chaudhary cannot oppose.
I never open. I survive.
Don't say never. Ever. Don't ever say never. You don't know when you have to oppose.
No, only something I feel is malafide I'll oppose. Otherwise, never oppose.
Never is then qualified.
Yes.
Your perception of the malafide.
Yes. My perception of malafide.
It's always our perception.
Yeah, keeps it tomorrow. I will be doing.
Tomorrow, very well. Fair enough.
Only one day, my lord.
May I also, my lord,
yes.
There's a proposed, my lord, added defendant. I've also filed, my lord, the devolution of order 22 addition petition. My lord, may I also serve him?
Serve a copy, then we'll take it up on Monday. Because she'll require instruction on that.
Yes,
also.
yes, I'll do that.
Yes.
On the prayer of the respondent, the matter is adjourned till November 17, 2025. So in the meantime, any unserved application, any application filed in connection with the appeal, comma, if you have already served.
My lord, on the proposed added defendants.
Another application you have served?
No, no.
Filed.
I'm saying, may I serve this application on the proposed added defendants?
Oh, achha,
because I filed two applications, one for injunction, one for, my lord, devolution of interest, addition of party.
How many are there? Then you
There are
cannot do it within
3.
Within Monday, you cannot do that. Then we'll
I'll serve today itself. They are all in Calcutta. They have knowledge of the suit. It's a suit for specific performance. Pending the suit, they've transferred. Defendant has transferred.
In the meantime, the appellant shall serve copies of Can 1 of 2025 on the proposed added respondents and file an affidavit of service to that effect on the returnable date.
Only then can I ask for an injunction. Otherwise, I
All
cannot.
right, because they are the persons. Affidavit of service filed today be kept on record.
Grateful.
You have got a copy of the memo also, Ms. Oja?
Yes, my lord, I have got.
So you come prepared in the matter.
Yes, my lord.
We'll take it up on 17th.
Great.
Thank you, sir.
Yes.
Item number 10, my lord, I am appealing for the interveners led by Mr. Aniruddha Chatterjee.
Yes. Mr. Chatterjee, Mr. Ranojit Chatterjee, you are appealing for the appellant?
Yes.
Right.
By the impugned judgment, my lord,
The ad interim order passed by my Lord's Court has been vacated. It's just coming from City Court, so yeah. I'll permit.
Our order has been vacated by whom?
Yes.
Trial court.
Yes, but there's a rider in my Lord's order.
Say that. You're putting it dramatically. Yes, Mr. Chatterjee.
My Lord's order is at page 62.
Yes.
Kindly comes to that.
So vacated under order 13 rule 4 or?
Yes.
Madam, led by Mr. Chatterjee.
Yes.
This is regarding that parking in Bara Bazar area. My client is a widow.
Who is Mr. Chatterjee? Who are your clients,
We
Mr.
are continuing with the collection now. After my learned senior friend's client Lord vacated it because he did not comply with my Lord's order.
Respondent number 1 is in charge of this this thing.
That's the
You
society.
allocate.
That's the
So it has been
society.
taken from them and given to you.
Given to me, and I'm continuing, my lord, and I've also obtained an order of injunction. What there's one lacuna here on my part, said I haven't filed an application for addition of party yet. I have filed one in the trial court.
In this appeal.
In this appeal. I have filed one.
No,
in
you
the
are a
trial
party.
court.
You are
No,
not the.
no.
I was heard by.
No. Who are the respondent numbers 2 to 6?
They are the.
Oh, they are the authorities.
Yes. But
Lord,
their case is that.
I was praying if I can file an application and come back so that your lordship may formally add me, or what, because I am a necessary party and I'll have to show your lordship that there is an injunction in my favor.
How soon can you file it? File it by tomorrow if you must be ready.
Yeah,
by-
after
Well, my case is that, well, since he has been appointed, well, after this order is vacated, but he cannot be a necessary party here because if I fail, he continues. If I succeed, he goes.
affectation.
No, not that. I mean, he was not a party in the suit.
No.
So he is claiming.
His case is that after the order was vacated, he has been appointed to in my
Yes,
place.
Mr. Chatterjee, your client's interest is represented through the.
My
present-
success in this
I have to show your lordship below that there is an injunction in my favor, and there is
I'm
direct
not a party there. I'm not a.
No,
There is a
you are
direct
you claim advantage of their vacating of their injunction application. So
Milord.
you are a beneficiary of an interim order or lack of it.
Milord, now a subsequent purchaser. Let's put it that way, very, very clear. See, even
Yes, their
order
interest should be direct. You
Rule 10 will also come in.
no, not exactly.
I'm giving you a broad.
Not that because
Not
you are
that-
claiming two Barabas free parking cooperative society.
Definitely.
So you are a beneficiary.
I have an independent.
No, you are claiming through them. Your interest is represented by Barabazar fee parking because Barabazar, their claim is against Barabazar. You are not directly a necessary party here.
Milord, why-
You are affected incidentally. You are a collateral damage. If you,
And here, Milord,
but that does not make you a necessary party here.
Milord, it make-
On that square, I have a judgment.
You are taking advantage of some order passed in the during pendency of the suit.
Yes, and
And
that's
your interest is represented by Barabazar fee parking. You cannot have an independent right. You cannot have an independent right. Your right is through Barabazar free parking.
My appointment was in January, not Milord during the pendency of the suit at all. Which Milord we that's why we filed.
So you're not yet a party in the suit also. You have
That's why Milord we filed a review application with respect to your lordship's order as well.
you
I filed a review application.
you have filed.
Yes,
I have no service, no knowledge,
review
nothing.
review,
And-
Milord, till it's admitted.
No, you have also sought to implicate yourself in the suit.
Yes, Milord.
You have made an application on order
In this suit,
order 1 routine.
after the application was moved in vacation, they have come up with that application.
That's when I took it down.
No, they say that order their right was created prior to the filing.
No, it was not disclosed when my lords heard the matter earlier.
Mr. Chatterjee,
He's not there. That's exactly what the problem
Mr.
is.
Chatterjee, since already it has been given to
Barabazar
them,
was there.
it has been given to them. So one week's adjournment won't affect you. Let them come up with that application. and deal
I
with
was placing a Supreme Court judgment on this proposition.
that. No, but unless they file an application under order 20 rule 10, we
So
can.
they sought to intervene in the vacation, and I was opposing that. On that score, my lord, that
Let them file a 2210 application. We'll decide that on merit. But you have to do it during the course of this week.
Yes,
By
sir.
Friday, you have to give a copy to Mr. Chatterjee so that you can take it up on Monday.
Absolutely.
my
We'll
lord
take
will
it
also
on
note the conduct. They filed lodged caveat. They didn't accept service. It has been recorded in the
That's
order of the division.
not me.
Anyway, they are the
That's
authority.
the other one.
Their fairness of action, my lord.
No, I'm surprised by that. If you've lodged caveat, why won't you accept?
Mr. Chatterjee, Learned Senior Counsel, Mr. Aniruddha Chatterjee, Learned Senior Counsel, having instruction to appear for the intervener, seeks some time to file an application for being impleted in the appeal, as according to Learned Senior Counsel, the vested rights of his client would be directly affected by the outcome of the present appeal. Full stop. Such contention is disputed by learned counsel appearing for the appellant. Full stop. Next para, be that as it may, comma, unless an application under Order 22 Rule, unless an application for addition of party is filed and is taken on board, comma, it would be premature to adjudicate on the outcome of the same. Full stop. For the ends of justice, comma, leave is granted to the proposed interveners to file a proper application under proper application for addition of party in connection with the appeal and hand over an advance copy of the same during the course of this week to the learned advocate for the appellant as well as to the learned advocate for the respondent number 1. Full stop. The matter shall be listed on November 18, 2025 along with the proposed application for addition if and when filed. Full stop. The applicants in the addition of party application shall mention the said application for inclusion in the list along with the appeal on November 17, 2025 or earlier as and when the same is filed. Whenever you file it, mention it immediately. You won't get time before.
Can it be listed on 19th?
Yes, yes, definitely. 18 na kore 19th ota kore. 19th.
Grateful.
19th.
May I take back that?
Yes, order one, এটা copy টা ফেরত দিন. Annex all of these two, whatever.
Grateful.
Thank
you.
I'm for the appellant.
Yes, Mr. Ghosh.
Well, the appellant before your lawsuit is the husband. Not he filed a suit of divorce on the ground of cruelty and desertion. No matter suit was decreed in my favor. No matter while decreeing the suit, learned trial court at his own motion on suo motu.
Your suit was decreed?
Yes.
What have you challenged?
Granted a permanent alimony without any application, even without any. If you also can see the order in portion. That is
without any application also.
Without any, even oral application also. That is recorded in the order. But kindly come to page 33 of the impugned order.
You got a degree on the ground of cruelty?
On the ground of cruelty and desertion.
And desertion.
Yes. So, may I read this?
Yes, yes, we see that. However, during prolonged argument, separately it was not submitted for any permanent alimony.
The question is simply that whether the court can pass an order of alimony without any application.
Apparently cannot.
I have the.
So have you served copies on the?
No, this is order 41.
Oh, we'll dispose of both together. What are you citing?
The act.
For what
section,
purpose?
Section 25, whether the application is required or not. Specifically,
if you cite the section, we'll look into it. Yes. We may find out some lacuna also in your case.
Page 143.
This is required to be cited, Mr.
But I just,
without any prayer, even court cannot grant quantum more than one prays for.
Yes.
Less than court can, but more than what one prays for.
Well, page 143.
Court even cannot grant that. So what is the question of without any application? Anyway, by the impugned order, comma, a divorce decree was granted at the behest of the appellant husband in favor of the appellant. Full stop. However, comma, while doing so, comma, the learned trial judge suo motu passed an order of permanent alimony despite recording that there was no prayer for such alimony and or application filed by the respondent wife. Full stop. Next para. An arguable question has been raised as to whether the learned trial judge had the power to do so in the absence of any prayer, comma, either by way of an application or verbally, comma, on the part of the respondent wife for such permanent alimony. Full stop. Accordingly, the appeal is admitted and shall be heard on the above question and the other grounds taken in the memorandum of appeal. The appellant shall serve copies of the.
I have an application for stay.
Shall serve copies of the memorandum of appeal as well as the application on the respondent number 1. Number 2 is the alleged respondent number 1, indicating that the appeal as well as the application shall be taken up for hearing on December 8, 2025, when the matter shall be listed under the heading application with the understanding that the appeal shall also be taken up for hearing. Full stop. For such purpose, the notice to be served by the appellant shall be deemed to be notice of the appeal as well. Full stop. Formal preparation of paper books and calling for the records is dispensed with. Full stop. Next para. There shall be stay of operation of the portion of the impugned decree whereby permanent alimony has been granted in favor of the respondent at the rate of now.
8,000.
A permanent alimony of rupees 8,000 per month has been granted to the respondent wife till disposal of the application. First of the appellant shall file an affidavit of service on the returnable date. যেখানে বললাম না মেঘনাদ ওই যে আসতে না যে serve copies of the application and the memorandum of appeal as well as a server copy of this order so that they know that we are taking up the appeal.
My lord, only one more prayer, my lord, there is a correction required because it was initially filed as a first appeal. Thereafter, pursuant to your lordship's order, it was converted from first appeal to first miscellaneous.
What correction is required?
But the application was filed in terms of the first appeal. So the number of
leave is granted to the learned advocate on record for the appellant to correct the cause title of the application, connected application depicting the FMA, the correct number of the appeal.
Much of
during the course of the day. Do it. Thank you.
Number লিখবি
a very short question involved, madam.
What is the matter, Mr. Datta?
This is a matter, madam, ex parte identity model of injunction passed.
Passed, yes.
Madam, with three tests is to be complied with. But unreasoned order, no recording anything, madam, ex parte identity model of injunction passed. Order 13 rule 3 the proviso that has
the partition suit.
They have alleged partition suit, but I am the defendant number 1 and 2. Against me, no partition. Injunction against me. Other are pro forma defendants. Asking for I have enclosed
partition suit.
I have enclosed the plain. Partition suit in respect of against the pro forma defendants, not against me. But I am the main defendant. I have the owner of the property.
Yes, must have been some declaration is also sought regarding your title. No. Let us see the plaint.
But I have enclosed, my lord. Firstly, my lord, you kindly have a look into the impugned order.
We have seen the impugned order already. That's why you are wanting to see.
Kindly consider the plaint.
Right title interest, usual prayer.
Usual prayer. I have enclosed, my lord, page.
If any documents be produced by defendants in respect of the same are all illegal. Vague prayer.
Prior to that, I have filed a suit against them. An injunction was passed.
You filed on the strength of
my
deed.
My deed, my record, my deed.
No, you record or deed?
Deed and record.
Your title deed, you are exclusive owner of the property?
Yes. I'm 24 decimal of land, I'm exclusive owner.
But we cannot stay the operation of this order.
Your lordship knows it very well, the golden principles, my lord.
We know it very well, but Mr. Datta will admit the appeal definitely. But we cannot stay the operation of the injunction order at this stage. That will be final hearing of the appeal.
And my lord,
serve quickly and come back. We'll put it on.
I must have, my lord. Your lordship, my lord, recently.
We'll take up the appeal application together.
My lord, recently 24th Supreme Court, my lord, already held.
What?
My regarding short judgment, my lord, your lordship kindly.
Is a judgment required for this?
No.
We are not passing any ad interim order.
All right, my lord, I am serving, my lord.
The present challenge has been preferred against an ad interim status quo order granted in favor of the plaintiff respondent number 1, Pushap Learned Counsel for the appellant argues that apart from the order being unreasoned, no specific declaration challenging the valid title deed in favor of the appellants, on the strength of which a previous suit has been filed and an injunction obtained by the appellants, has been paid for in the suit. Full stop. Next para, it is further submitted that the golden tests of grant of ad interim injunction have not been complied with in the impugned order. Full stop. Next para, since the above arguable questions have been raised in the appeal, the same is admitted and shall be heard on the above grounds as well as the other grounds taken in the memorandum of appeal. Full stop. However, comma, we are not granting ad interim order of stay at this stage, comma, since it will tantamount to allowing the appeal before hearing the other side, comma, since by the impugned order, comma, status quo has been granted in respect of the property. Full stop. Be that as it may, comma, the appeal along with the application shall be heard together on the returnable date. Full stop. The appellants shall serve copies of the application and the memorandum of appeal on the plaintiff respondent number 1, indicating that the appeal and the application shall be taken up for hearing together on November 25, 2025, when the matter shall be listed under the heading application. Full stop. Along with the memorandum of appeal and the application, comma, a server copy of this order shall also be served by the appellants on the plaintiff respondent number 1. Full stop. Service of the appeal and the service of notice of the appeal and the application on the pro forma respondent numbers 2 to 14 is dispensed with, since no relief has been sought for against them. Push a formal filing of paper books and calling for the records are dispensed with. Full stop. Appear on 25th, the appellant shall file an affidavit of service to that effect on the returnability. He will file a server copy of the order, application, appeal.
Deep apology, Your Lordship.
Thank you, sir.
Both of Lordship there.
Yes.
My lord,
Yes, Mr. Gupta.
I am for the petitioner, my lord.
Sub notice on the other side.
My lord, I have sir. My lord, this is only a direction upon the learned
expeditors.
Learned tribunal for expeditors disposal, my lord. What has happened, my lord? An order was challenged. An order passed by the learned Thika controller has been challenged, my lord, before the learned tribunal, my lord. My lord, there is some checkered history in this, my lord. I am not going through that, my lord. That was continuing. In the meantime, my lord, many persons have died, my lord. Substitution has been done, my lord. On 27/11/2020, my lord, the matter was dismissed for default, my lord. My lord, that was within the period, my lord.
27/11/2020.
2020. My lord, an application for restoration has been filed. My
That
lord,
is still pending.
it is pending, my lord. 7/5/2025. Your lordship, kindly see the order passed by the last order, my lord, passed by the learned tribunal, my lord. 7/5/2020. Yes, my lord. 7/5/2020.
Yes.
My lord, this is affidavit of service, my lord. My lord, 7/5, my lord, the learned tribunal directed.
MA number. What
Yes,
are
my lord,
why
that is
two
the
MA numbers?
applicant.
One for condonation and another restoration.
My lord, yes, my lord. On a condonation.
MA number 482 and 483, one for condonation and one for restoration.
That's
You filed it after 5 years.
My lord, your lordship, there is some communication gap during the pandemic period, my lord. That was
Maybe we are not on that, but Mr. Gupta, since you have filed the application only in May 2025,
actually, my lord, there
what
is
the scope of directing expeditious hearing?
My lord, I understand, my lord, your lordship, can I consider during that period, my lord? Only consider whether the learned
Application has not been rejected. These have been
my lord, not rejected, my lord.
fixed on 11th of February. What is the
My lord,
error in this order?
7/5/2025, my lord. It is, let it be hard on that date, my lord.
The innocuous prayer in the present application is that the application for restoration and application for condonation of delay in filing the same, bearing MA numbers 482 of 2025 and 483 of 2025, filed before the learned first bench West Bengal Land Reforms and Tenancy Tribunal in connection with OA 2628 of 2008, bracket LRTT, bracket closed, be disposed of expeditiously. For sub next para, although the applications have been filed only in May 2025, comma, and there would otherwise be no scope of any direction for expeditious hearing, comma, we find that the next date has been fixed has been fixed on February 11, 2026. That is about 9 months after the filing of the applications, which according to us is inordinately long. Full stop. Be that as it may, comma, since the respondents do not appear despite service, comma, the affidavit of service is kept on record and further service on the respondents is dispensed with, comma, particularly since the nature of the order proposed to be passed is innocuous. Full stop. WPLRT 182 of 2025 is accordingly disposed of by directing the learned, by requesting the learned first bench, comma, West Bengal Land Reforms and Tenancy Tribunal to positively dispose of the two applications, comma, respectively for restoration and condonation of delay, bearing MA numbers 482 of 2025 and 483 of 2025 filed by the petitioner in connection with OA 2628 of 2008 within bracket LRTT as expeditiously as possible, comma, positively by the end of February 2026, comma, by taking up the same for hearing on the next returnable date, that is February 11, 2026. Taken up for hearing on 11th February, disposal by end of February.
I'm grateful, my lord.
Orders to cause urgent settlement.
I'm grateful, my lord.
Thank you, sir.
Lord, I am for the appellant.
Can one is section 5?
Yes, your lordship, and there is a 15 days delay.
Served or
No, my lord,
first
it's for
time?
the first time.
Served both applications?
Great.
The how many of them? Many. The
Two
appellant shall
applications.
serve copies of Can 1 of 2025 and Can 2 of 2025 on the respondents, indicating that the applications shall be listed for hearing next on November 25, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Great. Just one thing, your lordship, if I may please. The cause list shows that there is no application for condonation of delay, but the condonation of delay application is
What is
already
the
been
number?
filed.
Can number?
Can 1, I presume, your lordship.
Can 1 is appearing in the list.
Yes, but my lord, there is a note that saying it's
No,
defective.
defective out of time, that is, they follow the stamp reporter's report.
Grateful.
Unless that is allowed, that will continue.
Grateful, your lordship. No.
This defect is there. Actually, it is out of time.
Yes, yes.
So therefore,
that
it is-
defect is there, your lordship. Houmujit Mujumdar, JIT.
For the appellant petitioner, my lord,
Yes.
in this matter, my lord, so for my lord, application number 1, my lord, I have served this stay application as well as injunction application.
Condonation?
No, my lord, this is a stay application.
Achha, 1.
Injunction application. Partition shoot, my lord.
Achha.
Preliminary against preliminary.
There was a direction for service or of your own?
Yes.
Achha. So they have received?
My lord, second application, my lord, I have filed afterward. That is why, my lord, it was not served.
What is the second application?
Second application, my lord, it is for additional evidence, my lord. Because London trial court has, my lord.
Second application will direct it to appear along with the appeal and will direct you to serve afresh. That has not been served.
Served, my lord.
Second application you have served.
I have not served.
Will direct you to serve. No difficulty. This is against a preliminary degree.
Yes, my lord, preliminary.
Preliminary degree. So usual order.
Usual order and my lord,
Continue.
injunction
No
I have prayed, my lord. Injunction I have prayed, my lord, because some portion of the, my lord, paragraph 6 and 7, my lord, I have indicated. Page 19 and 20 of my application, my lord. These three.
Why didn't you pray before the trial court? The final degree proceeding is going on.
My lord, after passing the degree.
No, final degree proceeding is still going on.
My lord,
Anyway, did you? There was no refusal of an injunction in the trial court.
No. Yes, my lord.
The present appeal has been preferred against a preliminary decree of partition. For since questions of both fact and law are involved, we find that there is sufficient prima facie case made out. For also, from the averments in the application, we are of the opinion that the balance of convenience and inconvenience is in favor of grant of injunction as prayed for. For also, the irreparable, there is apprehension of the appellant suffering irreparable injury in the event injunction is refused and the appeal may be rendered infructuous. Full stop. Accordingly, the respondent, your injunction period is only against one.
Yes, my lord, against one.
What about the others? They are also necessary parties.
Appeared before the trial court, that is a service was dispensed with upon them before this.
So next para, the affidavit of service filed today be kept on record. It transpires that the only contesting defendant
is respondent
number 1, only contesting defendant, that is defendant stroke respondent number 1 has been properly served. A copy of the application. First up, learned counsel appearing for the appellant hands over a copy of an order dated September 18, 2025, passed in connection with the appeal by a coordinate bench, whereby the appellant was directed to serve only on the defendant stroke respondent number 1. For next para, in any event, since no effective order has been sought against the other respondents and the suit proceeded ex parte against respondent numbers
2 to 67.
67.
60, yes, my lord.
To respondent 2 to 67, we dispensed with formal service of the application as well as the notice of appeal on the said respondents. Full stop. Next para. The copy of the order dated September 18, 2025 is also kept on record. Full stop. The respondent number 1 and or his men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, and or creating any third-party interest in respect of the suit property till disposal of the appeal. Full stop. Next para. The learned trial judge shall continue with the final degree proceedings but shall not draw up any final degree without the prior leave of this court also during pendency of the appeal. Full stop. Next para. The appellant shall put in postal costs and other requisites for service of notice of the appeal on the respondent number 1 within a week from date. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. Which of the trial court shall be entitled to maintain a skeletal record for the purpose of continuing with the final degree proceedings. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for hearing as and when mention the appeal for inclusion as and when the same is ready for hearing. Thank you.
Service of CAN number 2, my lord. Service of CAN number 2. Well, service of CAN number 2, my lord.
Yes. CAN 2 of 2025 shall be served by the appellant on the respondent number 1, indicating that the same shall be listed along with the appeal, and an affidavit of service shall be filed when the application is next taken up for hearing. First of next para. Affidavits, if any, in respect of the same shall be exchanged in the meantime. The entire property is a water body. You're seeking partition of that?
No, no, no.
There are lands also.
Lands.
Scheduler to give bank frank to give. Yes.
So 60 minute I appear for the appellant milord.
Yes.
Plus appearing for the first time milord, decree impugned is a decree for dismissal of a suit for divorce. I am the husband milord. Kindly
So very usual orders, yes.
I will bear the special messenger cost milord and informal paper books milord.
Let us check up the defect if any. Certified copy of the impugned degree you have not filed.
Milord, I shall do so milord. Filed from the judgment milord. I will also put in the decree milord.
How soon?
Milord, within a week.
On the prayer of learned counsel for the appellant, leave is granted to the appellant to put in the certified copy of the impugned degree within a fortnight. We are giving a fortnight. Try to do it within a week. Within a fortnight from date. Full stop. In default, the matter be placed in the list under the heading Lauzima. Full stop. Next para. The appeal arises out of the dismissal of a suit for divorce filed by the appellant husband. Full stop. In view of the implicit urgency involved in a matrimonial matter, CAN 1 of 2023 is allowed, thereby directing the trial court records to be brought by special messenger at the cost of the appellant, to be deposited within a week from date. Post of the appellant shall also put in due requisites and postal costs for service of notice of the appeal on the respondent within a week from date. Post of the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Post of liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing.
Grateful.
কোথাও একটা no orders to cost করে দেবেন ওই can such and such is allowed without any orders to cost. 17
years. For the appellant plot. It's
Section
challenging
5.
the preliminary decree. Yes, section 5, 9 days delays is there.
But you have to serve.
Yes, Lord, I have to serve. Not only Lord, the defect, Lord, if there be any Lord, I can cure it Lord, by this.
Why did you check up?
Lord, yes, Lord, my junior Lord.
Your junior is also sufficiently capable of checking up a defect.
Yes, Lord.
8 days delay it's stated and not informed as preliminary degree has not been filed with the.
Yes, Lord, the preliminary decree, my information in the instruction is that not yet drawn up.
Leave is granted to the appellant to file the certified copy of the preliminary decree as and when the same is available with the appellant. Full stop. Next para. The appellant shall serve copies of Can 1 of 2025 and Can 2 of 2025 on the plaintiff's respondent numbers 1 and 2, indicating that the applications shall be listed for hearing in the monthly list of December 2025 when an affidavit of service to that effect shall be filed. Service of notice. You have not claimed any relief against the rest of the.
Sir, it's partition suit.
But
preliminary decree.
Oh.
That's why, my lord, may I serve to all?
তাহলে শুধু যেটা সার্ভিসটা 1 and 2 এর উপর বললাম ওটা অন দি রেসপন্ডেন্টস, বাকিটা যা আছে this much please. Evidence service on the next day.
My lord, in this matter, Miss Devolonial ID is appearing for is Deblina Riley.
Deblina Ray or Lahiri?
She is arguing at.
She's not Lahiri, she's Ray.
Lahiri.
Lahiri, yes.
Yes.
He's arguing somewhere. You are there. You are there.
I am not engaged in this matter, my lord.
So where are you praying for time?
Kindly make it short pass over.
Yes, she has been present on the previous date.
Yes.
We remember.
Yes.
So what do you do? Pass it over or make it not today?
Except not today, then. Lordship may take it up at 2 o'clock. If it is
2 o'clock, another matter will be taken up probably. After matter this 2 o'clock. And the matter after that matter, then inform her that 2 o'clock we have fixed a matter. After that, we'll take up this matter.
Mal.
You also come prepared. Pass over.
Great.
2 o'clock, প্রথম আগের ম্যাটারটার পরে এটা ডাক।
On 19, I appear for the appellant mallet.
Yes.
Wife is the appellant before your lordship mallet. By the order impugned mallet, the application for permanent alimony has been rejected mallet. Although mallet, during the pendency of the suit mallet, there was an alimony order of rupees 5,000 mallet. Subsequently, mallet, but the alimony has been rejected mallet. Mallet will kindly take the order mallet.
Mr. Sen, what is the application for? This
application, I have filed an application for an appropriate order. My lord had been pleased to pass an direction for
appropriate
payment
means
of rupees 5,000 my lord.
Achha.
Now my lord, I have served my lord. They are paying the maintenance, but they are not appearing my lord.
So we'll dispose of this application by making that order.
My lord, in this application, my lord, I have prayed for an order of rupees 10,000 per month, my lord. My lord, the difficulty is, my lord, the order impugned, my lord, will kindly consider the memorandum of appeal, my lord.
Yes.
The memorandum of appeal, my lord will find, my lord, so far as the direction, the finding part, my lord, the petitioner did not file any affidavit of assets. But that is totally wrong, my lord. Affidavits for assets was filed.
Yes.
Subsequently, the another point is that, my lord, they have said neither side had produced evidence as regards the income of the other. So far as the income, my lord, this is a personal knowledge, my lord. If the husband does not provide income, my lord, I cannot help it.
You had to file your affidavit of asset here also. You have done.
I have, in the supplementary affidavit, I have filed a fresh.
File it. You have served copy of that also on there.
That also.
But they're not appearing. What can be done? We'll proceed on this premise. So what have you stated here? You have a child?
No child, my lord.
No child. What do you do, Mr. Chen, your client?
My lord, now, my lord, I am suffering from arthritis, my lord. Rheumatic arthritis.
So you are engaged somewhere?
I cannot, only some tuition, my lord. I have stated around 5,000 I earn by giving tuition.
What is your educational qualification? Can you tell us?
For educational qualification, I have master degree, my lord. But from the very beginning, my lord, due to this arthritis problem, my lord, I cannot move.
So you're asking for 10,000?
My lord, just 10,000, my lord. For the time being, my lord. And my lord, so far as the order impugned, my lord, it's totally fine. Neither the findings nor, my lord, the.
No, very well. We'll direct you to put in the. Did you direct you to put in special messenger cost and all?
No, my lord.
Those were. Supplemented affidavit as well as affidavit of service filed today by the appellant is kept on record. Full stop. Next para. From the affidavit of service, it transpires that due service has been effected on the respondent. Full stop. However, the respondent chooses not to appear. Full stop. Next para. The present appeal has been preferred against an order whereby permanent alimony has been refused to the appellant while your divorce decree was granted in your favor,
No,
against you,
divorce degree in favor of the husband, my lord.
while passing a divorce decree against the appellant. Full stop, next para. By the present application, comma, the appellant seeks alimony at the rest, interim alimony pendentility at the rate of rupees 10,000 per month. Full stop, next para. In view of non-appearance of the respondent despite service, comma, the averments made in the application as well as the supplementary affidavit of the appellant, comma, incorporating the affidavit of assets of the appellant as well, comma, have to be accepted by application of the doctrine of non-traverse. Full stop. Upon a careful consideration of the said application and the contents of the affidavit, as well as taking into consideration the current cost of living, comma, we are of the opinion that the claim of rupees 10,000 per month as alimony pendentility is justified. Full stop. Accordingly, can 1 of 2025 is allowed, comma, thereby directing the, what does the husband do?
He has said that he does at present he is not doing anything, no income, nothing, but his expense is 6,000, and it was a question was put during evidence that how he gets 6,000
By taking loans from people.
No, he has said could not say anything.
Can 1 of 2025 is allowed, comma, thereby directing the respondent husband to pay alimony at the rate of rupees 10,000 per month to the appellant by the 10th day of each succeeding month, full stop. The first current installment of alimony for the month of December 2025 shall be paid by December 10, 2025, and thereafter by the 10th day of each succeeding month for such current month. Full stop. The arrears of alimony from the date of the present application, that is from September, or this month only.
This month.
No, September, sorry. That is from September 2025 till November 2025 at the rate of rupees 10,000 per month shall be paid by 2 equal monthly installments, comma, the first of which shall be paid by December 31, 2025 and the next by January 31, 2025. Oh, they have been paying, you said?
Paying 5,000?
Very well. Next para. Any ad hoc payment, if made by the respondent husband pursuant to the order of this court, in the meantime shall be adjusted with the arrears. The direction says the appellant shall put in the requisites and due requisites and postal costs for service of notice of the appeal on the respondent within a week from date. The trial court record shall be called for by special messenger at the cost of the appellant, also to be deposited within a week. Push up. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the appeal on the learned advocate for the appellant. Push up liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for a hearing.
My lord, before your lordship's rise, my lord, may I permit to mention one original side matter, item number 7. Your lordship, I understand, my lord, your lordship was pleased to dismiss that matter since I could not. My lord,
we dismiss, we don't know. The officers are not there.
May I have your lordship's kind leave to mention?
Now we cannot do anything, Mr.
My lord, may I bring my lord other side, my lord?
No, the officers are not there. We cannot do like this. We cannot sit anytime we wish. We have taken up the original side matters in the morning and exhausted. Whatever happens next Wednesday.
I'm sorry, ma'am. May I have your lordship's kind indulgence to mention item number 21?
Yes.
21 to 23. My lord, the appellants are also here.
One of the appellants.
My lord, the parties are added, and my lord, these matters be posted on of December subject to your lordship?
Yes, no difficulty. Addendum on that.
Yes.
The other appellants? Oh, appellants.
But state.
I was appearing for some of the respondents.
State is one of the appellants.
State agrees to that. You are Mr. Banerjee, you are for the state.
No, I am appearing for some of the respondents, your lordship. I agree to this proposal.
Very well. On the mention, at a board, 21 to 23.
We have also communicated to the planet.
On the prayer of learned council for the parties, comma, the matters are adjourned and shall be taken up next on December 8, 2025.
So grateful to you.
Thank you.
So grateful.
Grateful to Lordship, my lord.
Grateful.
equally.
তোরা আমার দিয়ে দে For the appellant, my lord.
Yes. Defect has been removed.
Yes,
Name-
yes, yes.
Yes. Yes, sorry.
But we are the residents of Diamond City North Residents Association, my lord. Now, my lord, we were in the management before. Thereafter, my lord, we all of a sudden received show cause notice and debit notes were issued to us, my lord. Now, my lord, first, my lord, in the articles of the company, one is also a Section 8 company, my lord, there is no provision of issuing show cause notice. The management or one of the directors, one of the general body, my lord, cannot issue show cause notice. And my lord, the secondly, my lord, in the show cause notice, they tried to open the audited balance sheets of the company, which is also not permissible under the law, my lord. Under Section 130 of the Companies Act, my lord, an audited balance sheet until and unless gets order from the NCLT, my lord, it cannot be reopened, my lord. Now, my lord, we filed a suit, my lord, praying for the seeking for declaration of the show cause notice are bad and also injunctions of my lord. Permanent injunctions with regard to, my lord, the debit notes, my lord. Now, my lord, the learned judge, my lord, after the written objections was filed within 3 days' time, so hence, my lord, there was no scope of ad interim, my lord. My lord, the injunction application was heard. When injunction application was heard, my lord, the learned judge came into a finding that the prayers of the plaintiff and the prayers of the injunction applications are similar, my lord, and hence, my lord, cannot be granted.
Not only that, that you have not produced anything to show defamatory material.
My lord, defamation is different, my lord. There are two, my lord,
You're
grounds
not-
I have. Defamation is there, my lord, but I'm not. My intention more of is with regard.
Not asking for that mandatory injunction removed, right?
My lord. No, my lord. Right now, my lord, I'm asking for, my lord, that a show cause notice as well as the debit note be stayed, my lord. Because, my lord, I also cannot pay the maintenance charges. If I go to pay the maintenance charges, they are deducting from debit notes the amount, my lord. May I show page 120 at once, my lord? This is one of the debit notes. So this is to bring up your notice that upon review of, I'm sorry, my lord.
120, yes.
This is to bring to your attention that upon review of the financial records of the Diamond Association during your 10 years directly, it has been observed that legal profession amounting to 1,20,000 were incurred under the cash ledger court office during the period of 2019. You can see the period even without submission of the valid vouchers, bills, or supporting documentation. Kindly, my lord, sees, my lord, the date of the notice is of 28th of July 2025. You are hereby directed to respond to the 7 days notice of the date of notice, addressing the follows. Why this legal explanation should not be considered irregular or unauthorized in absence of supporting vouchers, why the said documents or the said amount of rupees 1,20,000 should not be recovered from you
Why do
personally.
you say they don't have the right to? They're the current association.
Yes, my lord. Kindly, my lord, takes, my lord, the articles of association at page from page 140, page 48, my lord. Page 49 is the definition of executive committee. My lord, sorry, my lord.
Yes, executive committee.
Yes, my lord. It means that the board of directors of the company, my lord.
You are the ex-directors.
I am one of them. I was there, my lord. All the appellants, my lord, here. Now, my lord, kindly, my lord, takes, my lord, page 58. The powers and duties of the committee. My lord, kindly, my lord, sees, my lord, subject to control and management of the business shall be vested in the committee, who shall be entitled to exercise all powers and do all that. Things the committee is authorized to exercise. Committee shall not exercise power and shall has been restricted by the general meeting. Can anyone sees any of not a single part is there for issuance of, my lord, show cause notice, my lord.
Supreme authority shall rest on the general meeting.
But if they're in control and management of the business of the company, why aren't they empowered to open something, some
Open
Pandora's
something,
box?
they cannot do it. The reason is under section 130 of the Companies Act. These are all audited accounts. These accounts have been audited by an auditor.
They have directed you to produce those accounts only.
No. They have actually reopened it. They have reviewed it. That is the word they have used. They have used the word reviewed. Can you take section 130 of the Companies Act, my lord? A company shall not
No, they have reviewed the financial records.
Yes, my lord. As reopening
and
of the
observed that certain professional expenses were
2019.
allegedly inflated. according.
2019, they are reviewing the accounts of 2019.
They're not reopening the accounts. They're saying that they have had a review of the financial records. They've seen the financial records and seen there are apparent irregularities, and they're wanting to inquire into that.
No, there are. I have given a reply. It's not that.
They're not reopening those financial accounts.
May I see, my lord?
Rather, they're relying on those accounts and saying that these are inflated.
But here, my lord, the accounts has been audited by an auditor. These are all audited accounts. I'm sure that.
Which section?
My lord, section 130. Kindly, my lord, takes, my lord. Lord, a company shall not reopen its books of account and shall not recast its financial statements unless an application in this regard is made by the central government, the income tax authority, the SEBI, my lord, and other statutory regulatory body or authority or any person concerned. An order is
The appellants have made out a prima facie case for admission of the appeal in view of the learned trial judge having refused to grant ad interim injunction on the prayer of the appellants, in a declaratory and in a suit for declaration and injunction with regard to certain impugned show cause notices, whereby in effect, the audited financial records, financial accounts of the this is a company.
The company, Section 8 company, my lord.
Of the company in question have been sought to be reopened in prima facie contravention of Section 130 of the Companies Act 2013, without there being any indication that any prior application in that regard has been made by the concerned tribunal. Push up next para. Accordingly, the appeal is admitted and shall be heard on the grounds taken in the memorandum of appeal. There shall be stay of operation of the impugned show cause notices dated July 9, 2025, July 10, 2025, July 12, 2025, July 26, 2025, and July 28, 2025, till disposal of the application. First of the appellant shall serve copies of the application on the pro forma respondent should be served.
My lord, all of them will respond.
Better.
All of this one.
On the respondent and pro forma respondents, indicating that the application shall be listed for hearing in the monthly list of December 2025. First of the appellant, the appellant shall file an affidavit of service to that effect on the returnable date.
Only a humble request, my lord, prayer, my lord. My lord, their essential services may be granted. That is the only request, my lord, a humble prayer.
Essential services may be granted, means?
My lord, why, my lord, I am saying, my lord? My lord, with regard to the debit notes are there, my lord. The debit notes are issued with regard to show cause notice. Now, my lord, if I am paying the services, I am paying for the services, what I am, my lord, may I give an example, my lord? 100 rupees is the payment I have to make for every month charges, my lord.
You are not a director anymore.
I'm not a director. I'm not in management anymore.
Then?
No, my lord, I have to pay for the essential services. I have to make a charge. I have to pay a charge. Now, my lord, what they are doing is that now they are debiting the amount from the show cause the notices.
Prospective cause of action. You state the operation of the notices, whatever that at this.
If they stop, I'll come back, my lord.
Do that. Come ready with a supplementary affidavit and give a copy to them.
Grateful.
Take back your book. Thank you.
Grateful.
আমাদের বই, ঠিক আছে। Yes.
This is my appeal. But we would be considering the recalling application filed by the defendant, the respondent in the appeal.
That is now being treated as an opposition to their application. Lordship's order is there.
Yes, yes.
Recalling of an order of injunction, country.
Yes.
So that's treated as an opposition. Supplementary affidavit by whom? You?
Yes.
Yes, ma'am.
So there are how many affidavits on record? This recalling we are treating as an opposition to the injunction?
Yes.
Supplementary, what? Supplementary is separate.
Recalling.
Supplementary is a paper book. Supplementary paper book.
Supplementary paper.
Supplementary affidavit? Thick supplementary affidavit.
It is mine. I have filed with along with the CAN 3 because the deed I could not file. That was possible.
Anyway, so CAN 3. What is this then? There are two supplementary affidavits to Can 3. This is Can 3, one supplementary affidavit, another supplementary affidavit. This supplementary, Gautam Pal is your man or his man?
My man.
So this supplementary affidavit is by them.
Have to have a look.
You've forgotten the.
I do not have the supplementary affidavit. I only have the paperwork with me.
What is the matter about?
My suit for declaration and injunction.
We admitted the appeal and granted ad interim injunction.
Ad interim injunction. Thereafter, Lordship had made it absolute because the respondent did not appear.
Now the appeal is before us.
Yes, the appeal is before your Lordship. After your Lordship confirmed the interim order granted by your Lordship, the respondent applied for recalling of that order.
Oh, so that recall is before us.
That's the recalling which is before your Lordship.
So you have to hear the appeal itself then.
Yes, so that may be heard.
Yes.
What is the impugned order?
Impugned order in the appeal is a refusal to pass an injunction in my favor against the defendant from creating any third-party rights or claiming any right.
For specific purpose?
Suit for declaration and injunction.
What declaration?
Declaration is the plaintiffs are the 1/3 owners of the property in question. These are two shops which are the subject matter of the dispute between the parties. Two shops, shop number 24 and 25. Now, the shop number 25 was gifted to all the parties to the suit by our mother. Parties to the suit are brothers. The plaintiffs are
Then we look into the paper.
Arshis will look into the paper book that has all the papers.
So it's difficult to take it up now.
Very short point. There's nothing.
That is very evident from the 3 volumes of the paper. Anyway, yes. Sorry. Please continue from where you stopped.
A shop was gifted by the mother of the parties. Plaintiffs are the elder brother and the middle brother. The defendant is the younger one. The shop number 25 was gifted by our mother. Thereafter, we find out that the same shop has been purchased by the defendant in the year 2023, in the year 2015, from the same party who had sold the shop to our mother. The consideration was 50,000, whatever it may be. Thereafter, we filed the suit, claiming a declaration that all the parties to the suit are.
Use the purchase deed of your mother and the gift.
Yes, man, that is also there.
Both of them.
Yes. What is what is the suit is all about? The plaintiffs filed for a declaration claiming that each of the parties are 1/3 owners of the property which is shop number 25, and the injunction which is claimed, the defendant can't sell it off without can sell only his share of the property, no other share. The injunction was prayed for. It was refused on the ground of misjoinder of parties, with the trial court observed that since the person from whom the
non-joinder
misjoinder is saying, for a person from whom it was purchased, that he has not been added as a party.
How can it be a misjoinder? It must be non-joinder.
That's what the order says.
It's a misstatement. Yes. So non-joiner of the architect of all these things.
Yes.
Sold it to your mother as well as to them.
Yes. So
only on that ground.
Only on that ground, and which your Lordship has overturned. Which your Lordship, when your Lordships admitted the appeal, Lordships have granted.
Which was the impugned order? Where is that? Which
page 99. At page 99, Lordship takes the second last paragraph. This court has perused the record. Lordships have found.
Yes.
This court has perused the record in the light of the documents produced. This court finds that there is specific allegation that
you have sought for a declaration that their deed is bad.
No, I've not sought.
You have claimed title, 1/3 title, and
1/3 title, and that's all.
Is correct. Yes.
This court finds that there is specific allegation that despite knowledge of the previous deed executed and registered in 2013, wherein the defendant as a donee had put his signature, the defendant had again purchased the same property from the landowners and the developer who is a conforming party. Remarkably, the said landowners and the developer have not been made party to the suit. If the second deed registered in the year 2015 is invalidated, it would adversely affect the interest of other parties. The said parties to the deed 2015 are therefore necessary parties who have not been made party to this suit.
Who are the other parties? The vendor?
The vendor. Thus, this suit apparently suffers from the.
Yes, Miss Lahiri, nothing in your mind.
Well, no, well, there is something. Well, I'll indicate.
What is their best case?
I'll indicate. Well, their best case is our mother did not have any title insofar as this shop is concerned. Shop number 25 could not have been gifted by our mother to the.
Your mother, you say, had a title deed which you have.
Yes, there is a title deed where only shop number 24 is mentioned.
Subject matter of the suit is 24 and 25.
Subject matter of the suit is 25.
So then
We are saying
you can take case.
No, what we are saying is shop number 24 and 25, they were undemarcated, and which is an admitted fact. In the recalling application, that is admitted.
Shop numbers are given undemarcated means?
Because the defendant himself is saying that after the purchase of the shop number 25, a boundary wall was created, and thereafter it was demarcated by him. There is no one else who was involved in the whole demarcation process.
In your mother's purchase deed, any shop number is given?
Shop number 24 is written.
So how
now
did
there
it
is a
become
dispute with regard to what is the area of the shop, because according to our clients, it was only
as
one
per the
shop.
descriptions of their sale deed and your gift deed, your mother's gift deed to you or her purchase deed, your mother's purchase deed and her gift deed to you must have the same schedules.
Must have the same schedules, but the schedule is different, because the purchase was the mother purchased the shop in 1991. Thereafter gifted it in 2023. So in the meantime, in the area there has been various alterations, additions. What we are saying is that when
the shop rooms are identified, how can it?
Yes, that is what I am saying. At this stage, it can't be identified. My case is this shop room, there was only one shop room which was purchased, and there was no existence of shop room number 25, which the defendant claims as his.
What are the boundaries? What do the boundaries show?
Boundaries,
their deeds boundaries.
We had tried to decipher from what is there. The boundaries are a little bit on
there
the.
cannot be any injunction then.
But only what I'm saying
Unless
is
the property can be identified properly.
It has to be identified.
Whether those two are similar, the same property.
Yes,
the plinth of your arguments.
Yes, I am saying that this property was the same. There was no shop number 25
That's
at
a
all.
claim. There cannot be an injunction.
But the
Injunction
defendant
restraining them from doing what?
But I'll read out the reliefs, which your lordship will find at page 6.
From disturbing peaceful right, title use and enjoyment.
No, decree of
As
permanent
owner. No, in the injunction application.
In the injunction,
restraining them from disturbing your right, title, use, interest, enjoyment. That means enjoyment, basically your possession and enjoyment.
Yes, my
So
possession and
if you are granted that, then their possession is ousted.
But if this relief, what I've prayed, what I've made in the injunction application can be molded. They are in possession of the shop in question. My relief would be if they are restrained from selling it further till the disposal of the suit.
Ask for that.
But in the suit, I have. In the suit,
an application, if you have not asked, we cannot go beyond the.
No, if it could be modified, because this is the subject matter of the suit. If this subject matter of the suit could be preserved, because there are allegations, counter allegations. I am saying this was only one property, whereas the defendant, who is a signatory to the deed of gift, the defendant is saying that no, there were two shops. I had purchased the
This
other
ground is bad, but otherwise you are not entitled to injunction, because unless the suit property can be identified, how can we? I mean, we don't even know whether their purchased property is the same as yours. It may be an entirely different shop room.
I derive my right from
you
the
get
gift.
prima facie case. You have a prima facie case only if you can identify the property. You could have sought for whatever local investigation or investigation in the sense that survey pass commissioner with comparing the deeds and all.
Has to be done. Has to be done
Without
without a
get your
commissioner.
injunction in the main injunction application. But at ad interim stage, why interference?
Ad interim stage or ad interim refusal was only on misjoinder. The lordship had molded.
Sound bad. Conclusion right.
Yes, but the trial court has not even gone into whether this is identified or not. What is the main status of the property? That has not been gone into. Now, what I am saying, the trial court.
You satisfy us because
Yes,
you have to, if you upset this and grant ad interim injunction.
I'll tell my lord. But the subject matter of the suit is.
We'll grant you liberty to apply for local investigation.
We will have to do that
on a comparison of the deeds of both the parties and.
We realize, and the commissioner would also.
At interim stage, you are not interfering. Then we will say that this ground is a bad ground.
No, but that will not suffice.
No, even otherwise, you have to. The identity of the property has to be established.
That has to be established, but till such time it is identified.
Yes, Ms. Lairi, what about transfer?
Ship, I have already transferred. And that is on record. I don't know why my learned friend has not indicated
Yes, that is on record in their application.
In our application, I have annexed the title deed, and 1 year before the order has been passed by your lordships, I have already.
So it's bad for non-joiner that way also. You have to implicate those people.
Yes. Lordship will appreciate.
Want to implicate those people.
Lordship, there is a map in the deed of my mother's purchase deed, there is a map at page 122 of the supplementary paper book. So they cannot say that 24 and 25 are two, and it was, Lordship will come to the bottom portion of it, of the map at page 122. Lordship will find that 24 was earmarked with red. That is the in the schedule of
Don't
the
have the
deed.
colors here, but
Yes, the colors is not there, but it
24 we can see a different.
24 and there is a different 25. So what happened was,
This is whose deed?
this is my mother's deed.
By which she purchased.
By which she purchased. She only purchased 24. Now, Lordship will also kindly look into
And you have purchased this to 25 only.
I have purchased 25. What happened is, after we purchased, at that time, it is a fact that there was no boundary wall between these two shops.
So you say 24 and 25 remain the same. You have only created a boundary wall.
That I have created long back, and Lordship, what happened is, there was a gift deed. Lordship will kindly look into the recital of the gift deed at page 124. The gift deed recital, Lordship, the gift deed starts, the gift deed which is their case.
So Basu, your phone is ringing. Yes. Please deposit the phone. We'll check the messages and give back. And your posts on the social media also. Yes, Ms. Larry, please continue. 124.
Lordship, 124 is the gift deed. Lordship will come directly to the relevant paragraph at page 132. When this is the recital, says,
yes.
Whereas Srimati Joshna Pal, the donor herein, the mother of the donees, had purchased undivided interest in the land proportionate to the space measuring super built-up area 91 square feet on the ground floor, earmarks as shop number 25 at premises number this and this on payment of valuable consideration without any demarcation or boundary with the shop number 24 of the premises from the owners and confirming parties of the said land and newly constructed building which was also purchased by the donor. What she purchased was 24, not 25. That is specifically
Without any undivided, if it's undivided.
Divided. There was
Says this deed says.
According to this recital, this deed is a nullity. This deed, when the mother never had a title to pass on the give the property, this deed is a nullity. I will challenge it in collateral proceedings. But today, how can I be restrained? And not only that, I have already sold it. That is also my specific case made out.
Yes, that has been sold after the suit was filed.
Suit was filed, but there was no order of injunction, and 1 year before they have moved this application before this honorable court. And there was, Lordship will also look into the pictures. They have been sitting on this issue, if at all. There is no case
So she purchased 24?
No, yes. And she
24 or 25?
24.
She purchased 24,
She
donated 24, gifted 25 in a roundabout way.
In a roundabout way. So there was no title and I was in possession. That is their admitted case. I, being the younger brother, I was given this possession. You take this possession. And later when I realized that I don't have title, I got the title from the actual owners and the developer.
Yes, this is very, fudgy.
But I'll tell my lord.
Lordship will also look into page 176. I have raised this 176, Lordship. The pictures may be very hazy, but now I have constructed a demarcation. They were all along sitting on it. They knew of all this fact. And
that you built about
2015.
Yes.
In 2021 or 2.
No interference. I'll tell my lord.
Yes,
But
quick.
page 132, what has been placed. But
shop number 25 is a suit property.
Shop number 25 is the suit property.
25 was donated, but she got only 24.
She got in the sale deed of my mother 24 written. Now what she is saying that she has purchased 25.
She cannot improve her purchase deed in her.
I agree. But without demarcation of
Got 24. She had to give you 24 only. She could give you 24 only.
Could give me 24 only.
25 she could not touch. They have purchased and in occupation of 25. They have sold it out. So no question of.
But what has happened is when the property was purchased, there was nothing. It was undemarcated.
That you prove in the suit, but
that is admitted. That was admitted in the recalling application, and they are also admitting to the gift. The gift.
No, a demarcated shop room was given. Although it's.
They have said.
Case of their
it is
rights.
I'll place the paragraphs of the recalling application. Kindly place.
No, forget the recalling application. Let us see page 119, your schedule. your mother's purchase deed schedule. Earmarked for shop being number 24 was purchased.
4 of the total built up area of such and such.
How could
Now,
you give to 25 to you?
Lord, I agree, but the issue here is when 24 was purchased, there was no demarcation. So there was no where 25 is or
The
not.
deed specifically says space measuring an area of specifically 113 square feet on the ground floor earmarked for shop being number 24.
Well, the fact that
So she purchased that earmarked portion.
but the schedule says it is earmarked. The case made pleaded by the plaintiff as well as the defendant both of the parties admit that it was undemarcated. The defendant admits that it was undemarcated.
Undemarcated. She says undivided.
Undivided.
There's a difference between
Yes.
divided.
But that is the
difference between undemarcated and undivided.
Yes.
Undivided share may be demarcated also.
Yes.
But anyway, I mean,
but
so you said she had share in this.
And she is, and the defendant is.
The vendor is the same. He or she can
Vendor
earmark a portion and sell it.
Yes. But
there is a question of divide.
There are various other issues which may crop. What is the consideration?
At this stage, no.
But only thing is, I'm not inviting. We have to file for a local commissioner. Investigation has to be made. But till such time that is done, the defendant after filing of the suit,
they already sold the property.
After filing of the suit, they have
complete them. What can be done?
But I shall have to. But if the
what injunction are you expecting now?
From creating any right where they have already created. The defendant has already created some third party right. But they are in possession. It is the creation of third party rights is only to frustrate the suit. Because that was done after filing of the suit.
No.
And the gift deed is admitted. Gift deed.
The present hard learned counsel for the parties on the appeal itself. First up, the present appeal arises out of a suit filed by the plaintiff stroke appellants for declaration of their 1/3 share in respect of the suit property and for permanent injunction. For next para, in the said suit, an application was filed by the plaintiff stroke appellants praying for injunction restraining the defendant stroke respondent from disturbing the peaceful right, title, use, interest and enjoyment of the plaintiffs as co-owners of the suit property. For next para, the learned trial judge refused to grant ad interim injunction on the ground that the landowners and the developer have not been impleaded in the suit. For next para, upon hearing the contention of the parties, we find it evident that the said ground was not a valid ground in the eye of law for refusing ad interim injunction, since in the suit of of the present nature, the developer and the original landowners are not necessary parties. For next para, however, we agree with the conclusion of the learned trial judge, although on different grounds than that attributed in the impugned order. For next para, the claim of title of the plaintiff stroke appellants is through a gift deed executed by their mother in their favor. The said mother purchased the property in the year 2013.
No, well, purchased in 1991, 2023, she gifted it.
In 1991.
2013.
Full stop. Next para. On the other hand, the defendant stroke respondent claims title to shop room number 25, by virtue of a purchase deed from the vendor of the mother of the plaintiffs, executed in the year 2015, that is after the gift deed dated 2013. For next para, learned counsel for the appellant argues that it is an admitted position from the deeds, that the property purchased by the mother of the plaintiffs was undivided, and as such, the plaintiffs have equal right over the entire property comprised of shop number 24 and 25. Furthermore, it is argued that the respondent has constructed a boundary wall purportedly between shop room numbers 24 and 25, despite there being no clear demarcation or division of the said shop rooms at the time of purchase by the mother of the plaintiff stroke appellants. So as such, it is argued that the plaintiffs have equal right over shop room number 25 as well. For some next parallel, counsel appearing for the respondent submits that the respondents have transferred transferred shop room number 25 in the meantime in favor of third parties. Because of that apart, comma, it is pointed out that in the schedule of the purchase deed of the plaintiff's mother, comma, it was categorically mentioned that the space earmarked for shop being number 24 was transferred to her. Full stop. Thus, comma, in her deed of gift, comma, the mother transgressed her rights by donating more than she had, comma, by indicating in the gift deed that she was transferring the the space earmarked as shop room number 25 with shop room number 24.
Lordship, most respectfully, this is the gift deed is only in respect of 25. No, not in respect of 24. That is, I say that it is
Earmarked,
exactly a nullity.
earmarked as shop number 25 at the said premises, তারপর double inverted, on payment of valuable consideration without any demarcation and stroke or boundary with the shop number 24 of the said premises, double inverted close. Full stop. Next para, it is contended that thus, comma, although the mother of the plaintiff's appellants purchased shop room number 24, comma, she gifted shop room number 25 without having any title in the same, and comma, as such, comma, the gift deed is a nullity ab initio. Full stop. Next para. Thus, comma, it is submitted on behalf of the respondent that the learned trial judge rightly refused to grant ad interim injunction. So next para. On a perusal of the schedule of the purchase deed of the mother of the plaintiff's appellants, it is crystal clear that although the interest in the land was undivided, comma, the subject matter of the said purchase by the mother of the plaintiffs was the space measuring an area of 113 square feet approximately on the ground floor of the building, তারপর double inverted, earmarked for shop being number 24, double inverted close. Full stop. Next para. However, comma, in her gift deed, comma, she transferred shop number 25 by taking advantage of the fact that the interest in the land was undivided. Full stop. On the other hand, comma, the defendant stroke respondent purchased the earmark portion for shop room number 25, comma, which had not been purchased by the mother of the plaintiffs. Full stop. Thus, comma, on a prima facie footing, comma, we find that the mother of the plaintiffs never acquired any title to shop room number 25, which she purportedly donated to the plaintiff stroke appellants, comma, which is the plinth of the claim of title of the plaintiff stroke appellants. Full stop. Next para. There is a gulf of difference between double inverted undemarcated, double inverted close, and quote unquote undivided. Full stop. Whereas by virtue of the former, comma, what is meant is that the property is question is clearly separated and demarcated physically, comma, the latter means that the rights of the parties might not have been partitioned by metes and bounds or divided by a registered deed or a decree of court. Full stop. Next para. Proceeding from such perspective also, since the vendor of the mother of the plaintiffs, comma, through whom the plaintiffs claim was common with the vendor of the defendant stroke respondent, comma, the question of the land being undivided does not have any germane bearing on the subject of the respective transfers. Full stop. It is prima facie evident that only the area earmarked for shop room number 24, which was separate from shop room number 25, was sold to the mother of the plaintiffs, comma, the earmarked portion of shop room number 25 was transferred to the defendant stroke respondent, comma, which is the subject matter of the present property. Full stop. Hence, comma, we do not find any prima facie proof of title of the plaintiffs in the subject property, suit property, that is shop room number 25. Full stop. Next para. Moreover, comma, since the said shop room has already been sold in favor of third parties, comma, there is no scope of grant of ad interim injunction. Thus, comma, we agree with the conclusion. Thus, comma, we reiterate that we agree of the conclusion of the learned trial judge in the impugned order, although disagreeing with the ground assigned for passing the same. In such view of the matter, comma, FMA 683 of 2023 is dismissed on contest without any order as to cost, comma, thereby affirming order number 2 dated September 20, 2023, passed by the Learned Civil Judge Junior Division at Bidhannagar, District North 24 Parganas in title suit number 325 of 2023. Full sub next para. Consequentially, can 3 of 2025 is also disposed of. Full stop. We make it clear that we have not conclusively determined the respective contentions of the parties in the suit as well as the injunction application pending in the court below on merits, and it will be open to the learned trial judge to decide the injunction application as well as the suit independently on their own merits without being unduly influenced by any of the observations made above. No less to cost. Thank you.
Grateful. Grateful.
Thank you.
Because I was thinking of requesting your lordship to make certain observations regarding local investigation, whatever that.
That will open another either Pandora's box or Jack in the box, depending on your perspective.
Pandora's box.
Depending on the perspective.
Yes. Grateful.
Petition, my lord. Previously, my lord, before vacation, my lord wanted to hear out the entire writ petition.
Obviously, could not because the respondent was absent.
Yes. My lord, and Mr. Basu
I was
took
not
the charge.
absent, but I was not absent to the court. I said, Millard, that the brief was not traceable, Millard, and
In
ultimately
your chamber. Where was it found? In whose chamber was it? Your own chamber.
Now, Millard, I tried to shift my burden upon my junior Nilanjan. Obviously, he kept Millard, they have filed an application, Millard. Nilanjan Pal Millard was.
My lord, can hear out the writ petition, my lord. Honestly, because the affidavit's been exchanged,
Yes,
issue is whether this property can be treated as thika or not. The controller, this is one of such cases where controller has held that this property is not a thika property. But the tribunal, my lord, has reversed the order passed by the controller.
But this is to be heard on facts also. What is your ground? I mean, why was the tribunal wrong? What was the premise of the tribunal's reversing?
Yes. My lord, initially this property
There
was
is no dispute as to jurisdiction of the Thika controller. I mean, this does not have that facet. He had jurisdiction.
even that is also there.
It was passed when? After the coming to force of the section 5.3?
No.
Tribunal is to 2013.
Return was filed in the year 1988.
No, we have to see when the adjudication was.
My lord, the date of the
On that
controller's
date,
order.
the tribunal had the ticket controller had the power then.
Yes, 6
Had the-
July 2009.
So then it
Yes.
had the power. Yes.
The entire property was a one premises number, 236 AJC Bosch Road. Then during that period, there was a homestead, construction was there, Pakka construction was there.
By whom?
By the landlord. By that time, this property was not given for a lease. The vacant portion, part of the portion of the property was given for a lease to Mr. Basu's client in the year 1938. And
construction was made before that.
Before that.
So then?
So on that score, controller has said already existing a Pakka construction on that particular property. And
he constructed on that vacant portion.
On that vacant portion, 5 kata something.
Say that is not a vacant land as such, but a part of the homestead.
Yes.
All right.
Same property cannot be adjudicated by Premises Tenancy Act as also by the Thika Tenancy Act.
But they made the construction all the same.
Yes. Leased out.
Thika controller.
Now my next point would be that construction even was raised by Mr. Basu's client was a Pakka in nature because that was a petrol pump. So first one is on the same premises, there was an existence of a homestead, a Pakka construction raised by the landlord.
Not in the spirit of the case.
It again.
Acha, this the premises number of the building and this vacant portion was the same.
Same.
Same
No,
premise?
no. Later on, it was bifurcated 23(6)A and 23(6)B. 236 initially 236 Ajeshi Bose Road. When lease was granted, it was the one premises.
When
Thereafter,
this was granted to them, it was 236 only.
Yes.
That is to be considered. Yes, let us see the definition of this ticket tenancy.
এমনি দিয়ে রাখতে দাও। হ্যাঁ। Well, it is in the definition clause.
Yes,
perhaps.
240. Yes.
Thika tenant means any person who occupies, whether under a written lease or otherwise, land under another person and is or but for a special contract would be liable to pay rent at a monthly or any other periodical rate for that land to that another person and has erected or acquired by purchase or gift any structure including pakka structure, if any land. This one at the bottom will find substituted by has got this around November 2010. This substitution was made. Any means pakka, that was done in November 2010. On such land for residential, manufacturing or business purpose and includes the successors in interest.
Pakka was introduced in November 2010.
November 2010.
So the adjudication by the Tika controller was before that.
Before that.
So what is the premise of the tribunal's order?
The tribunal has said everything is retrospective. All amendments, 1993 amendment, tribunal has interpreted.
So that was the interpretation on the Pakka thing. Pakka.
Yes, yes.
And what about the other point? What was the take of the tribunal that the land was not given, but a part of the homestead was given? Let us see the impugned judgment of the tribunal.
Kindly first come to the controller's order, page 200.
Page 200 of this?
Of the paper book.
This is the paper book?
Yes. I'm sorry, volume 1.
কাপড় আছে একটু ঝেড়ে দিতে হবে। ঝাঁটা বালতি আর জল দিন আমরা করে নিচ্ছি। ওকে ডাকুন না, পিয়ন ছেলেটিকে ডাকুন না। ওকে ডাকতে দিতে হবে না, এখন আপনি করে দিন। ওসব না, পাশে যেগুলো খাঁজগুলো রয়েছে দিলেন, কলাটার করে দিন, ব্যাস ছেড়ে দিন, দিয়ে দিন। জাস্টিস ভট্টাচার্যটা করে দিন, এটা দীপঙ্কর করবে জাস্টিস ভট্টাচার্যটা। ওটা আপনি নামুন, এবার তুমি ওটা, তুমি ওনারটা করো। ততক্ষণ 200 কথা বার করি বসে। किसी का एकाकार हो जाता है।
I'm sorry, man.
You cannot be sorry for the... Yes.
একটা কাজ করেন, এখানে
দুশো কথা ওইসব
from page 200.
Yes, 200. Brief history, let us see.
Yes, the applicant two returns. One 2nd May of 1988 and the other one is 4th April 1988. One is for 5 kata, 14 chatak, 3 square feet area of land. Another one is 987 square feet respectively. So 2 returns in respect of the same premises in 2 tranches. Now, my lord, kindly come to the next page. 201. The contention of the applicant is that the applicant is the successor in interest of Caltex India. Initially, Caltex was the lessee. Then Caltex changed the name to HPCL. This is the said Caltex India Limited to bear land from the then landlady Srimati Sarojabala Kaur for an area of 5 kata 14 chatak 3 square feet bearing a portion of 236 Lower Circular Road. My lord, kindly mark it. 236. The premises 236 Lower Circular Road was subdivided in the year 1950-51 as 236A and 236B. This happened, bifurcation had taken place in the year 1950 to 51. And the original lease deed executed on, well, next paragraph, the Lower Circular Road took the bare land on lease by way of deeds of lease of 1938, 1944, 1954, 1963 and 69, and had been running a petrol pump since 1938-39.
Before 50-51, you can understand, but from 1950, there were renewals of the same deed or fresh deeds? If it's a fresh deed, then 1954
renewal.
Onwards, it is different, A and B.
Renewal. Renewal got expired in the year 1969. Thereafter, no renewal from 1969 onwards. Then, Malan.
So they must have made the construction in 1938 itself.
Yes. Even that itself takes out the definition of Thika tenant.
No, then they take it on lease and make the construction. They are Thika tenants. But if it's
if it is Pakka, Malad, if it is Pakka, then Malad, it again
at that point of time it was. Yes, right.
Even implementation of 49 Act. Then deed number 10th May 1954 for 7 years, 6 months with effect from such and such, renewable for another 7 years, 6 months in respect of 236.
All renewals, yes. All renewals.
All renewals. Now, kindly come to the page 202. It is contended that Messrs. Caltex India Limited, after taking lease of land, constructed Kacha structure and thereafter by way of sanction plan of KMC dated 31st December 1969 raised the present structure in the year 1970. That thus the Messrs. That was their case, became the Thika tenant since 1938 and continued thereafter. The HPCL being the successor in interest accordingly is the Thika tenant in respect of said premises, which is now being renumbered as 236A AJC Bose Road and filed return accordingly and used to pay the rents to the state since then. Then, next paragraph. They are the successor in interest of the previous owner and have purchased the right title and interest of the said owners by way of a registered deed dated 24th April 2006, and the predecessor in interest of HPCL, that is Mrs. Caltex India Limited, had not been inducted in bare land but in land with structure. That was my case. The entire premises had a homestead structure with a land appertaining thereto, and in that land appertaining thereto, vacant land was, a portion of the vacant land was given. That the return was filed much later, that the time limit is barred by limitation. That was my another reason that the return was filed beyond the limitation period.
That was
answered. Well, that was answered by the controller against me.
Yes.
And the another aspect is it was more than 12 years. So hence this is not a Thika property. It then goes out purview of 1949 Thika Tenancy Act and thereafter out of purview of both the 81 and 2001 Act. Then, my lord, kindly come to the next page. The document number 1, certified copy of assessment book of KMC land and building in respect of 236 Circular Road in the year 1927-28. That was the evidence I produced. Then deed of settlement of 28th February 1939 in respect of 236 Lower Circular Road, executed by Sorojabala Kaur in favor of Srimati Kamalabala Ghosh, appointing the latter as trustee. Then document number 3, certified copy of the sanction building plan dated 1st February 1939 in respect of 236 Lower Circular Road. The plan having jointly signed by the owner Sorojabala Kaur and the predecessor of Mr. Basu's client, that is the Caltex, showing existing structure thereon. So it is an admitted fact that in the year 1939, there was an existence of a structure.
They took it on in 38.
Yes. 39, they took it on 38, put it for a plan sanction. During that time, they admitted that there was a construction, Pakka construction. Then the document 5, certified copy of inspection book KMC for 1969-70 and 75-76 in respect of 236A AJC Bose Road. Now, my lord, I'll place the later on. I'll place the schedule of the trust deed, wherefrom I can show that even that registered trust deed says about the construction in that particular premises.
The assessment book of the corporation was also dealt.
Yes, all corroborates.
Dwelling house.
Then, my lord, the findings. My lord, I kindly come to the next page, 204. Answer to questions number A. From the records, it appears that the return was filed in the year 88. During that period of time, the Calcutta Thika Tenancy Regulation Act 81 was in force under Rule 3A of the relevant rules of 82. A Thika tenant was bound to furnish return in Form A within 240 days, which they did not, obviously. However, he may furnish such return, also subject to acceptance by the controller, again under the West Bengal Thika Tenancy Act, Rule 2004. Within to accept any return filed after the expiry of the time limit. Then, my lord, in this matter, well, I'm not placing that paragraph. Kindly come to the next answer, that is B. To arrive at the question whether bare land had been let out or land with structure were let out, the initial point is the date of such letting out. The application herein has furnished different dates at different times in the returns itself. The date of commencement of Thika tenancy has been furnished as 1st April 1969. Later, a deed dated 10th May 1954 has been furnished to show that the Thika tenancy started with effect from 1st April 1954. Again, at a later stage of proceeding in the written submission filed on 19 June 2008, the applicant claimed that the petrol pump of Messrs. Caltex India Limited had been running since 1938-39. Considering the documents of both parties, it is found that the letting out took place in the year 1938. And the contention of the opposite party is that there was already two existing structure in the said premises at the time of induction of tenancy. In their support, they have produced the certified copy for assessment book of the Corporation of Kolkata 1927-28, which shows description as dwelling house, the owner as Mr. P.C. Kaur and occupier as H.F. Batsman, who was tenant in the said structure at that point of time. There was a tenant also. That mentioning is also in the book. Thus, there is no doubt that the undivided premises number 236 Lower Circular Road had structures since quite some time, proceeding at letting out to Messrs. Caltex India Limited. It is their contention the premises number 236 Lower Circular Road was not divided at the time of induction of Messrs. Caltex India Limited, predecessor in interest of the applicant as tenant. Further, sanction plan of CMC dated 11th February 1939 shows a comprehensive plan of building over the entire premises and inclusive of portion let out to Messrs. Caltex India Limited. Hence, the question of Thika tenancy has to be determined, taking into consideration the nature of the entire premises and not only a part thereof. Further, the sanction plan of CMC number dated 11th February 1939 shows the existence of existing structures in the said premises. Even the lease of deed dated 4th August 1938 for the particular portion of the premises.
Everything after 1939 is not so important, because after 1939, if there is stated that there is a structure, we don't know, that might have been built before, after 30, but only after 30. But only this 2728 corporation assessment book shows that description is dwelling house. So that has been relied on.
Coupled with registered trust deed. There, in that settlement, it's been mentioned about the structure.
That is of February 1939.
Yes.
And their lease deed was 4th of August 1938.
Yes.
So might have been built after that, within those
It's
4.
not built it by them. They are only on 5 kathas and few chataks of land.
The relevant date is 4th of August 1938, when they obtained the lease deed. We have to see whether on that date there was any structure on the property, pre-existing structure. If there was no structure, it was a land simpliciter, and they have made the construction. Therefore, it would be a tenancy.
Yes,
1939, the deed of settlement.
There is no quarrel, but still, even hypothetically, if my lord thinks, if today landlord gives in the year 1938, landlord leased out a land in favor of X. And in the next year, 1939, if landlord constructs any pakka construction in his area,
No,
not
even then it's already a tenancy. Does not make a difference. It's
in-
already a tenancy. The character of tenancy is acquired the moment the lease is granted, and they make a construction.
38, there was no definition or there was no law governing the field.
If construction
it came
is
in
subsequent,
1949.
Whatever, if construction is beyond 4th of August 1938, because the definition is whenever the Tenancy Act came for 49 or wherever, it says that a lease has been granted in respect of a land.
Vacant
and
land.
He has made a construction there on that.
Yes.
So
The
we have to
owner would be
the cutoff date is 4th
tenant.
of August 1938 when the lease was given. We have to see when then it was a land.
That,
After that, whether construction was
that
made,
evidence I have. I can substantiate that.
27.
27.
Assessment book. Yes. Let us see how the tribunal proceeded. We have seen.
No, no. Kindly come.
137 petition.
One.
Page.
August page. No?
Tribunal
My
page.
lord, before my lord goes to the tribunal's order, my lord wanted to say that they got the lease in August 1939.
Yes, they did not.
They got the lease in August 1939.
Yes, something recorded. Something's recorded here.
Yes. Sorry.
We are not trying to say it's recorded at page
Yes,
206. Even the lease deed of August 4th, 20.
Well, I'll go straight away
document
to the
4. Is that the lease deed?
Malad is referring page
206. First paragraph, 5th line from bottom. First paragraph. Even the lease deed of 4/8/1938.
Yes.
They are document number 4. That is the lease deed. So that is the date. We are not saying anything. It's all on record. So now show us the
Now,
time.
Malad, kindly come to page 137.
সত্যি কথার অর্ডার লিখেছে, সত্যি করে ইচ্ছে করে যেতে না। Tribunal judgment is 63 pages.
63 pages. Or kindly
Taking
come to-
inspiration from Mr.
Yes, I was.
Prose. Only the question marks are missing. Yes.
Or kindly come to 141, my lord.
141.
Kindly come to first 141 at page 141.
If you come from 114, it will take the entire day.
That's
Kacha pakka, that is
only two paragraphs, my lord, at page 141.
read out.
Luckily, that time the money square was not available to the before the tribunal. Now Supreme Court has categorically, my lord, explained after the review has been entertained. My lord, page 141, paragraph 2.5. My lord, the expression any structure included in the definition of thika tenant was substituted by any structure, including pakka structure, by the Amendment Act 2010. And the word substitution in any beneficent statute should have retrospective effect. As per the provisions of the Act 2001, any bare land given on lease or otherwise occupied on condition of paying monthly or periodical rent be declared as thika land.
But the notification gives effect from November 2010.
November 2010. We are discussing about the tenancy of 1939.
Yes.
So retrospective effect was given by the tribunal. Not by the legislature, but by the tribunal.
All the same, yes. Next.
No.
So many judgments have been considered.
Yes, so many judgments. Kindly come to the next paragraph. 1993 amendment was also considered.
Yes.
So 1993 amendment, 2010 amendment went back to 1938. 1993 amendment went back to 1938. Now, Malad, kindly come to 149.
Yes.
Should I place the
select any 5 pages, you will be permitted to read 5 pages, you select your pages.
And kindly come to page 1.
Any 5 pages of your choice you will read, will permit you to do that. No more. Please select your 5 pages.
And page 163, paragraph 12.
Yes.
Yes. On perusal of the registered deed of lease executed in the year 1938 and further deed dated 10th May 1954, it is crystal clear that only bare lands were leased out. The fact of taking the lease of bare lands for business purpose cannot be disputed and need not be proved further. Hence, it is held that the applicant was given lease on bare lands and not land with structure as observed by the controller in the impugned proceedings. So, how tribunal has avoided? Regarding the existence of a structure on that particular premises, this is the explanation.
We also have to look at the lease deed. That will also look into. Let us see read the judgment first.
Authority was given by the lessor to the lessee, that
the thika controller has also given a peculiar interpretation that including land has been given, including appurtenances easements, drains, sewerage. So that means there was a structure.
Yes.
That also is not.
Yes.
We'll look into that. So this is one of the things.
Yes, authority was given by the lessor to the lessee and the applicant to construct a structure on the demised lands. Corporation records cannot nullify the fact narrated by the registered deed. Hence, contents of the lease that only bare land was given to the applicant is accepted.
So tribunal relies on the lease deed to say that bare land was given.
Yes,
And
I admit that. We have given them a bare land and they have constructed on that land. It is not my case at all that we did not give them a bare land.
But
the entire premises, there was an existence of a structure, and on that structure there was a premises tenant.
And regarding this pakka, kacha thing, this retrospective effect.
Retrospective.
This is the crux of the tribunal, sir.
Yes. This is the
Rest are
crux.
judgments of high courts. These are the 2 points on which you are.
Yes. Yes. Then all Lokshimoni Dashi, even special bench
Both
was
of you filed written notes of arguments in this matter?
Yes. Well, no, not before my lord.
Don't.
No.
Before the tribunal it was done, probably.
Not
done.
Notes of argument? Yes.
was done.
I was not there, my lord. Mr.
You were there. You had filed written notes of argument.
Yes.
Yes. Have you got copies of those written notes of arguments?
have to find it out.
Which was filed before the tribunal?
That is not a correct copy.
No,
It's academic curiosity.
No, it is. I have given in the paper book. Well, it is there.
Which page?
Well, page 418. 4182 to 581.
No. You're giving the wrong page.
559 it starts.
Oh, no, sorry, 559.
Yes, correct. 559. Appellant were you. No, you, because you.
Totodol Bashini considered, special bench considered, PD Murarka considered, everything was distinguished by the tribunal. All settled judgments were considered. Pratanko Shekhar Maiti, even
who is he?
It is under protective umbrella, hence
permit me to address your lordship tomorrow, my lord.
No. We won't. Today. We'll permit you to address today. Anyway, so this is the premise.
Yes, this is the premise.
Let us hear Mr. Basu.
Yes.
And I'll be relying on few judgments.
Rely on the judgments, then we'll hear Mr. Basu.
No, definitely money square.
Whatever.
Yourself জানেন ওগুলো just money square টা দাও.
How many judgment? Those points will be awarded on that.
I'm not giving anything. Let me.
No, please cite this. We're not precluding you. We'll consider the quantity and the quality of the judgment. Relevance to the matter.
নিমাই চন্দ্র দাও মানি স্কয়ার বলে বুঝতে পারি করলাম না কুলেটা দাও দিয়ে দিই লক্ষ্মীমণি দাসীটা এনেছো হ্যাঁ দাও
ঠিক আছে একটু এদের ডেকে নাও তো মিস্টার ধর will rise for 5 minutes and come
Sorry,
Yes.
I'll not take much time.
No.
I'll be just only mentioning the paragraphs. This is the Lokshimoni Dashi after our special bench where Kacha and Pakka, which subsequently even Supreme Court has relied on that judgment. This is again Kole properties.
You give the paragraphs, sir.
Yes. Lokshimoni Dashi mala page para 4356.
43.
Yes.
56.
3 and 56.
All right.
Kole properties mala 7, 8.
First paragraph, 7, 8,
Then 12, 13, 14.
24 to
And
28.
24 to 28. And then 41 to.
No, 39 is
I'm sorry, 39,
Then
40, 41. 244.
51.
And 51, 52. Achha, that's it.
Yes.
Then
these are both on Kacha.
Pakka and Kacha.
Pakka and Kacha.
Yes.
And then the Omid Basu, I'll be relying on.
Same point in Indian multiply.
No, not Omid Basu is not on that point. Omid Basu is also on the point of where landlord has already made a structure in that property, and one portion of the vacant land was given.
Which paragraph?
17 onwards.
17, para 17.
And then para 20.
22 to 29. Para 17 onwards. Victor Moses Omid Basu. 2014, volume 2, CLT 498.
Very well.
Then, relying on Omid Basu, very recently, one unreported judgment, I was before Honorable Justice, before the Honorable Division Bench, Justice Devanshu Bhasak sitting with Shabbar Rasidi, the same point, in the same premises, landlord had a construction, and a part of the portion of that premise was given on a lease, or rather for khatal. And Omid Basu was relied and said in the one premises tenancy and tika tenancy cannot. It's a weird proposition. And I'm supplying since it is unreported, I'm supplying a copy to Mr. Basu. And then the very recent the review, the Money Square one.
Any paragraphs, Mr.
95 onwards, several discussions. Even in the middle portion of the judgment, there was a discussion about the. So 95 onwards,
This is on the effect of 2010 amendment also.
Yes, all have been discussed. 49, what was the law? What should be the interpretation? Then 81 Act, then 2001 Act, and subsequent amendment taken place in the year 2010. The original judgment was passed, Malad knows, the original judgment was passed by Justice Jyotima Bhattacharya sitting with Justice Ishan Chandra Das, and Malad in the first round, Supreme Court has revised that judgment with a interpretation that any structure means is all, kacha, pakka, everything. Ignored the amendment of November 2010. Then subsequently, the review application was filed. Then Supreme Court has considered the special bench judgment and passed this order, considering all the 49 Act, 81 Act, 2001 Act.
Yes. Thank you. Yes, Mr. Vasu.
Yes. 4th August 1938, lease deed was executed by and between the parties. 4th August 1938, my lord, is at page number 220. Page 220 of your lordship's brief. My lord's got it. 220. 220. 220. 220.
Yes.
My lord's got it. 220.
Got it.
Yes. Kindly, my lord, it starts from, my lord, it is agreed as follows: the landlord hereby lets and the tenant hereby takes all that piece of land measuring 5 quarters, 14 chotak, 33 square.
It is agreed for everybody.
That is, my lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 16,
10 lines to
Yes.
bottom.
15. Yes.
Yes. Where
The landlord hereby lets and the tenant hereby takes all that piece of land measuring such and such and forming a portion of premises number 236 Lower Circular Road in the town of Calcutta, Thana, Bhavanipur, District 24 Praganas, and which portion is delineated on the plan here to annex being thereon surrounded by a red color boundary line together with all ways, passages, lights, drains, sewers, water courses, rights, easements, advantages, appurtenances, whatsoever to the piece of land belonging to the with the usually held or enjoyed, and together also with the right for the tenant to install, erect, and maintain upon the said piece of land roadways and pathways and underground petrol tank, petrol delivery pump connected with such and such for attendant to or west for greasing, washing, such and such. So, my lord, the land was vacant. It was with a right, my lord, to construct, my lord, the structure, my lord, for the convenience. My lord, the act, neither this act, my lord, does not, my lord, make any, my lord, distinction between, my lord, the premises, my lord, the premises tenancy and the thicker tenancy. According to my humble understanding, 1949 Act, my lord, when it was promulgated, it was named as Calcutta Thicker Tenancy Act. Calcutta Thicker Tenancy Act does not make any provision for vesting, my lord, as it was incorporated in Section 5 thereon, later on, my lord, in the 2000 Act, my lord, the concept of vesting was not, my lord, with the state, and it was not there. The 1949 Act, my lord, when it was, my lord, repealed, it was repealed, my lord, subject to correction without any savings and reaping clause. Now it has some ramification. It means, my lord, that the act, any action taken today, my lord, the definition of thicker tenant, my lord, in the 1949 Act, 1981, it is the ingredients, my lord, are it has to be a vacant land, and, my lord, right to construct, and I am the owner of the structure. The parties in the proceeding never disputed such factual matrix, and accordingly, my lord, this is done. Now, my lord, the 81 Act and under the rule, my lord, Section 19 of the 81 Act, my lord, it empowers the state for making rules. It's a rule-making power. The rule-making power, my lord, it includes, my lord, the filing of a return by a thicker tenant, and, my lord, no executive action, my lord, cannot be said that it has no ramification after, my lord, it has been adjudicated that the rent is being accepted. The definition of landlord, the definition of appurtenant, the definition of the thicker tenant, all are there. In 81, my lord, what is the distinction between the definition of Paka structure? In Paka structure, my lord, construction 49 and 81 almost akin to each other. 81 Paka structure, my lord, it was included, my lord, any structure, it was clarified in 2001 Act. And, my lord, the power of vesting. My respectful submission is, my lord, in the 81 rules and 2001 rules and within the Act, your lordship will be pleased to find in Section 5, Section 6, Section 6, my lord, the Kolkata Municipal Corporation Thicker Contrary for tenant wants to, my lord, erect a Paka structure, my lord. There was a provision in the Act, my lord, to make a Paka structure upon being armed with, my lord, the plan to be sanctioned by the appropriate authority.
Where? Which provision?
This is, my lord, first 81 Act, my lord.
Yes.
Yes.
Which section?
Section, my lord, kindly, my lord, turn to Section 25. I repeat, my lord, because I may have been omitted. I may have omitted, my lord, that 39, my lord, the plan was sanctioned subject to what my learned senior friend will say. Now, my lord, when the municipal commissioner has given permission to execute work The approved plans of the work shall be signed by officer such and such.
So this is that Thika tenant can create a constructed structure.
I said, Milord, that building regulations in respect of the lands covered by the Calcutta Thika Tenancy Acquisition Regulation 81. That is, Milord, your lordship.
No, what are you trying to drive?
I am trying to, Milord, impress upon your lordship that the building plan sanction is not unknown to the legislature. Legislature was conscious that Thika tenant has a right to construct a Paka structure.
So what is disputing that?
I am saying, so Milord, the Paka structure, the construction of Paka structure by a Thika tenant, Milord, that was there. And Milord, accordingly, application.
You see, a Paka structure also could be.
I said, Milord, the ramification or the clarification, Milord, after
the clarification.
The clarification of the ramification, it's a ramification of this clarification made by the Supreme Court, which he just now pointed out, Milord. It starts from paragraph 104 of the.
We require a clarification of the ramification.
Yes, the clarification, when a statute becomes a clarificatory statute, it operates retrospectively. That was the submission made by me.
Which comes first, ramification or clarification?
Clarification, Milord. The clarificatory statute.
You are trying to clarify the ramification, and we are trying to ramify the clarification.
The clarification is, Milord, that whether Paka structure should be included from a particular date.
So you say by necessary implication, Section 25 gives a power authority to the Thika controller to Thika tenant to build a structure, Paka structure. So therefore, you say Paka structure also was by necessary implication included.
Yes, it was there from 1981 Act, 2000 Act. It was not unknown to the legislature. Legislature was not unmindful of its times, Milord, and accordingly, these sections and provisions were engrafted.
This is a very interesting argument, actually.
It is innuendo.
No, we are not making fun. It's really an interesting argument.
That is my understanding, Milord.
Your understanding is really interesting. That is what you say. How many times do you have to say that?
I can't.
Don't seek affirmation from a court of law.
It's on the air, Milord. বেশি বকো না তুমি পাশ থেকে শুনে বাইরে চলো
So Thika controller did have the right to make a Paka construction also.
Yes, Thika tenant, Milord. Thika tenant had a right subject to, Milord, approval of the municipal laws. Why I am telling? So, Milord, the submission is based, Milord. I, Milord, get a point, Milord. Possibly Section 92 of the KMC Act, Milord, that the owner of the structure, it finds, Milord, a place, Milord, in the assessment register that it is a heart, bosti, heart, everything that is there. So, Milord, this concept was from the very beginning. Today, Milord.
But you aren't you going against the clarification of the ramification of money square?
But no, I am saying, Milord, I am saying
money square.
No, money square, Milord, this argument. Milord, money square is otherwise. Money square, Milord, did not take into an account. Subject to correction, Milord.
Money square, can we say that?
No, I say, Milord. No, I say, Milord, that this provision, the particular rules, schedule.
No, Money square under Article 141 is binding on us.
Yes, Milord, it is a law declared, and Milord, all civil and judicial authorities must come in aid of Supreme Court.
And also the advocates.
Now, Milord, the money square judgment,
Yes.
Money square, Milord, page, a paragraph 104.
104, 113, there are several paragraphs.
Yes, 104.
We have some.
104.
Yes.
In the Act of 81, the legislative intent on the one hand being protecting the interest of the vulnerable class of tenants, occupants, but on the other hand, the flat being exaction of the lender's property to the state. Obviously, the provisions were required to be construed in a balanced manner and were so construed by the Calcutta High Court in several of its decisions, and the matter was ultimately dealt with by the full bench of the High Court in case of Lakhi Manidashi, wherein the full bench approved the interpretation of Section 5 of the Act as put by division bench in case of Jatadhari Daw and such. The full bench answered the reference in the following terms. For the reasons aforesaid, we hold as follows: the impugned act is not protected under Article 31C of the Constitution, as it is found on the scrutiny of different provisions of the impugned act. The impugned act has not been enacted to give effect the provision of Article such and such of to give effect of the Constitution, and the impugned act is open to challenge on the score of violations of Part 3 of the Constitution. Within the scope and ambit of Section 5 of the impugned act, only lands comprised in Thika tenancy within the meaning of the Calcutta Thika Tenancy Act, comprising a Kacha structure or a Pakka structure constructed for residential purpose with the permission of the controller, used under Calcutta Thika Tenancy Act, Khatar lands and the lease shall vary vest and save as aforesaid, no other land and structure was vested under the Impugned Act. Subsection 2, 3 and section 8 of the Impugned Act, Thika Tenancy Regulation Rules, ultra-virus of the Constitution. Rule 3D of the Calcutta Thika Tenancy Act rules, excepting the following portion, every Thika tenant to Thika tenant shall pay to the controller annual revenue being not less than he was paying to the landlord, such and such, coming to the force of the Act. Rule 3, Rule H. Section 19 of the Impugned Act is so far as it purports to abate any pending appeal preferred by a Thika tenant against a decree of eviction of the Thika tenant under the Calcutta Thika Tenancy Act 1949 and any execution proceeding for the eviction of the Thika tenancy whom a decree of eviction had been passed under this Calcutta Tenancy.
Basu, these have culminated in paragraph 111, 12, 13. Please
Yes,
read
Millard.
12 onwards, please read.
Yes, Millard. Only one.
Yes.
Reference.
This continue and Loksamani has been interpreted.
Yes.
Please come to para 112 and 113.
In the Act of 1949, as originally enacted, even though the expression any structure had been used, but it was consistently maintained by the Calcutta High Court with reference to the object of the purpose of the Act. It's framed that the definition of Thika tenant would not include Pakka structure because the enactment or otherwise not dealing with the rights and liabilities of the tenant, for which the provision of the TP Act, where Transfer of Property Act, were required to be referred to, and such a proposition was also in accordance with the section 2, subsection 6 of the Act, as one and Part section 108p of the Transfer of Property Act, Pakka structure was not permissible. In Jotadhari, the grandsons, the division bench of the High Court, even while construing the Act of 18, proceeded on the same lines and held that the expression structure in the statute did not include permanent structure. The full bench of the High Court in Lokshimani Dashi supra meticulously examined the variegated aspects of the matter and various provisions of enactment and also different pronouncement while holding the construction of kacha structure on the leasehold land was sine qua non for constructing Thika tenancy. We find such interpretation to be in accord with the very object and purpose of the enactment, at least until the enforcement of the Amendment Act of 2010 with effect from 1/11/2010. And the submission of the learned counsel for the respondent based on the doctrines it deserves to be accepted that the interpretation of the
parties. So, Mr. Vasu, both the contention, your contention that it includes a Pakka structure has been turned down in this, and also the interpretation of the tribunal that it's retrospective, because at least until the enforcement of the Amendment Act of 2010 with effect from 1st of November 2010.
Yes.
So before 1st of November 2010, it was only kacha structures which came under the purview of Thika tenancies.
Yes, but Millard,
it has been held now. Supreme
it has been
Court.
held.
How can you
Millard,
deviate from that?
No,
and take a different interpretation.
No, I said, Millard, that the interpretation of Millard, the structure, kacha structure, this amendment, I said 1949 Millard was considered in this judgment. 1949 Act was repealed, and it was repealed, Millard, without any saving or repeal clause. Number one.
But it has been interpreted now.
But it has been interpreted. But Millard, the 81 Act, the 81 rules, if your lordships look at 81 rules and 2001 rules, Millard, all rules contain, Millard, that the Thika tenant, Millard, is empowered to, Millard, raise a Pakka structure. And, Millard, the Pakka structure, it has to be routed to the Thika controller. I said, Millard, the adjudicatory process was never, Millard. It is not the case that the law scheme of the Act says.
It has been now finalized. Till now, at least that is the law. Kacha structure was the only thing. And if you argue that, because tribunal said that it has retrospective effect.
No,
yes, do you also argue that?
Yes, I argued, Millard, because it was the amendment as that was sought to be brought about. But I said that any amendment clarifying the position of law, it is a clarificatory statute, and such amendment
accepted. But here, if effect is specifically given from November 1st, 2010.
Yes, that is what Millard the Money Square has recorded.
And that is
Millard, that is correct. I cannot
the notification says with effect from November 1st.
But what I am trying to, Millard, impress upon your lordship that the Act and rules, Millard, it is replete with these provisions, Millard, that we can make this application.
Replete means section 25 and what other provisions?
25 and, Millard, the rules also, Millard, 2004 rules. 2004 rules. And also, Millard, I just একটা section 6 যেটা বলেছে পারমিশনটা নেওয়া যেটা আছে না ঠিকা টেনেন্ট এই করতে পারে মিলাট this is 2004 rules.
Which rule?
2004 West Bengal ঠিকা tenancy acquisition rule.
No, which rule
yes, Milord, just give me 1 minute, Milord.
Rule 6 টা দেখাতে চাই
No, 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 ওটা না, ওটা না। Milord, it makes a provision, Rule 19, rate of monthly revenue payable ঠিকা tenant on other lands directly under the holding under the directly under the state government under subsection 1 section 24 the rate of announcement of the monthly revenue such and such. The rate of revenue, Milord, first part covers Rule 19 A B Kacha structure and second part, Milord, rent of pakka and rent of pakka structure, this Rule 19, Milord, I said, Milord, that rule clearly indicates that even if a state government can be a landlord, Milord, in respect of a because obviously state government is the landlord, Milord, here also, Milord, it makes a provision in rule 2004 rules. Yes. 19C, Milord. It kindly comes to Milord Form D. It was under C sub-rule 1, Rule 5. Application for permission to construct a pakka structure or the building to change the nature and character and dimension of a structure on the land comprised in ঠিকা tenancy. And I would like to take my lord's kind undivided attention also to my lord section 6 of the 81 Act. That is my understanding of the reading. Section 6 subsection 4. If your lordships permit me, my lord, may read for you, my lords. The ঠিকা tenants and tenants of other lands holding directly under the state under subsection 1 shall be entitled to construct pakka structure in accordance with the building plans sanctioned under the Calcutta Municipal Corporation Act and the rules made thereunder or the HMC Act and the rules made according to as the land may be situated within Calcutta as defined in clause 9 and section 2 of the Calcutta Municipal Corporation Act or the Howrah defined in clause 15 of section 2 of the Municipal Corporation Act for residential and business purpose for themselves and the bharatias under them and essential common facilities like common pathway, common bath toilet, water supply, drainage, sewerage, lighting and similar other purposes. And which was also taken care of by the money square in paragraph 61 also. And 81, but also the 81, this permission that in the 6.
This is post vesting.
This is post vesting. I said it is automatic. I said 220 page.
Yes, because with effect from the date of commencement of
yes,
this act, the following land.
Yes, if I was a tenant, my lord, and with a permission to grant structure, my lord, it is law of eminent domain automatically vesting. Only, my lord, section 4, the conditions are complied with because it is a law of eminent domain. It is incumbent upon the citizen or the landlord that to say and to demolish, my lord, the edifice of this argument that no, there cannot be any provision like, my lord, automatic vesting. The law says the moment it is, my lord, a vacant land, the state, my lord, enjoys, my lord, it is protected under the law of eminent domain. That is one of the ingredients of, my lord, the sovereignty of the state, my lord, under the constitution. Because your lordship knows, my lord, that the power of acquisition of a property, my lord, ultimately all property vests with the state, subject to law. So I say, my lord, this argument, it is not that something has been brought about recently. I said, my lord, the 81 Act, my lord, was conscious.
Does this court have the scope of Mr. Bose of going beyond the
yes,
money square judgment? Even if you accept your contention, what is your argument on that?
No, I said, Miller, the date of reference of the judgment, Miller, Supreme Court, all judgments are, Miller, retrospective in nature, unless.
Court judgment para 113 is very clear. It was Kacha till 1st of November 23rd.
Yes, Supreme Court was, my lord, in Supreme Court, my lord, had
Can we interpret that and say that Supreme Court was misled?
No, I said, my lord, I only say, my
Supreme
lord,
Court
I
has
cannot-
laid down the
as an
law on
advocate-
that. Can we
Yeah,
reopen that in sitting in division bench in a High Court? If you say yes, yes.
No, my lord. But these points, my lord, the endeavor, my lord, made by the state, my lord, at that point of time, my lord, these were absolutely unnecessary. Because because Supreme Court, my lord, defined in page 104 that the definition of thicca tenant remained the same. The Supreme Court, my lord, has only effected change with regard to the structure, which was unnecessary.
But that
Because
has been done.
If I'm a thicca tenant, it can if the land is vested.
You may argue that this pakka structure,
it is immaterial.
Pakka kacha, this was artificial.
Artificially
brought in.
Artificially, because
But we cannot say that after this
no,
judgment.
because if the land will stood vested, if the Supreme Court says that all along the definition of thicca tenancy remains same, that means will land vested. If the land vested, will what is the effect of the structure? How it is? This is absolutely very logical. I say, will the decision.
No, but Mr. Basu, there is something here. It is vested with the coming into effect of the Act. In thicca tenancies which have vested, Section 6(4) says that thicca tenants and tenants under other lands, they can make pakka construction. So, but then what something comes in between. They already have to be thicca tenants in the first place.
Yes. So if
you are already a thicca tenant on the date
yes,
of coming into,
I said I'm already a thicca tenant because 2000 Act.
No, because when there are 2 points here. One is that whether you were a thicca tenant when the Act came into force. If you were a thicca tenant when the Act came into force, because here it says Section 5 of 1981 Act, with effect from the date of commencement of this Act, the following lands along with the interest of landlords shall vest in the state, free from encumbrances.
Right.
So therefore the definition is given and whatever. Now, thicca tenancy definition is there. If you are already a thicca tenant under this Act, then it's vested. Thicca tenancy is vested. Then you can make with sanction a pakka construction. But in the first place, when it happened, when you were to become a thicca tenant, you had to have a kacha structure there. Because unless you had a kacha structure, there was the question of making a pakka structure with a sanction plan. Once you are a thicca tenant and the land is vested in the state, only then you can have a sanction plan and build a pakka structure there. Because it's vested in the state.
Yes, but
because inherently, Mr. Bose, there is no bar in a thicca tenant converting his kacha structure with sanction plan to a pakka structure. But in the first place, whether he was to be a thicca tenant, he had to have a kacha structure. That there is possibility of a harmonious construction.
Yes, my lord. Then, my lord, we need to, my lord, kindly see what is the definition in 81 Act.
Yes, exactly.
Thicca tenant means any person who occupies, whether under a written lease or otherwise, land under another person or is or but a special contract for a special contract would be liable to pay rent at a monthly or at any other periodical rate for that land to that another person. So that land means the land, it is immaterial when this land, 1938 land was given with a right to construct a structure. So, my lord, I squarely come under.
Previously, 49 Act was there.
49 Act at that point of before 49, my lord, the Act was not promulgated,
When
but it
49 Act
speaks
came,
about a situation.
to be a thicca tenant when 49 Act came.
My lord, 49 Act, my lord.
This any structure has been actually interpreted.
Thicca tenant means any person who holds, whether under a written lease or otherwise, land under any person and is for a special contract would be liable to pay rent.
Same, almost same.
Same. So nothing. So everything is same.
Any structure is used.
Any structure everywhere. Now, my lord, I said, my lord, first
Structure
condition
is used, but that any structure has been interpreted by the Supreme Court.
Yes.
And on an interpretation of Lokhi Munidas.
Yes, but Lokhi Munidashi, my lord, the major part is, my lord, 1949 Act. 1949 Act, my lord, subject to correction.
Definition was any structure.
Yes, because every action that was taken under a contract, but at that point of time, my lord, neither Calcutta thicca tenancy existed. But this act, 81 Act, 1949 Act, both act will not contemplate a situation where this condition happened. Now, 81 Act, Section 4, subject to correction, Willard.
81 Act, to have a sanction plan, you already have to be a ticket tenant and it has to be vested in the state in the first place. So to be a ticket tenant, you had to have a kacha structure. Once you have a kacha structure, you are a ticket tenant, your land vests. And then, but if initially you had a pakka structure, there is no question of getting another sanction plan to build another pakka structure.
No. But here, Miller, 2 times, Miller, the plan we have sought for modification. There
when? Because it's in a different chapter. It's in chapter
that
2.
is, Miller, the
incidents
yes.
of ticket tenancies.
This
is one of the incidents of ticket. No, sorry, not incident.
Next time, the plan.
Sorry. Let us come back to 81 Act once.
1830. First plan, Miller, the structural plan, that was the construction of petrol pump, 1939. Then, Miller, the garages.
No, chapter 2, if you please come to, if you are relying on 6.4 of 81 Act, right? So please come to chapter 2, section 5 of 81 Act. Section 6 is under chapter 2 of 81 Act. The chapter 2 is the heading is acquisition of lands comprised in ticket tenancies and other lands.
Yes.
So it contemplates, it envisages acquisition of lands which are already comprised in ticket tenancies.
Yes.
So it had to be a ticket tenancy previously, then it is acquired. Once it is acquired and vested, then the ticket tenant who is already a ticket tenant can apply, have a sanction, build a pakka structure.
Yes, but
that does not mean initially he had to have a pakka structure.
No, but it does not also, Millard, kindly sees. Yes. Millard, kindly sees. It also says that lands held in monthly, section 5, subsection D, lands held in monthly or periodical tenancy, whether or under a general lease. Now, land held, Millard, initially page 220, Millard, it clearly states that the land was given on rent.
Chapter 2 is on a different footing, on a wider footing. Chapter 2, the heading is acquisition of lands comprised in ticket tenancies and other lands.
Other lands. And the rights of the landlords in such lands. Now, Millard,
so it also comprises of other lands than ticket tenancies, not only ticket tenancies.
Yes. Millard, I was trying to, Millard, impress upon your lordship that if, Millard, I come within the section 5D condition.
To come within section 5 or 6.4.
And 6.4, ticket tenancies, Millard, 6.4.
Come within 6.4, you already had to be a ticket tenant.
Yes.
When the act came into force. By virtue of this act, it had to be vested in the state and acquired by the state.
Yes.
That is the composite meaning of chapter 2 heading and section 5. Chapter 2 says acquisition of lands comprised in ticket tenancies.
Yes.
The land already has to comprise in a ticket tenancy for it to be acquired. And 5 begins with effect from the date of commencement of this act. The following lands, along with the interests of landlords, shall vest in the state, free from all encumbrances. A is lands comprised in and appertaining to tenancies of ticket tenants, including open areas.
Yes. I said, Millard, section
the others are not ticket tenancies necessarily.
No.
Buses may be, but C, D, if you see C and D, these are not ticket tenancies. So it's wider than only ticket tenancies.
With effect from the date of commencement,
come
following
under D or C, you are not a ticket tenant.
No, with effect from the date of commencement of this act means 81 Act for section 5.
No, Mr. Basu, probably you are not being clear to you. Section 5 says with effect from the date of commencement of the act, the following land along with the interests of landlords shall vest in the state. And the caption of chapter 2 is acquisition of lands. Don't be myopic. I mean, just be a bit wider. Acquisition of lands comprised in ticket tenancies and other lands. And 5 says with effect from date of commencement, following lands. A is land comprised in and appertaining to tenancies of ticket tenants. Now, their ticket tenancy ends.
Yes.
And other lands begins. Lands, B is lands comprising and appertaining to bastis on khas lands. C, suppose. Other lands not covered by clause A and B, therefore not covered by ticket tenancies. So these are other lands. If you come under C or D, you are not a ticket tenant, Mr. Vasu. And therefore, if you are saying, or if you come under D, C, D, you are not a ticket tenant. By specific exclusion, ticket tenancy is under A and C excludes A and B. And includes other lands also. So this is wider than only ticket tenancies.
And but my lord,
And
the-
6 is incident of tenancies in respect of lands vested in the state. 4, you are right, subclause 4 of subsection 4 of 6, the Thika tenants and tenants of other land.
I have to be a Thika tenant first. Yes, and then Miller, that is why I said that section 2 subsection 8 says, Miller, that it means who
That is
occupies
same as the 49 Act.
49 Act.
Other
So
any
definition.
structure.
So I said, Miller, the moment I mean, land is held by me.
Any structure has now been defined, been interpreted in the light of Lokshimoni. Moni Square has interpreted that. How can you deviate from that? Any structure is, you may feel otherwise, but this section 5, Mr. Basu, section 6 is not necessarily in support of your argument that Thika tenancy can include Paka structure. No. We are unable to agree with that because this is only after it was. It already had to be a Thika tenancy.
Yes, I mean, I was, Millard, at the cost of tiring repetition, I was trying to impress upon your lordships that Millard, that the moment Millard I held a land with the right to construct, Millard, that is Millard, because 2001 Act, Millard, if
your construction comes after you become a
yes, I said the moment the land is vacant land is given to me with a particular period.
At that point of time, vacant land, you had to have a kacha structure on that to be a Thika tenant. And once you are a Thika tenant, only then your land vests and then you are entitled to apply for a sanction. Your land, your saga started in 1938.
Yes.
So in 1938, we have to look at the situation in 1938 when there was no Thika Tenancy Act.
No.
Then you had acquired a land, that lease was acquired in the land was acquired, a lease of the land, and you constructed a Pakka structure there. Question is, when 49 Act came, what was contemplated as a Thika tenancy under that? Any structure has been used. It has not been said either Kacha or Pakka or anything, any structure. Very well. Once it is any structure under it's a Thika tenancy, then you can make a sanction, have a sanction plan and make construction. But this has been interpreted in Lokshimoni and in the light of Money Square review. That any structure means only Kacha structure before November 1st, 2010. And that is para 113 specifically that. At least up to 1st November 2010, it had to be only Kacha. If that is the interpretation, then on your date of purchase, you admittedly built a Pakka structure there on. It's a petrol pump. So how can you get over that, we are thinking, even if we accept your interpretation? And you also referred to Rule 24, probably rules cannot override the Act.
No, but I said, Millard, the Act itself contemplates, Millard, a situation.
Section 26 is
yes
post facto, after.
Section 6 is 81. So, Millard,
and you relied on Section 25 of 1981 or rules of.
No, Section.
What was that? Rule 25 or Section 25?
Section 25, 24, 25.
Section 25, why that? Of the 1981 Act?
Section, no. Rule regulation 81.
81 regulation rules, you relied on Rule 19. 2004 rules, Rule 19.
Yes, 2000 Rule 419. And I also relied on a Schedule 5B also, 2004, where Millard, the Thika tenant can make an application. That is prior to 2010.
That is in consonance with Section 6 also.
Yes.
But no, Section 25 was something you relied on.
Yes,
1981 Act.
Just a minute.
How does Section 25 help you? Section 25 you started with Section 25.
Yes, just a minute. Oh, the 25 it says when the signature of approved plans, when the municipal commissioner, that is
Section 25 of which Act?
Acquisition and Regulation Act 81.
25 of which Act?
Calcutta Thika Tenancy Acquisition and Regulation Act 81. Signature of approved plans. And 22, Millard, I forgot. Every person who intends to erect a new building or convert an existing hut into a Pakka structure or intend to make addition or alteration of an existing hut.
What is this?
Section 22, employment of a license server, the name and address of the license, persons so employed, if the person so employed dies or ceases to be so employed.
1 minute.
22 and 24.
Wait. Yes, 22.
22, my lord, if every person who intends to erect a new building or convert an existing hut into a pakka structure or intends to make any addition or alteration of an existing hut shall employ a licensed building survey or architect for supervision. Then, my lord, it says the name and address of the license number such and such. If the person so employed dies or ceases to be employed before the completion of the said building or pakka structure, the name of the licensed building surveyor architect employed in place of such person to supervise the construction shall be forthwith reported to the municipal commissioner. And my lord, no work to be commenced unless and until permission is given. Section 27 says. Sanction fee is also mayor in council, the next section. So, my lord, there is a provision for extension of sanction plan as per 399, which is engrafted in section 30. And, my lord, building permanent structure in Thika tenanted land 33, it says, in a Thika tenanted no permission.
But there are two things here. First of all, rules cannot override the main statute. Whatever is there in the statute has to be followed.
Right.
Now, in statute, chapter 2 deals with acquisition, post-acquisition scenario, incidents of Thika tenancy. Once you are a Thika tenant and you come within the ambit of the act, then this you can apply and have a sanction plan and build a pakka structure. But you had to be a Thika tenant.
Yes, I said, my lord, that since
rules are only under those.
Yes, I said, my lord, the 1949 Act cannot be taken into an account because 1949 Act, my lord, was repealed without any, my lord, provision for savings and repairs. Then this point, this aspect, then what is? My lord, I made a...
Forget 1949 Act.
1981 Act. 1981 Act, my lord, I initially, my lord, when the land was given to me, I held the vacant land with a right to construct. So, my lord, the lease was granted in respect of vacant land. So, it's not a transfer of interest, but right to, my lord, enjoy the land.
Your crown is also speaking.
Yes, sorry. I said, my lord, the vacant land was given to me. And that right is a particular right with regard to the land. Suppose, my lord, tomorrow, whether because when I talk about a lease, I always talk about a lease in respect of a vacant land with a permission to construct. So the concept of vacant land remains with the landlord. Transfer of interest, not ownership.
No, but permission to construct a pakka structure is not from the landlord.
It is
it's
from
once you were a Thika tenant, then under section under the 1981 Act.
Correct.
Once you are a Thika tenant, state gives you that permission. You have to obtain a sanction.
But at that point of time, you
has to be already vested, being a prior Thika tenancy.
Right. But when the legislature, my lord, contemplates, while my lord incorporating the definition of a Thika tenant or the incident of tenancies, it always contemplates in no uncertain terms that it has to be a land, vacant land, my lord, that was given on land. That conditions are fulfilled. If that is fulfilled,
not only vacant land, any structure. Any structure, we cannot help it if it has been interpreted.
Yes. No, I can. The most.
And any structure does not mean, by definition, does not mean kacha structure only.
Right.
Obviously, any structure means any structure, be it kacha or pakka. But that has been interpreted now by several judgments, not only one, a line of string of judgments. Lokhimoni and then now interpreted.
But yes, my lord, I tried to impress, my lord, upon your lordship, that saying that the provision of the act, the rules, these were everything, my lord, all aspects were covered. It is not that this was, my lord, the sudden amendment 2000.
Maybe it defies logic as to how any structure can be
a particular structure
to a kacha structure.
And not only that, with reference to a particular date.
We don't have that liberty now after this.
Yes.
We don't have that liberty. And your vacant land, what is your argument on this? Admittedly, it was only 236, plot number 236.
But I said, my lord,
a part of it, vacant land was given to you.
My lord, a particular part of the vacant land is there. The moment the land is given to the land, it is immaterial.
And be segregated. I mean, if within Justice Bossack's judgment says that, the previous judgment also said.
My lord, appertenance definition in the
yes, appertenance.
What is
Justice Talukdar's division bench?
Kindly sees whether the division,
judgment,
my lord, the division bench, whether, my lord, it takes note of the definitions of, my lord, the 2001, the land appertenant. It includes any easement right or any common benefits or facilities or access.
Which act?
2001 Act.
The definition of Thika tenancy?
No, the West Bengal Thika Tenancy Acquisition and Regulation Act 2001, Section 2, Subsection 6. Land appertenant includes any easement right or any common benefits or facilities or access, passage, drains, tanks, and pools which were owned by the landlord and were enjoyed by the thika tenant and the bharatiya, if any, before the date of vesting. Before the date of vesting. Premises Tenancy Act operates in a different field.
Land appertinent, how is it relevant here?
No, he said, Willard, that land appertinent, because I said, Willard, that the premises number 236, a particular part of
This
a
is
land.
land appertinent as used as in this act.
Yes, the lease also says that the lease that was given
Not in
to
the lease. The lease cannot be interpreted in the light of this definition.
No, I said, Willard,
here land appertinent as used in this act. Where has it been used? Land appertinent. Let us find that out.
No, here, Millard, this point, I said, Millard, the judgment does not say that
definition says in this act, unless there is anything repugnant, land appertinent includes any easement such as that. So where is land appertinent used in this act?
He said the land appertinent, Millard, cannot come within the purview, if I have correctly understood, Millard, the submission. Which
where land appertinent? Land appertinent, if it is used somewhere else, then this statute, then this definition is not relevant for this.
No.
This definition is only
because
where
I have to. Yes, sorry, Millard.
This land appertinent has been defined for the purpose of this statute.
This
Wherever
statute.
this expression is used in the statute,
Now,
this definition will operate.
Yes.
This is not a general omnibus definition for any lease deed, anything. Land appertinent as used in this act means this.
But the Mr. Dhar, my learned senior friend, submission at the outset, Millard, that a part premises is under Premises Tenancy Act and the other part, Millard.
Yes.
I said, Millard, the two acts, Millard, operate differently. Millard, it operates. Thika Tenancy Act is an absolutely different concept. If a particular land, Millard, had it been a case,
You are relying on 2.6, but where has land appertinent been used in this act? Let us see that. You will understand the context immediately.
No, he said that land appertinent, Millard, is, if I have correctly understood, land appertinent is not applicable here.
Probably 15, 215.
215 says the Thika land means any land comprised in and appertinent to tenancies of Thika land, irrespective of the fact whether there is any claim of such Thika tenancy or not, includes open areas and roads on such land. Millard, Thika tenancy, whether I am entitled to make this submission subject to correction, Millard, that even if there is no claim, a particular land can be a Thika land, only on the basis of a fact that the particular land was given on rent. Section, only just a minute. Millard, 2001 acquisition of lands comprised its Thika tenancy, the rights of landlords in such lands. Section 4, acquisition of lands comprises Thika tenancy and the rights of landlord in such lands. Lands comprising Thika tenancy and other lands to vest to the state with effect from 18th day of January 82, the following lands, along with the interest of the landlords, shall be deemed to have vested in the state free from all encumbrances. 1. A Thika land. B. Land held in monthly or other periodical tenancies, whether under a written lease or otherwise, for being used or as occupied as khatal. Millard, the land, I held land, Millard, and against which, Millard, I had to pay rent. My tenancy, Millard, always in respect of a vacant land.
It is not a khatal.
No.
How is it relevant?
No, Millard, I said, Millard, the 18th, the following, free from all encumbrances, land held in monthly or periodical tenancy, whether under it is for being, provided that any land comprised in and tenancy, Thika tenant called after 18 years shall also be deemed to have vested the state free from all encumbrances with effect from the date of creation of tenancies of the Thika tenants. Provided further that such vesting shall not be deemed to have affected in any way easement such and such customary rights. Provided also that nothing.
Immaterial for your purpose.
I said, Millard, that if I'm a Thika tenant, that has to be adjudged, Millard, only in respect of a vacant land. Structure, Millard, comes later on because Supreme Court says, Millard, the definition of Thika tenancy all remained the same.
Mr. Basu, the law of the High Court, if somebody is given lease of that and he builds a structure, that will become a Thika tenancy.
Millard,
it's a part of the appurtenances of
Section 15 of the Act, Millard, it excludes the operation of the act from the where
the entire land has to be vacant then. If there is even a single structure in the land, it cannot be a vacant land.
Millard, scheme of the act
has been the premise of all previous judgments. That if there is a structure standing on the land,
But the moment, my lord, land is vacant given to me, a particular portion of a land, my lord,
No.
that the act does not distinguish.
It has to be the entire land has to be vacant. Appertaining to the same plot, 236 plot, a portion
236
is
plot, a
there
part
is a
is
building.
structured as a building.
No.
And when the lease is given, my lord, the act does
The
not
same
mention.
property cannot be a non-ticket tenancy and a ticket tenancy.
Suppose, my lord, I have more than 8, I have a 8 kata land, vacant land. My lord, beyond 7.5 katas, my lord, it is automatically vested under Land Ceiling Act, the portion. So, my lord, if it is there is no structure.
Different concept, you are mixing concepts. If
But
it's
my lord,
vested, it becomes vested in the state.
yes, my lord, but in the instant case,
That has nothing to do with
the
this.
scheme of the act only says a vacant land. It does not talk about, my lord, that the entire land has to be vacant. The tenanted land, my lord, is to be vested, vacant land. Had there been a, my lord, the provision?
No, then that will be a peculiar confusion and absurd confusion of ideas, because otherwise then every land, all lands wherever a structure is raised on a vacant land, it will become a ticket tenant if it's raised by. Cannot be.
If your lordships look at the, my lord,
then it will be two different acts operating in the same premises, in the same plot, undemarcated plot, and if suppose co-owners are there are co-owners, it's undivided, undemarcated. The vacant land is given by one of the co-owners to somebody. This is a construction, it becomes a ticket tenancy.
Particular
with its incidents.
My lord, this is, my lord, this act does not make any distinction, my lord. It is silent.
Silence, wherever there is silence, you have to read in appropriate context. That is what we are saying. The confusion of ideas comes when then a land, suppose there is a land, there is a building standing there and there are co-owners. Then one of the co-owners gives a portion, a lease of the vacant land. Construction is created on that. Then that ticket tenant will claim the entire land as a ticket tenant. That will be a confusion of ideas, because then there will be a ticket tenancy and the non-ticket tenancy on the same land, which is not possible. Just because a portion, there is one slice of land vacancy, there something is constructed. Not possible. The land has to be vacant. That's the sine qua non. As per the definition also. And was there any demarcation of vacant land and building in this plot? No. It was one premises number 236.
Yes.
There was no demarcation. So the building owners had equal land rights over the land. Could not have been. So your argument in a nutshell is that it will be borne out by the 1981 Act as well as the rules under that Act, that there were several provisions which indicate that on obtaining a sanction plan, a pakka construction can be made. Therefore, you have to read any structure in the light of that. And the structure can include a pakka construction also as per the scheme of the 1981 Act itself. Also similar provisions in 2001.
Yes, and I said the land held by the under written lease or anything, my lord, when the land is given a written lease.
This is one aspect of the matter. Therefore, pakka construct. This is on pakka structure. Pakka structure can be included as per the scheme.
As per
this is one. 1949 Act. Your argument is that has been repealed. We cannot look into that.
Repealed without any saving clause.
Yes,
That
obviously. Thirdly, regarding this land, you say even if a portion of a land of a property which is vacant is given to someone in lease and the structure is made on that, that portion will become a ticket tenancy.
Yes.
According to you, then that portion
The act does not make any distinction.
No, according to you, what becomes a ticket? The entire property becomes a
No,
ticket.
no. I said that the land occupied by me, the
that cannot be demarcated then. There cannot be it's not a demarcated.
Here
an undivided land. The property remains undivided, undemarcated. How can you distinguish the land from the structure? That is our question to you. If it's demarcated, yes, definitely. Divided, demarcated, mutated or whatever, separated, then the land portion becomes a separate land. But if it's a part of the household,
it says, my lord,
one piece of lawn, that is also a vacant land. It is a structure, the entire property becomes vacant. Anyway, so this is. You want to rely on anything, you can.
It says, my lord, that all that piece and parcel 237, all that piece and parcel of land ground situate lying at 1A Lee Road and forming part thereof, PS Bhavanipur, in the registration such and such, at measuring such and such, bounded on the east. No, it is on the east by Lee Road, on the west by land 236 lower circular road belonging to the lesser. On the north by vacant land of 236 lower circular road belonging to the lesser.
That's a
On the-
different vacant.
Yes.
That's a different vacant land outside the boundary. That's a boundary you are describing.
Yes. Schedule of the land above referred to the stamp duty. Yes.
That's
No.
a boundary. There is another vacant land outside.
236A and 236 দাদা না D না
B
বিটা বার করুন give me 1 minute 27 Miller. No. It says Miller 227 Miller in this agreement that 227 236A and that was 236B 8 years period next terms and condition. It was provided with line together with all ways passages to hydrants, sewers, water carriages, rights and easement, advantages, appurtenance whatsoever held or enjoyed, and together with the right of for the tenants to install, erect, and maintain in and upon the said place of land, roadways, underground petrol tank, and petrol delivery planes connected with the said petrol tank, and shelter for an attended to cars such and such, but not.
How do you get over these judgments, Mr. Vasu, cited by him?
But I said the definition of Thikaten and Miller.
No, the judgments are there. These are binding effect. You have to distinguish the judgments. These are binding effect on us.
Miller, this judgment, Miller, today, Miller, I have come across. Give me 1 day, Miller. It's a long judgment, Miller.
Come back tomorrow. Parted. Anything else you have to argue apart from the judgment, then complete.
No, Miller.
Tomorrow, then we will only address on his judgments.
Or if I can make some points, Miller.
No further points, Mr. Vasu. You complete your points today. We have 15 minutes. Nobody else will be ready now. No, complete your arguments otherwise.
Yes, Miller. I am restricting myself to the argument. Nothing. At least I at best I can add. I will only show one decision if I can find it out. 2009. If the act is repealed without any saving clause, it is.
Now, why is that? Why are you harping on that? 1949 Act. Why is that German here?
I must be candid to your lordship that in one premises, two laws, how can it be applicable? But I need to answer because I could not apprehend, Miller. I need to, Miller. I need to go. I need to think about this. Miller, this is I must be candid.
That is where we are saying it's a confusion of ideas. Then it will be.
Yes.
Idea means legal notion.
Yes.
The same premise is governed by two. And if there was a demarcation, we could have understood. We are still telling you. Obviously, it would be obvious. Land demarcated, the structure demarcated portion. But if there is no demarcation, undivided property, and everything is common within the common hotspot of co-owners and all, everybody has rights over every inch of the property. Half are governed by, say, Premises Tenancy Act, and the rest governed by Ticket Tenancy Act. How can you distinguish? You have to go home with that bee in your bonnet.
Tomorrow, Miller.
Tomorrow, then only distinguishing is your what points?
These two.
You cite a judgment and distinguish his judgments.
I will cite a judgment. I will try to cite a judgment, and I will try to distinguish this judgment from the facts.
No. Why the try? We are keeping it only for that.
Yes. I will.
But don't do anything else. I mean, no further arguments.
Arguments means, Miller, that
arguments you complete today.
Miller, arguments means that the two questions, Miller. First of all, the distinguish.
Pakka
kacha, and Miller the
vacant.
And vacant, and Miller these two laws. How could it be operated, Miller, in respect?
That comes within that vacant.
Vacant.
Because he says it was not a vacant land. It had a structure. Yes. You say no. Even if a portion is vacant, because the land, the act does not distinguish.
Yes.
It says vacant land.
And if I get any judgment on that score, Miller, I will.
Then you will score. Very hard in part for further hearing.
Very difficult task, Miller. The Supreme Court after the pronouncement of this judgment. Very difficult.
Yes, you also have to have a relook. Probably you will be more confused if you look into the heading of chapter 2. which you cited. Just look into that and just apply your mind that whether it should already be a thicker tenancy under the definition for that chapter itself to apply. Once you are a thicker tenant, already you are a thicker tenant. Then only you can apply and state gives you the blessings. You can apply to the state and state will permit you to make a pakka construction. But that is applicable only to already thicker tenants. So therefore, by borrowing that, you cannot interpret the definition of thicker tenancy. Are it clear to you? Because we cannot borrow that into the definition of thicker tenancy. It is post facto. Once you are a thicker tenant, then the incidents happen. Any structure is very wide, but that has been interpreted now. We cannot reopen that. There must be some reasons. Long line of judgment, Lokhimoni and all, they were also wise brains. So, anyway, for further hearing tomorrow. Hard in part for further hearing tomorrow. আরেকটা পাঠাটা আছে না কালকে? সেটা কোনটা পর্যন্ত কারা আছে? কি ম্যাটার? একটা কারা আছে মনে হয়? এটা 2 মিনিট লাগে। The first part of it. This will be in the morning. Tomorrow we take up these matters first. Thank you. Very next. Yes. You have to come to court and attend the matter at 10:30. এগুলো সাবধান আরে বাবারে
আরেকটা ফোন মনে আছে পেজ নাম্বার জানেন
পেজ নাম্বার কার মনে
সব মনে আছে
What happened?
এখানে দেখলাম
Yes, Mr. Basu.
Betal was asking Mr. Basu.
How long
First
it will
time-
continue?
No, first time you read the Manish question.
No, he's more acquainted with the actual site than the judgment. Yes. Next.
Item number 24.
24, Malad, I appear for the respondent.
Yes.
Malad.
Respondent.
Yes, Malad. Respondent corporation, Malad. But there was a direction passed for filing of affidavits in the matter, Malad. We
Yes.
don't intend to file in the affidavit, Malad. I'll argue out.
What is Can 1 and what is Can 2 and what is the
Can
appellate?
has been
You offer the
taken out.
appellate?
Lord, I have just been formally instructed today because Mr. Ghoshal, who was appearing, is now mostly present at the circuit bench. Now, I believe there's an order.
Which Mr. Ghoshal?
Somnath Ghoshal.
Oh, yes.
There is an order. There is an interim order for filing of affidavits which they have not filed, but the paperwork is ready for hearing.
So the challenge is against what?
Challenges against this is what has happened. I was granted a dealership in 2020 by the respondent HPL on certain terms and condition for a lease of 10 years.
Yes.
What he on terms, on very drastic and strict terms, had to put in a lot of money. Now, what has happened? The HPL respondents, they have now granted dealership to another person, third party, within 1 kilometer distance in the state highway. The argument, what I find from the order here, the argument put
You're
forward.
enjoying an interim order till disposal of the application?
No. There is no interim order. There is no interim order because
So this will put it in the hearing list under the intra-court appeals hearing.
Yes.
This is ready for hearing.
Yes.
Ready for hearing, so intra-court appeals.
Yes, and they should not then operate because
Operate what?
operate the pump because
failed to obtain an interim order.
No.
Petrol pump will stop operation of petrol pump. In any event, we won't do that.
Then my lord can say this with
A dealer challenging awarding of a dealer of another dealer of a corporation.
Yes.
Malad. It's a policy
Yes.
decision, Malad. He's not.
No,
He's
sorry.
appeal. We are not in a public interest litigation.
It's the first ground is it's arbitrary. I will make submission on.
Since the appeal itself is ready for hearing, comma, let the appeal and the application be listed together under the heading, under the appropriate heading. Appropriate heading টা কোনটা বলুন তো? Hearing intra-court. Tomorrow.
Right.
It will appear under that heading tomorrow.
My
May
lord,
not be
kindly-
reached tomorrow. May not be reached tomorrow.
Because there are certain judgments which have.
You prepare yourself. You won't be able to reach it tomorrow. It will appear. You will get that. You will get that because intra-court appeals we won't be. There are several other appeals before that.
Very great.
But you don't want to block the application list with these appeals.
Yes, absolutely.
Oblige.
Thank
My lord, where for the petitioner, advocate on record is really ill and could not come today.
Really ill means exactly what?
My lord, ill.
The ailment.
He is down with fever or something. That is what he told
Is
me.
unreally ill?
And
No. You had prayed for an adjournment in the last one. Then it goes out of the list.
that is.
Are they enjoying an interim order?
No, nothing of that sort. My lord,
It
only
goes out of the list.
one issue. I have been served with the stay application, not the memo. If I could just.
Memo, there was no direction because at this stage you are not entitled.
My lord, can we mention again to put it on the list? Because he cannot come this week.
We find from the records that adjournments have been sought on several occasions, comma, including on September 16, 2025, as well as November 4, 2025, on behalf of the appellant. Full stop. Even today, when the matter is called on, comma, an adjournment is sought by the appellant. Full stop. Accordingly, let the matter go out of the list with liberty to mention as and when the appellant is prepared to do the matter.
Grateful, my lord.
Out of list. List block করে রাখবো না আপনাদের লোক দাঁড়িয়ে আছে
Item number 26.
Item number 26, I am appearing for the appellant petition on lordship.
Yes.
Before your lordship take up, may I just pray that service could not be affected upon the respondents. If I may come back after
When
2
did
weeks
you when did you send?
It was filed on 7th, but subsequently it came in the list.
We directed you to serve.
No, lordship. It's a CAN application section 5.
Unless you direct, there is a scope of your serving. You serve and come back. We are directing you.
Lordship.
The appellant shall.
Lordship, may I just indicate only one thing? There are 33 writ petitioners. They were represented by their power of attorney holder. So if your lordship may kindly direct us to serve the power of attorney, the represented person by power of attorney. It's at page 5 of my CAN application, lordship.
Very
at the
good.
bottom.
We'll direct you to do that.
Grateful. Lordship.
And the other respondents we can dispense with service.
Other respondents are
State and all.
state respondents.
Regarding section 12, they are not preferring a challenge.
No, lordship. They were.
Writ petition was allowed.
Writ petition was allowed.
Therefore,
the acquisition.
We are
notification
if your
was-
appeal is allowed, then the writ petitions will be affected.
Lordship.
So therefore, we'll direct serve. Very well. Fair
The
enough.
states
The appellant shall serve a copy of CAN 1 of 2025 along with the memorandum of the appeal on the constituted attorney of respondent of the writ petitioner stroke respondent numbers 1 to 33, comma, namely Provat, PROVAT, Kumar Hazra, comma, residing at 3/1, comma, Kuchil, KUCHIL, Sarkar Lane, comma, Kodamtala, comma, Police Station, Batra, District, Howrah, hyphen 711101. And file an affidavit of service on the returnable date. First up, the matter shall next be listed on December 8, 2025.
I'm grateful to your lordship.
Give your name.
Item number 27.
7.
You are appearing in the matter?
20.
Yes.
Defective.
Let us check up what is the delay.
Only
2 days delay.
Only 2 days delay.
But in any event, you have to serve a notice on the other side. So we'll direct. You have not filed any section 5.
My lord, 3 matters. Item 27.
Yes.
And 29. And
32.
32. Three matters.
Same matter, similar.
Same matter.
All these matters same 2 days delay or what?
My lord? No, my lord. Other two.
Within time. So what is the appeal? What are the appeals directed against? Why 3 appeals then? Different persons agreed by the same. You are writ petitioners.
They are the occupant of a land, railway land.
Very well.
Since 1977, my lord. They got sometime license, sometime not, my lord.
Sometime?
In this, sometime not. Then by this time, the 2010, my lord, 3 persons are get license.
These 3 persons?
3 persons. License get, I have annexed the document, my lord. And they are running first one, my lord, running a hardware shop. Second man running a hotel.
No, what was done by the impugned order? Writ petition has been dismissed. Your writ petition was what relief did you seek?
The ground that alternative remedy is there.
What is the alternative remedy?
What is section 9, my lord? This is the
of public premises.
Public
premises unauthorized. So then that is a correct order.
No, my lord. There is some
merit. আচ্ছা
merit.
27, 29 আর 32 যেটা আছে এই নাম্বারগুলো দিয়ে ম্যাথস we are taking up appeal hearings first. So there is very little chance of these matters being reached. Day after tomorrow, we will be taking up, we will be sitting singly. So probably in any event, it won't be reached today. Mr. Mukherjee, don't approach us
This is
now.
a part-heard matter.
Oh, this, you are appearing here.
Yes, part-heard matter, your lordships already.
Whenever it is taken up, then let us know. Whenever we take up.